Good morning, everybody. Happy Monday. Welcome back. We got our extra hour this morning. Oh my goodness. Does that just feel luxurious or what? She did warn us that if the parties had something they need to take care of, she'd be there early. But I have been monitoring the stream to make sure that they haven't gone into court without us. And no, we're just happily in fan mode, waiting for things to get started. About to start day 3 of Trooper Bukhenik on the stand. He has put in 2 full days already. And, are we even close to the end yet? I'm honestly not even sure. I'm really not even sure. The strategy that the defense has been pursuing here has been to make him the surrogate lead detective, since I think it's in question whether the Commonwealth is going to call Trooper Proctor or not. The defense is taking the opportunity to elicit all of the shortcomings in the investigation through Bukhenik. And the way that they're able to do this is by virtue of the fact that Bukhenik was Proctor's supervisor. And so therefore he's already testified. It's his business to pay attention to what Proctor is doing, to be aware of it and make sure that he's doing it all correctly, in accordance with policies and so forth. So it's provided them the backup opportunity that they needed to point out all of the questions that they didn't ask, all of the suspicious circumstances that didn't seem to cause them any kind of heartburn, any trouble. Oh, and there's still a lot of that to go. A lot of things the defense could still be hitting on. You know, we heard just very briefly starting to touch on circumstances about Brian Higgins and him going back to the Canton Police Department, him claiming that the reason he didn't see John's body lying there in the snow when he left is because he had been plowing and he didn't see over the snowbank. But we've seen some videos from this time frame, and we also have that testimony from the weatherman. You have barely more than a cat's track worth of snow at this point in time. So like a half inch total accumulation by 1 a.m. So not something that we're plowing. But we haven't gotten into Jen McCabe's phone calls, her phone records. We haven't gotten into really the how shall we say, the travel path of John's phone. Who actually handed over John's phone at the Canton Police Department, supposedly on January the 29th? Got it over to Nicholas Guarino that afternoon. Don't know that. Julie Albert gave the interview where her time frames are a little off. Her story doesn't really match the other ones. She said that Jen McCabe had called her at 5 a.m, and that's how she found out John was dead. That's a little bit of a problem for the Commonwealth's version of events here. Nobody's supposed to know John is dead until after 6 o'clock. And so these are just pieces of information that they had that by his own testimony, that's the type of thing you're looking for. You're looking for conflicts in the versions of events. You're looking for stories that don't add up with the facts as you know them, with the evidence that you've uncovered, looking for fabricating alibis and so forth. That's just some of the stuff that they would have been aware of as this was unfolding. But then we've got the whole shenanigans with the Sallyport video, all of that stuff too. Wouldn't you have gone and verified Brian Alberts's actions after he told you gave you his version of events. You testified. That's part of what you do. You don't just take a witness's word for it. Witnesses don't lie all the time. Not all the time. That's too much. It's just helpful witnesses that are always being helpful. No, so you have to try to corroborate people's stories. So surely you would have tried to corroborate Brian Higgins' story, because it would have been so easy. There's all that video right there at the Canton Sallyport, and you could just verify. They got the card keys. You could just verify. He went back. He was doing what he said he was going to be doing during that time frame. But if you went and looked at the Sallyport video, that's going to start opening up some doors, isn't it? Opening up some questions about when you had, what you had, and when you had it. Because the story on that has just been all over the place. First, it was all gone. Then it was downloaded. Then it was stored on a secured server. Then it was on the iCloud. Then it was on some officer's personal device. Stories have just been all over the place about what's going on with the Sallyport video. And Trooper Bukhenik doesn't have testimony from last time that he can fall back on. This would be new. The defense has information from a variety of sources. Different people have made different statements about what's going on with the Sallyport video that we know about from the pretrial proceedings. So does he know? Does he know all that? Has he tucked all that away in his mind? I don't know, guys. So we could have Trooper Bukhenik all day today too. That's possible. I think that's possible. With the volume of information that they have to go through, and the attitude that he's had toward testifying. His attitude towards testifying has hardly been prepared and helpful. Not exactly a situation where he's gone back and carefully reviewed all of the 80-some reports. I don't even know how many there are in total. We just heard that number 83 thrown out on Friday, report number 83. Carefully reviewed all that to make sure he's familiar with the facts and circumstances of the investigation to be able to testify to it. No, that's not Trooper Bukhenik. He's been so resistant, and like, to the lawyer watching it, me, the lawyer watching it, I'm sure other lawyers watching it are seeing this too. He's really given away the game with some of the technical nature of his explanations for why he doesn't know, why he doesn't remember, why he won't concede a point. There was one just last Friday where he's being shown a document. I believe it was probably an extraction of Trooper Proctor's texts, just given the context. And the questioning was about whether Bukhenik had instructed Proctor to go and do something. I forget which aspect of the investigation. But so it seems that it's there in a text message. Asked if it refreshed him to review that text message, and Yuri indicated no, it did not refresh him, but he would take the document as true if it were a true and accurate and authentic representation. This is technical. This is legal technical speak. Yuri understands this game extremely well. For a document to be authentic, true and correct copy of what it purports to be, that is your foundation to get an item into evidence. So this is Yuri fleshing out, is this item in evidence or not? Is it in evidence or not? And he's probably got a suspicion it isn't, because if these extractions came from the FBI, and we have reason to think they did, that's how all of this came out in the first place. The FBI did their investigation. They confronted a number of these witnesses, including the law enforcement officers, like Michael Proctor, confronted them with what they had found during the federal grand jury proceeding in the late spring, early summer of 2023. That's how a lot of this information came out about what Proctor was texting with his buddies, things like that. So Bukhenik knows that came from the FBI, and the FBI, the Commonwealth is not calling the FBI as a witness. He knows that. So it's a fair gamble on his part. These texts are not already in evidence, so I can deny, I can push them off. They haven't been established as authentic, and I can deny any memory of what they contain, because they can't be handed to the jury and read out or whatever to contradict me. So he's very, very educated in this game, and that's why he's no Albert Einstein. Obviously, this guy is not a super genius, but I've seen a lot of comments, oh, this is, dumb cop or whatever. I'm not getting that at all. He knows this game extremely well, and he understands a lot of the technical stuff that's going on behind this game, and he knows how to play it. He knows the difference between being refreshed and having a document and evidence that then can be read out to you to contradict what you just said. He showed us that on Friday. He understands that difference. So not a dumb cop at all, but a little smarter, it seems, about how to not admit things and not talk about things than about how to just freely and openly disclose the process and results of your investigation, where suddenly the details become vague. He doesn't remember. And so, it's coming off, I think, is pretty evasive, pretty combative, refusing to concede stuff. You should just concede. Why would you not concede? Why would you not concede the nature of those text messages? Why would you not concede that? At least now he knows. Now he knows if you're not going to concede that, we may be watching the entire thing.
Let's now open to make a seat.
We might have to read this whole thing out.
I came into 3 motions that I did not have when I checked email before coming to court today. So I'll hear you quickly on these. I've had a chance to read them. So, Mr. Brennan, I'll hear you. Let's today focus on the Boden ones. We can focus on the other one later.
My motion memorandum on Boden just iterates my objections continuously at sidebar, that not all evidence is admissible, characterization of evidence is not admissible, and the defense should have the ability and intention to follow up with substantive proof if they're going to ask a question. It's not limitless. Boden is wide parameters to ask the investigator about their state of mind, about the scope of the investigation, but it has boundaries of reasonableness. And my earlier objections about offering information that go into beyond Boden, delve into third-party, inadmissible evidence, those objections are what compelled me to draft this motion. And I can continue and will continue to object during the case, but once the questions are asked, if they're improper, the jury hears them, it inflames the jury. And without a basis and an intention to follow it up with substantive proof, the question should not be asked.
So the one point I want you to focus on, Mr. Brennan, is the specific evidence regarding materials that Sergeant Bukhenik has not been able to look at.
You want me to?
Is that something we can do here in open court, or based on the protective order, is that something that should be done at Sidebar?
Sidebar.
All right, why don't you come up, Mr. Jackson?
Okay, so going to Sidebar now. I do see there has been posted a copy of the motion. I think this is what we're talking about. The Commonwealth's motion to preclude inadmissible hearsay under the guise of a Boden defense. It is replete with typos, as we're used to from Mr. Brennan. And so what he seems to be arguing is that the defense is exceeding the scope of what Boden allows, which is to question about the failings in the investigation. What did you pursue? Why did you pursue it? Why did you fail to pursue certain things? And he is suggesting, I guess, that they're getting in. Okay, so number one, they're getting into issues that they can't substantively prove. This might be Proctor's text messages, right? If they can't call the FBI, and you can't call the FBI without going through TUI. There's no FBI officer, agent on the defense's witness list. So they can't get it in that way. They would have to get it in through Proctor, I guess, would be their expectation. And I would think that they could do that because he testified about all these in the first trial. He acknowledged them. He, tried to excuse them, minimize them, etc. But he acknowledged them as his text messages. But so he doesn't want the defense to ask questions about things that they can't actually come back and prove in some way. I don't know what his example of that is. So first he says the defense's attempt to elicit inadmissible hearsay under the guise of a Boden defense is improper. They failed to establish that certain information, particularly confidential materials provided by the U.S. Attorney's Office in February 2024, were known to Sergeant Yuri Bukhenik, or that in these circumstances it would have been reasonable for police to investigate such information. For example, the federal government's decision to obtain cell phone records of an investigator and civilians does not fall within the parameters of Boden, especially when there has never been a showing that those cell phone records were material and relevant to the investigation. Pretty sure that the text messages and the communications and the butt dials and so forth were very much relevant to the investigation. That's why they came out in the first trial. So he's trying to say that what the feds got should be off limits because it doesn't, there's no showing, I guess, that the Canton Police or the Massachusetts State Police should have come across that information themselves. Isn't that a question for the jury to decide? If the evidence is available and it's relevant, communications between the people in 34 Fairview the morning after all of this is happening seems to be pretty relevant, particularly when they've lied about it. Then the question is simply, is that something that this investigation should have uncovered? And that's for the jury to decide, is it not? That's the nature of the Boden defense. If you had taken Brian Albert a little bit more seriously as a suspect and you'd looked at his phone, you would have found the butt dials. You would have found the butt dials. You would have found the group chat and all these conversations during the group chat, which are clearly relevant to the investigation because they're in evidence. They've been allowed in. They're in evidence. So, this is kind of typical Hank talking in these broad general terms without being real specific about what he's trying to say. Okay, challenge a specific piece of evidence then. What is it? I don't know. He's trying to make a general claim. When I think of what the specific example is, to me, this argument doesn't work, but he's not giving me some alternative to be able to work with. So then he's arguing they're trying to admit otherwise inadmissible evidence. Evidence admitted pursuant to a Boden defense is not hearsay because it is not offered to show the truth of the matter asserted, rather that the information was provided for police. Is information that the testifying witness has personal knowledge of, and yet that information was not adequately investigated. Okay, so it's not hearsay. If it's not offered for a hearsay purpose, and that's the whole point, It's offered to show this is the information that you had and what you did with it or did not do with it. That's the nature of the Boden defense. So it's not because anything that's said in these text messages is true or not true. That's not the argument that's being made. We're not arguing at this point. Brian Albert did it. Brian Higgins did it. Jen McCabe did it. That's not the argument the defense is making. They're saying there's enough suspicion here, given these facts, that you should have followed up on it. You should have investigated these leads further. So it's not hearsay, and yet this whole motion is entitled Preclude Inadmissible Hearsay under the guise of a Boden defense. But it seems like you're just now acknowledging it's not hearsay. Boden does not permit the defendant to ask questions without proper foundation or questions that are replete of authenticated inadmissible hearsay solely to infect the jury with speculative claims that the defense has continually failed to establish. This is, again, it's just, okay, what exactly are you talking about? Tell us, what is the unauthenticated inadmissible hearsay that is going to infect the jury with a speculative claim that the defense will continually fail to establish? What are you talking about? Identify the issue. I think this is the Proctor text again, because it came from the feds. And just talking about that. Yuri, he's smart. He knows his game. Well, if it's authenticated and true and correct copy, I'd take the document for it. But it's not in evidence. And their only pathway to get it into evidence is going to be likely through Proctor. I would think the defense could get it in that way. Similarly, if the defense intends to claim that police lost or destroyed evidence, the defense bears the initial burden to establish a reasonable possibility based on concrete evidence rather than a fertile information that access to the evidence would have produced evidence favorable to his or her case. If the defendant meets that burden, the trial judge must weigh the culpability of the Commonwealth, the materiality of the evidence, and the potential prejudice to the defendant. This, I think, is talking about a spoliation instruction. Not sure that is necessarily the same standard that you have to meet to order that under Boden there was something that they should have preserved, something that they did not preserve, or anything like that. But I could be wrong about that. Nevertheless, this is going to get into the Sallyport, isn't it? And the 43 missing minutes, the apparitions, the misrepresentation of the nature of what the Sallyport video showed in the first trial by Trooper Bukhenik, where they put up the video of the Sallyport and he narrates it and he says, look, you can see there's nobody near the passenger side tail light because they're all over on the other side of the car. Except lo and behold, it turns out this is an inverted video. It's mirror imaged. It's been flipped. And so when you consider it that way, the people are actually all near the right rear tail light. So all of that remains to be dealt with. Does that create a reasonable possibility that the Sallyport video that would have shown the exact time when Karen Reed's car is brought in, the taillight, the condition of the taillight, so forth, just happens to be missing? And then there's all these other circumstances that are highly suspect concerning both the handling of the Sallyport video, when they got it, what they got, when they handed it over, the multiple stories they've given about it, and then what the Sallyport video itself depicts and how they have misrepresented it. Is that altogether enough to raise a reasonable possibility that the reason why, for example, those 43 minutes are gone because not helpful to the Commonwealth's case? Seems like it to me. And ultimately for the jury to decide. So given the defense strategy to ask repeated, improper, and argumentative questions, a curative instruction is insufficient. Therefore, the Commonwealth requests a voir dire hearing of Sergeant Bukhenik for the court to determine whether the areas of the defendant's proffer of Boden evidence is admissible before evidence and argument is made to the jury. So what he's asking for, What he's asking for is he wants to be able to have Alan Jackson ask all of the questions of Sergeant Bukhenik outside of the presence of the jury so he can see if they're good questions or not. Give him a trial run. He wants a trial run. And then bring the jury back in and do it again now that he's had a chance to practice. That is what he's asking for. So I see Rob's here in the chat. Good to see you, Rob. Hank wants his cake and eat it too. Doesn't want to call Proctor, but doesn't want defense to cross Yuri Bukhenik on things Proctor didn't investigate. 100%. 100%. That is what he's trying to do here. And he's also trying to, he's trying to get the preview of what the defense is going to ask about. Give Bukhenik a chance to think about how are you going to answer these questions before you got to do it live and in front of the jury. So if you got to sit there and pause and smirk and do all the things that he's done to buy himself time to come up with an answer that he thinks might be plausible, he can do that outside the presence of the jury, and then by the time the jury comes back in, he'll have that all figured out. So quite a little clever trick he's got going on. So I think we've got also some more. We've got one other motion here. Dee Dee, of course, fabulous Dee Dee. She's at Special Sauce on X. If you are not following Dee Dee on X, you are not getting the documents like as they come out, when they come out. Second motion here, the Commonwealth's motion to introduce additional evidence of the nature of the defendant and the victim's relationship. So let's see. The Commonwealth moves to admit testimony through percipient witnesses who observed the defendant and victim's volatile and hostile relationship as it existed at the time of the victim's death. 4 weeks prior to the murder, the defendant became enraged at the victim for speaking to a female friend who was on their group vacation in Aruba and accused the victim of having an affair. This incident was observed by numerous individuals who will testify to their personal observations of the incident, as well as to statements of the defendant in the immediate aftermath. He wants to bring in Aruba now? We're in like the last week of his case. He conceded in pre-trial they weren't going to raise this because there was a defense 404B motion to exclude quote unquote prior bad acts. And he said we don't have to deal with this because he's not going to bring in Aruba. Oh, we do trial now?
Bring in the jury. Will that
Aruba?
take a couple minutes, Paul? Okay, thank you.
All rise, please.
Oh my Lord. This is nuts. This is nuts. So evidence of the Aruba incident was proffered by the defendant through a series of text messages between the defendant and Brian Higgins, thus opening the door for the Commonwealth to rebut the defendant's misleading and inaccurate claims about what had occurred weeks prior in Aruba. They're not offered for their truth, though, are they, Hank? None of this was offered for its truth. It's offered to the Boden defense. These were the texts that were given to Yuri Bukhenik that he didn't follow up on, didn't raise any questions to him about, does this guy maybe have a motive? Not offered for their truth. So if they're not offered for their truth, there's nothing to rebut. Definitely trying to have it both ways here. This incident in Aruba seems to be the turning point in the relationship. Oh my Lord. Oh my Lord. So he wants to bring in testimony through Laura Sullivan, Marietta Sullivan, Aaron O'Keefe, and Juvenile KF about the Aruba incident. You know, this is a very much a maybe be careful what you ask for situation because the Aruba girls, you guys remember the timeline of the investigation and how the Aruba sisters, Marietta and Laura Sullivan, were interviewed 10 days after John's death. Meanwhile, the eyewitnesses who were there at the scene, Heather Maxson, Ricky D'Antano, what did we just hear on Friday? Took over a year to investigate the eyewitnesses. But 10 days later, there they were right on top of Aruba, following that up. Oh, guys, what a disaster. This is Hank. This is Hank flailing. I don't know how or why he wants to go down this road now. I don't know how or why he thinks this is a good idea. He's not getting his voir dire. Okay, they're bringing the jury in. He's not getting his voir dire. So I'm imagining we're going to come back to his desire to get into the Aruba sisters now. Some point later. I mean, once Yuri is done, I guess we can deal with that. Yikes. Is that's quite a Hail Mary. You think this is going to help? You think that's going to help? Oof. The volatile and hostile nature of their relationship. He's fallen right back now into Lally's case. Lally thought this Aruba stuff was really important because it gave Karen a motive for murder. Right? A month before John is dead. And they go on this vacation with a bunch of John's friends. And there is like nothing going on but drinking. They're just constantly at the bar, going here, drinking that, drinking this other. And Karen is the one left on New Year's Eve in John's room to take care of John's kids while John is out partying with his friends, continuing to drink. And then, according to Karen, catches him doing some improper physical stuff with one of these Sullivan sisters.
You are unmuted.
And then they made up, and here we are today. But somehow all of that stuff a month before is Karen's motive. I mean, he's really flailing. If this is where you want to go and what you want to get into, this is a bit of a disaster. Yeah, I'm with you, Rob. These motions suggest AJ did real damage Friday, 100%.
All persons have any business before the Honorable Beverly Canoni, Justice of the Norfolk Superior Court before the County of Norfolk. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is now open. You may be seated.
Hank is trying very hard.
Good morning again, counsel. Good morning, Ms. Reed. Good morning.
Hank is trying very hard to recover from Friday.
We appreciate your patience this morning. We're trying really hard to cut back on the sidebar conferences, so we spent some time this morning, hopefully paving the way for that to be able to happen. So we do appreciate your patience. I do have to ask you those questions. Were you all able to follow the instructions and refrain from discussing this case with anyone since we left here on Friday?
Great question.
Everyone said yes or not.
Great question.
Were you also able to follow the instruction and refrain from doing any independent research and investigation?
Still waiting to hear about John's injuries and the proof that he was hit by a car.
Did anyone happen to see, hear, or read anything about this case since we left here for the week? Everyone said no. Thank you. Could we have Sergeant Bukhenik again, please? And Mr. Jackson, you can go to the podium.
Thank you, Your Honor.
Now, for all that some of these comments are not particularly helpful or appropriate, she has now kind of made it clear to the jury, if Hank starts objecting, we have to have all these sidebars. His fault, man. We tried to sort it out this morning.
Sergeant, I'll remind you, you're under arrest. Thank you.
Good morning.
Well, is he all
Mr.
rested
Jackson,
and
whenever you're
refreshed?
ready.
Thank you, Your Honor. Good morning, Sergeant.
Good morning.
I'd like to ask you, just to start off with, at some point during the course of your investigation, did you become aware that a snowplow driver had reported having seen a Ford Edge being moved into a location in front of 34 Fairview sometime in the early morning hours of January 29th, 2022?
we learned about a plow truck driver. I don't believe his recollection was as you described, though.
Do you remember him mentioning a Ford Edge?
Yes.
Okay. And do you remember him saying that the Ford Edge had been moved? He had passed by, it wasn't there. At some point, he passed by again, and it was there, impeding his plow route.
Yes.
Okay. What is your best memory about when he said he believed the Ford Edge? Sorry, I guess a better way to put it is, when did he say he first saw the Ford Edge in place in front of 34 Fairview?
I don't remember exactly. I know it was during the middle of the night. My not adopting your narrative was the fact that he saw it being moved there.
Understood. I figured that. I clocked that as soon as I said it. He didn't see it moved. He saw it. He saw 34 Fairview without it there. Then about an hour later, it was there.
I believe so, yes.
Okay. Would about 3:30 in the morning sound right to you in terms of what he reported, in terms of the time that he saw it there?
It sounds right, but I'm not sure of the exact time. My report would reflect the accurate
Refresh
time.
you.
Fair enough. Let me see if I can grab that.
So a Ford Edge right there by the body. What did you do to follow up? Because that Ford Edge, if it's not nefarious, it's an eyewitness.
Sit there and wait. Let me just ask this. Do you remember him saying that he had first plowed the area free of the Ford Edge? In other words, first passed in front of 34 Fairview around 2:30 in the morning? Does that sound right?
I believe his dispatch time for the plowing of the roads that evening was 2:30, but I would have to look at my report.
That's fine. And then it was sometime subsequent there too that he saw the Ford Edge in place, maybe an hour later.
Sounds about right again.
Okay. Did you take any investigative steps when you learned about this snowplow driver to determine who, if anyone, might have owned a Ford Edge associated with 34 Fairview?
Any Ford Edge. It's a potential eyewitness. How would you not follow up on that?
I did not know.
Did your investigation ever reveal that the Albert family actually had a Ford Edge at the time?
Yes.
I want to shift gears for a second to
Good, Alan. Just got the facts out. Didn't
One
make
Meadows,
him try
if
to
I could,
explain it.
and ring video evidence associated with One Meadows. You testified that on direct examination that there was no video from Ring at or around the time 12:36 a.m. When Miss Reed's SUV returned back to One Meadows. Do you remember that testimony?
Yes.
You did receive a search warrant returned from the Ring Corporation in furtherance of a search warrant executed by Trooper Proctor, correct? Former Trooper Proctor.
Evidence was returned by Ring, yes.
And in addition to the actual video recordings, there was also an activity log that was returned associated with that time and that location from the Ring Corporation, correct?
There was a key log identifying each video that was provided by the time and date when the video was recorded. It's not an activity log per se for the account. It's strictly a key describing the video, telling you what time the video was recorded.
During the entirety of your investigation, was there any evidence uncovered at all that Ms. Reed had accessed the account information associated with that Ring account?
No evidence could be provided by Ring documenting that activity.
But there is evidence that someone had accessed the account through John O'Keefe's cell phone, correct?
I am not aware of that.
Are you aware that after John O'Keefe's cell phone was recovered by Massachusetts State Police, someone at Massachusetts State Police actually opened the Ring app on his cell phone?
Ooh.
Yes.
Who is the person who opened and accessed the Ring app on John O'Keefe's cell phone?
I'm not 100% sure.
Are you 95% sure? I'd take one standard deviation.
Yes.
I'd take two. Oof. They got it from the phone data, didn't they? Love to know. Give us details, Alan. What time did this happen?
Look at a report, perhaps.
Yes.
May I approach?
Yes.
Doesn't know who. And you didn't follow up on that? That didn't cause you any investigative heartburn to try to identify that person?
And tell me if that refreshes your recollection.
Does that refresh you? The who got into John's phone? Or is this not a true and authentic copy? If it is, he'll accept it. That's fine. That lays the foundation for Mr. Jackson to get the report in during the defense case. If he just denies it, read it all very carefully and think about how you're going to handle it. This is one of their local reports, so. Doesn't look happy, does he?
Sergeant, having looked at this report, does that refresh your recollection as to who may have accessed that Ring app?
Yes, that report is authored by Michael Proctor, and it says that investigators accessed the Ring application.
Thank you. I want to show you one other document, if I could.
The sticky note. Is this the sticky note from DeChico? Maybe, maybe not.
Thank you. I've just handed you what purports to be the search warrant return for the Ring, from the Ring company, correct?
I got to take a look through all of it.
Of course. Take your time.
Take your time. Look through all of it. Look through all of it. The warrant return says that they provided activity logs, and activity logs should show what action was taken on the account in the app. Videos viewed, videos deleted, whatever. But strangely, the activity log has never shown up in trial. Certainly seems like something an investigator would want to follow up on. There's critical missing evidence. Get into that activity log to find out when it was deleted and how, by what device, etc. That would certainly help you narrow down the options for why that video is no longer there. Instead of just, getting on the stand and implying Karen did it when you could have verified.
Thank you, Sergeant. Have you had an opportunity to review that document?
I have.
Does it indicate that in addition to several other files, there is a login session report that was produced by the Ring Corporation as well? It's highlighted on that page.
Number 4 is highlighted with one Excel file containing login session information.
Thank you. Mayor Approach?
Yes.
And again, just to make sure I'm very clear about this, nothing from the Ring Corporation suggested or intimated that Ms. Reed actually accessed any of that Ring account information, correct?
The information provided did not indicate that, no.
Thank you. I want to ask you a couple of questions about your testimony on direct examination related to your trip to the hospital and your observation specific to Mr. O'Keefe's right arm. You indicated that you saw bruising on his right arm in addition to the abrasions, the parallel abrasions that you described, correct?
I believe bruising is very similar to abrasion.
Okay, that's my question. Can we, Your Honor, with the court's permission, can we show Exhibit 1? It's already been introduced. Is this a fair and accurate depiction of what you saw in terms of the condition of Mr. O'Keefe's arm while at the hospital, if not exactly like this?
Yes, it is.
Okay. What did you mean when you said you saw bruising on his arm? What were you talking about?
Up there by his shoulder?
I actually indicated bruising on his right hand, the back of his right hand.
Okay, fair enough. From his wrist, when I say arm, can we agree, at least for this purpose for the purposes of this discussion, that I mean from the wrist up to the shoulder?
Mm-hmm.
Did you see any bruising from the wrist to his shoulder?
I saw exactly what's depicted there with the abrasions and lacerations.
Okay. You know what lividity is, correct?
I do.
Okay. Describe for the jurors what lividity is.
Lividity is the pooling of blood inside the body as a deceased individual falls or is positioned naturally with gravity. Blood begins to settle in the lowest portions of the body. If you're laying face down, it'd be your face. It also contours to the imprint or the force that's exerted on the body from below. If someone's deceased on
like a phone?
TV remote control, you can see the remote control, the buttons underneath.
Oh, you mean like a phone?
So it's a bluish, purplish discoloration of the skin, not from an impact, but from the pooling of blood after the heart stops, correct?
That's correct.
Do you see an area at the upper arm that the skin looks discolored in addition to the abrasions that we see?
I'm sorry, I was looking at that one.
Oh, sure, I'm sorry, yes. Right up toward the upper biceps, triceps area.
I see that area, yes.
Okay, is that consistent with lividity rather than bruising?
I would not agree with that, no.
You believe that that's a bruise?
I believe that that's a laceration.
I'm sorry, I'm talking about the discoloration of the skin, the reddish purplish hue of the skin, separate and apart from the abrasion. From the abrasions or lacerations.
I mean, I saw
to the
it.
skin.
It looked like
The
bruising.
discoloration. Do you see that discoloration or no?
I do not know.
You do not?
I do not know.
Okay, we can take that down. As you sit here today, you're not suggesting that you saw bruising from the wrist to the shoulder on John O'Keefe's arm?
Nothing that stood out to me.
Okay.
I observed lacerations and abrasions.
All right, thank you. I want to shift gears one more time and ask you about your trip to Dighton and the seizure of the SUV. You testified that you seized the SUV somewhere, I think your testimony on direct examination was somewhere around 4:15, 4:17, something like that, correct?
Yes, sir.
Does 4:12 sound like it could be a reasonable time that SUV was actually seized in Massachusetts State Police custody?
It could be reasonable. I'd have to refer to the video evidence that, and then also the exact time that we advised the defendant that we are going to be seizing it. I guess it could be argued that that's when it was seized. Even we had the intent to seize it right there.
Right. Took the key fob, went outside, had a, had a tow truck driver actually put it onto the back of a flatbed. Ultimately, it was transported, correct?
Correct.
And you became aware at some point that there was video evidence, you just referenced it, video evidence of that, I'm going to call it seizure process. Is that right?
Yes.
And that video evidence had a timestamp on it, correct?
Yes.
Okay. You're also aware, as the supervisor of Michael Proctor, that he swore under oath in multiple affidavits in support of search warrants that the SUV was seized at 5:30 p.m., correct?
Yes.
That was not accurate.
And you knew at the time, because you were actually there, and you knew when the vehicle was seized, that stating under oath in an affidavit that it was 5:30 p.m. and not 4:12 p.m., that was a false statement, correct?
There's a discrepancy in time there, yes.
Did you take any action, you yourself as a supervisor, did you take any action to correct that false or misleading state? Let me ask it a different way. Did you take any action to correct that time to the accurate time of 4:12 in any of the affidavits that you became aware of?
No, the actual time of the seizure through the video, we learned much later. So the approximate time, 5:30, although inaccurate, I did not take any action to correct it, no.
And you received that video as a production from the defense. You did not have access to that video, correct?
Yes.
And so at the time that Michael Proctor actually wrote and drafted these affidavits and swore to them under oath, he did not know that a video existed, correct?
Objection.
Sustained, you have to word it differently.
Sure.
You didn't know that it existed.
Let me ask it a different way. At the time that you reviewed his declarations under oath, you did not know that a video existed.
Yep.
No, we did not know.
Should be in the catalog and everything too. I mean, should be multiple ways to verify the
Let me have
time.
just a moment, Your Honor.
Sure.
Take a drink, Mr. Jackson. Get comfortable. Might be a
I
minute.
want to ask you about something that was brought up on direct examination. Sustained findings as it pertains to you. You've already talked about the fact that, Sergeant, you're a supervisor and we're a supervisor back in January of 2022 moving forward over Trooper Proctor, correct?
Yes.
Generally speaking, as a supervisor, your job is to properly and professionally supervise, show some authority over those in your charge. Is that right?
Yes.
Michael Proctor was, in fact, a trooper in your charge.
Yes.
And you would agree that your supervision has a direct impact on the character and quality of the subordinate investigators that you supervise.
Yes.
The whole point of having
Very different Yuri
supervision and
today.
a chain of command is to establish a certain amount of, for lack of a better phrase, quality control of the subordinates.
Yes.
That would also include quality control over the subordinates' investigations.
Yes.
On August 17th, 2022, you were in a group text with the following individuals: Michael Proctor, Trooper Kukowski, a lieutenant named Fanning, and a trooper named DiCicco, D-I-C-I-C-C-O, correct?
Yes.
No nudes yet.
May I approach, Your Honor?
Yes.
Get him into evidence.
I'm handing you a document. Can you tell me if you recognize that document?
Recognize your chat? What a different Yuri Bukhenik we have today. Isn't he agreeable? Isn't he agreeable? Almost wonder if somebody might have mentioned something to him about how he was coming
I
on.
recognize parts of it.
You saw that document on direct examination. I think you were shown the same document, correct?
It was different parts of it, but same. It's inclusive of within this document.
Okay. Let's start with this. You indicated that you did not see Michael Proctor's name on that document, correct?
He testified he didn't see the chats come in. He didn't know the context. He just thumbs up one of them.
Correct. His name is not on here.
But you do recognize that as being reflective, accurately reflective of the text chain that you were on August 17th, 2022, that group chat.
Yes, sir.
I'm going to do this a little bit backward, but bear with me. You do see the name Karkowski, correct?
I do.
You do see the name Fanning, correct?
I do.
You do see the name DeChico, correct?
I do.
And you do see the name Bukhenik, correct?
No, it's misspelled, but I know they're probably referencing me.
Okay. The only other text or person texting on that chain is a code, a lengthy, almost like a URL code with no name, correct?
Yes, you're right.
And the only person that I didn't name, whose name I did not read off, it's obvious on that document, is Michael Proctor, correct?
Correct.
So deductive reasoning tells you that that is the code is Michael Proctor. Is that right?
I would agree with you, yes.
Okay. In that text chain, it starts with Trooper DeChico sending a photograph, correct?
No.
May I approach?
Yes.
His name is misspelled. Wonder how it's misspelled. In Proctor's phone.
You turn to page 2683, please.
Wonder how it's misspelled in a way that Mr. Jackson can't take credit for.
Do you see a photograph there?
Yes, I do.
Okay. Fair enough. There were some texts between and among the group that preceded this photograph, correct?
Yes.
I want to start on this date, August 17, 2022, with this photograph. This photograph was sent by Trooper DeChico to the group, correct?
You need to look at the whole chat to see that.
It possibly appears that way. I really can't. I mean,
Your Honor, with the
Yes.
permission, I'm not sure this document has been marked. I'd like to have this marked and
Sure,
admitted.
we'll mark it for ID.
Have it marked.
I'd actually have it marked and admitted. There's certain things I'd like to show.
What's the Commonwealth's position on that?
I have no objection to admission, but not in this form. It needs to be redacted.
Can you do it
What I intend to do, I can do with one photograph. If I may have a moment with counsel.
Okay.
No objection to it being admitted. He knows it's coming in. It's coming in. It's coming in. So what was the basis then for that motion that you filed over the weekend? He's redacted because he doesn't want their phone numbers and evidence.
Right, thank you. Your Honor, with the court's permission, I'd like to publish just one page of what's been marked for identification. I'm sorry, I would ask that it be marked, the entire document be marked for identification.
Yes.
Yeah, I need this.
And then admitted.
It's exhibit FF for ID.
And with the court's permission, I would ask to display or to publish page 2683 of that document.
So are you admitting into evidence, page 263?
I would.
Do you have a separate one rather than tearing it out of what's been marked for
I can-
identification?
I can take it out of this copy.
The photo. I don't think we've seen the photo.
And can you
Going to a
redact
lot
it
of
before
trouble.
it's admitted, please?
It's been redacted.
Okay.
Exhibit 116.
Yeah.
Yes.
Thank you.
Now, I don't mind Bev's comments here. She is keeping him doing it
I'm sure we're
correctly.
talking about the
There's
same thing, Sergeant.
difference.
I've just handed you a page that's been marked Exhibit 116. Do you recognize that as being a copy of one of the multiple pages in the document that you're holding that's been marked for identification as FF?
Yes, sir.
Okay, if we could publish that single page, please.
Okay.
Is that a photograph that was sent by Trooper DeChico to the group?
According to this document, yes.
Who is depicted in that photograph?
The big story, Mr. David Yannetti, criminal defense attorney.
Do you see that person in court?
Yes, I do.
Where is he seated and what is he wearing?
He's seated right there wearing a blue tie and a dark suit, white shirt.
Thank you. We can bring the lights up, Your Honor.
Okay.
In response to, and going back to the multi-page document FF, in response to Trooper DeChico's photograph that he sent to the group, you responded to that photograph, did you not?
Did you not?
Yes, this document indicates so, yes.
And you responded by laughing at it, correct?
That's what it says, yes.
Well, that's what it says, or that's what you did?
Good
I
question.
don't remember.
He doesn't
Trooper
remember.
Proctor then, former Trooper Proctor, Michael Proctor, then responded, correct?
That's what it says here, yes.
And he responded to the group, funny, I'm going through his retarded client's phone, correct?
That's what it says, yes.
Michael Proctor then responded again. Is that right?
Yes.
No nudes yet. No
He
nudes
wrote,
yet.
No nudes so far, correct?
That's what it says, yes.
And did you
Michael
respond?
Proctor responded yet again. Is that right?
That's correct.
And in reference to Mr. Yannetti's photograph, he wrote, I hate that man. I truly hate him. Correct?
That's what it says.
There's a trooper by the name of Moore, M-O-O-R-E, correct?
There is.
And he disliked Trooper Proctor's phrase, the statement, no nudes so far, correct?
That's what it says.
Did that indicate to you that Moore was disappointed that Trooper Proctor, Michael Proctor, had not found naked pictures of Miss Reed as yet?
I don't know what that indicated for Mr. Moore.
How did you interpret it?
And then you responded to the phrase, funny, I'm going through his retarded client's phone, correct?
I acknowledged that text message being sent.
You acknowledged it by liking it, correct? With a thumbs up.
I acknowledged it by responding with a thumbs up emoji.
The fact is, Trooper Proctor told you, his supervisor, in this series of text messages that he was going through Miss Reed's phone. Is that right?
Correct.
And he also informed you, his supervisor, that he was going through her phone looking for nudes or naked pictures of her on her phone, correct?
I didn't see that. He didn't see that.
He did not tell me that he was going through the naked pictures, for naked pictures through the phone.
He wrote, no nudes so far, right?
That is what is written, yes.
What did you think he was looking for when he wrote that phrase?
I don't know what he was looking for.
What would be a reasonable interpretation of what Michael Proctor was looking for when he wrote, no nudes so far?
I don't know.
Motorcycles, handbags,
You don't know what's reasonable.
their shoes,
Thanks for spelling that out.
or naked pictures of Miss Karen Reed?
His mission was to go through the phone to look for digital evidence that's related to the crime. The fact that he wrote no nude so far, I cannot comment on.
You
Other
cannot
than the
comment
thumb
on
up,
or you
thumb up.
don't want to comment on.
I don't know what he was looking for in that specific time.
You certainly did nothing. You took no action to stop him from potentially looking for naked pictures of my client, correct?
That's correct.
In fact, last week you testified that in your view, Michael Proctor handled himself in this investigation with integrity. That's what you said, correct?
That's correct.
Do you stand by that testimony?
The investigation was handled with integrity and honor.
Do you stand by your testimony that Michael Proctor conducted himself during the course of this investigation with integrity?
Yes, I do.
He also called her retarded, correct?
That is what's written.
That's what's written? That's a very passive way of saying it, Sergeant. That's what's written, or that's what he wrote?
That's what he wrote.
That's what he wrote. Make it active.
And that's what you read.
I have no memory of reading that. I acknowledged him going through the phone on my Apple Watch. I have no memory of him writing retarded on a text message.
And you'll agree that that is one of the most vile and insensitive and incendiary terms one could use in modern society. Retarded, correct?
That is correct.
And in fact, through your response to that vile phrase, you encouraged it because you liked it with a thumbs up, correct?
Objection.
Sustained.
Did you encourage that statement by Michael Proctor by liking it with a thumbs up?
I don't know if it encouraged him, but so I cannot speak to
But
that.
that's what you did.
I acknowledged the text message being sent.
I want to be clear. These text messages were sent to you by your direct report, by your direct subordinate, correct?
That's correct.
And there was even someone on that text chain who was more senior than you, Lieutenant Fanning, right?
That's correct.
Michael Proctor was both your partner and the lead investigator on this case when he wrote that, correct?
Case agent.
He's a subordinate, and he was the case officer.
Yeah, I knew he was going to do that. Can't acknowledge lead investigator.
This thread, text thread, contains communications between a subordinate, the person you call the case up. By the way, let me ask you another question. Did you ever, during the course of the investigation in which you were a part, the sustained findings, the internal affairs investigation. Did you ever review Colonel Noble's determinations about your subordinate, Michael Proctor?
Objection.
Did you review them?
No, Your Honor, I did not.
So his own subordinate, he doesn't review his disciplinary.
What would Colonel Noble call Michael Proctor's title in this case? You think he'd call him the case officer or the lead investigator? What is your experience with Massachusetts State Police in that regard?
Objection.
Sustained.
He did call him the lead investigator. So did Bev.
Notwithstanding the fact that a subordinate was on this text chain and a supervisor to you, was Lieutenant Fanning one of your supervisors?
Yes.
Notwithstanding the fact that a subordinate was on this text chain and one of your supervisors was on this text chain, you felt comfortable enough within this group of law enforcement to actually like when the subordinate refers to a suspect as retarded, correct?
I acknowledge the text message with a thumbs up emoji.
Do you believe that? Well, let me ask you another question, a predicate question. You were also comfortable enough with that text chain to receive information that your subordinate was looking for naked pictures on a suspect's phone, a woman, no less. Correct? You took no remedial action against Trooper Proctor for that, correct?
No, I did not, no.
Do you believe, as you sit here, that that was a misuse of power and authority by a Massachusetts State Police officer?
By myself or somebody else?
By Michael Proctor.
Misuse of what?
Misuse of authority and power to go through a suspect's phone to get her phone using the authority and the power vested in that officer by the community members. That's the power that you've derived, correct? You work for the public. Would you agree?
Objection.
Sustained.
Do you believe it was a misuse of his authority and power to use Massachusetts State Police Authority to go through her phone and look for naked pictures of her?
Objection.
Sustained.
Do you believe it was a misuse of authority or power to go through her phone and potentially look for nudes?
Objection.
Sustained.
I don't know what's wrong with
Let me
this.
ask it differently. Did you think his text was appropriate?
I don't remember reading that text.
As you sit here now, do you think that text is appropriate?
No, it is not.
Do you think it's professional?
No, it is not.
Do you think it shows integrity?
That text message does not show integrity.
Do you think it shows honor? A word I expect you hold dear.
That text message does not show honor.
On October 15th, 2022, you completed a performance review of Michael Proctor, correct?
That's correct.
Specifically, you were asked to rank his, quote, oral and written communication skills, end quote, correct?
Oh, boy.
As part of an overall evaluation and performance review, is that right?
Yes, overall 90-day quarterly annual review.
You were specifically asked to rank whether he effectively would whether members, your subordinates, would effectively communicate with others, both within and outside the department, in oral and written form, correct?
That's correct.
And you rated him as exceptional, a number 4 rating out of 5, correct?
That's correct.
You actually went on to write and comment on Michael Proctor, and you wrote, quote, Trooper Michael Proctor displays professional demeanor, composure, dignity, and respect during the performance of his duties, and especially during his interactions with the public. This is seen during interviews with witnesses, suspects, as well as victims and their families, end quote. That was a statement you wrote about Michael Proctor, correct?
That is correct.
And this is after the text chain that we've just been talking about, where he calls Miss Reed retarded and references looking for nude photographs of her, correct?
That is correct.
Was your statement in that evaluation true or false?
It was true.
Not what your bosses
You
thought,
knew
though,
Michael
was it?
Proctor's proclivities, obviously. He told them to you, correct?
The term proclivities, what
You
does that mean?
knew what he tended to do, what he wanted to do through his own comments, to look for nudes on a woman's phone, correct?
Objection.
Sustained.
You were aware, sir, that
You can let it go, Alan.
he had received
Starting
evidence
to get
in the case,
argumentative.
evidence that doesn't belong to him, belongs to the Massachusetts State Police, at least at that point, correct? The cell phone.
I was aware that he received a cell phone, yes.
And he used that power and the authority to go through that cell phone and look for nudes of my client, correct?
Objection.
Sustained.
During the same course of your evaluation, you were also asked to evaluate his investigative ability, correct?
That's correct.
You rated him the highest standard in the Massachusetts State Police, outstanding, a 5, correct?
That's correct.
And you went on to write about Michael Proctor in the commentary below that rating to justify it. Is that right?
That is accurate, yes.
You wrote, quote, Trooper Proctor has had a high-profile caseload with a lot of eye and pressure from external sources during the first day of the investigation. He handled himself and all the case with utmost professionalism and competence. He is able to investigate his case thoroughly and with strict integrity, end quote. Correct?
Which quarterly review was this?
This is the same one, October 2022. Is that right? Those are your comments.
That sounds very accurate. I just was not sure which quarterly review that was for.
Professionalism.
Yes,
You believe that he acted in accordance with the highest standards of professionalism?
during his 90-day performance, yes.
And you didn't just say he displayed professionalism, you said utmost professionalism, correct?
Yes.
Competence? Do you
Yeah.
believe he displayed competence?
Yes.
And not just in integrity, but he conducted himself, as you put it, with strict integrity. Is that right?
That is correct.
Did it show integrity in your view when your subordinate Michael Proctor called Miss Reed retarded?
Objection.
I'll allow that.
I believe that as a U.S. citizen, he has the right to comment. That's his
First
First
Amendment?
Amendment right.
Oh,
We uphold the Constitution, and it's unfortunate, unprofessional what he said in the private text message communication. He might have been voicing his frustrations. I cannot speak for Michael Proctor. It is unprofessional and unfortunate that he said that.
This was not, Sergeant Bukhenik, a private text message conversation. This was with his boss and 4 or 5 other individuals, one of whom was your boss, correct?
Correct.
This was a communication intended for and received by members of his unit in furtherance of his investigative authority, correct?
It was amongst members of the unit.
He was updating his boss about what he was doing in furtherance of the investigation, going through her phone, correct?
No, I would disagree with you on that. This was a group chain, text message chain that we were discussing private matters in our personal lives.
Private matters, including going through Miss Reed's phone?
That is unfortunately shared on that group text.
So in other words, to the public, he holds one face in private conversations with you and your colleagues within the unit. He shows a completely different face, private face, correct?
Objection.
Sustained.
You
I
said that
can't
you believe that he has a constitutional right,
He's hiding by the First Amendment.
right, to call Miss Reed a suspect in his official investigation, in his official capacity as a Massachusetts state trooper, to call her retarded? That's your justification?
Objection.
Sustained.
Do you justify his statement, that vile statement?
Well,
I
he
do
just
not
did.
know.
Do you think it's appropriate, given the fact that he has a First Amendment right to say whatever he wants?
No, I do not.
Except
Do you
where
think
he
there actually might be
did.
members of the community, parents, siblings,
Objection.
children?
Mr. Jackson, I'm going to exclude that question as argumentative. Move on.
You wrote in your report, if I may have a moment, Your Honor, you wrote in your report about his conduct. He shows composure, dignity, and respect during the performance of his duties, and especially during his interactions with the public. He has a duty to the public, to the community that he serves, correct?
Yes, he does.
Just like you have a duty to the public and the community that you serve. Is that right?
That is correct.
Do you think community members might take offense to the use of the
Objection.
word retarded?
Sustained. It's argumentative again, Mr. Jackson. Please don't do that.
Telling him explicitly, they're sorting out what the
He
situation
didn't
is.
just put it, that derogatory comment. He didn't just put it, or he didn't just say it, correct? You talked about the First Amendment.
Objection.
Sustained.
I'm not finished with my question, if I could.
All right, so just ask a question.
Sure.
Comments first, okay?
My question is, did he just say the word, or did he go further than just saying it?
Objection.
Okay, we've gone through this. Move on, please.
The fact is, Sergeant, you put it in writing and you liked it, correct?
I acknowledge the text message. I never saw the vile term.
The vile turn. Isn't it your job to see the vile turn?
approach it just very briefly for a scheduling issue?
Okay, jurors, feel free to stand up and stretch.
Scheduling. So it sounds like we may be done. Not going to get into the Sallyport? Not going to get into the Sallyport? That seems surprising. Huh. I can't believe he's trying to hide behind the First Amendment. Even he knew, even he realized, oh shit, that was desperate. That's not going to fly. He has a First Amendment right at work to call the suspect retarded. Nobody's buying that one. Nobody is buying that one. That is not the law anyway. Yes, your employer gets to exercise control over your communications in scope of your work. You do not have unrestricted, unlimited First Amendment rights on the job. Oh boy, it really hurt him to have to walk back the integrity and honor and so forth of Trooper Proctor. He's really trying to still be part of the team, still have the back. Sergeant Bukhenik, if nothing else, man, he is one of the boys, doesn't he? He understands the mission. He understands the mission always. Always have the back of the guy in blue. He understands that mission loud and clear. You got to always have his back no matter what. Trying so hard. But you know, even he reached the point of having to realize this is not I can't say it. I can't say that was acting with honor and integrity. Mr. Jackson hasn't nailed down that his comments in this performance review are what were found to be inaccurate, are part of the reason why Bukhenik himself was disciplined. He hasn't closed that circle. He is getting argumentative. You know, this is the taking it the step beyond just eliciting the fact and now trying to get him to characterize it, to agree with your characterization, etc. It's not necessary, but it may be making a point to the jury. He's there reading them, seeing them react in real time. So there may be a reason for it, but we're at the point now where Judge Bev is being helpful. She is being helpful about what the issue is, both in terms of here's a marked item, you want to publish it. Well, are you admitting it? This is correct. This is procedurally what you need to do. You need to have it admitted before you can publish. And she's not, you know, just saying, no, we're not going to do that and leaving it to him to sort out. She's telling him, are you admitting it? She's cluing him in on what steps you need to take for that to happen. Same thing with the argumentative. She's making it clear this is what the problem is. All you got to do is solve that. Ask him about facts. Don't ask him about characterizations, and you're not going to have a problem. He's just he wants to fight with him over that admission about, you know, whether it's has integrity and honor and so forth.
We probably should have given you a break before this, but I thought that was going to be quick. Why don't we take the morning recess and we'll take two.
Court all rise for the jury.
And you're free to go out to work.
Already taken the morning recess, huh? Well, I guess it is that time since they had that late start. My goodness. So yeah, I mean, I feel like I know lots of people, and I certainly have my own issues with Judge Cannoni and her rulings and so forth. But I do feel like there's been a little bit of a shift in her handling of all of this and her behavior towards Mr. Jackson. She's not just being obstructive. She's cluing him in. Here's what the issue is. If you fix that, then you're going to be able to do what you need to do. I can't believe that Trooper Bukhenik volunteered in his explanation about lividity that if you're lying on something like a remote control, it'll leave the imprint and you can see the numbers. You've just told us there should be a clear imprint of that phone that John O'Keefe was lying on in the lividity on his back. You just told us that. I can't believe he volunteered that. I can't believe he volunteered that. But he did. Didn't hear anything about that in the last trial. Kind of would have expected we would have heard about that. That's a fairly important detail, isn't it? Important piece of the chain of custody of this phone. Didn't hear anything at all about that in the first trial, that there would be an imprint in the lividity on John's back showing where the phone was. Also, very interesting set of questions about apparent bruising on his right arm. I saw it when they had that photo up. Yeah, it does. It looks like he's got bruising kind of on part of his shoulder. I noticed that in the photo. Don't know what that means either. Didn't hear about that in the first trial. We're going to hear about it from a defense expert. I kind of think we are. I kind of think there's a reason why that was called out, because we're going to hear it from the defense expert. I thought Alan did a great job with that questioning about the ring footage. The fact twice he hammered it in. At no point did they obtain any evidence of Karen accessing the Ring app, but he is aware that Michael Proctor, per his own report, said that investigators got into the Ring app. Which they surely have no business doing. Can we infer that from Jessica Hyde's testimony about the best practices when you handle a phone? You disconnect it from the network, do the extraction, anything that's done afterwards, leaves a record, creates the possibility of overwriting, etc. She didn't address that specifically. Can we infer it from what she said? Of course, you're not supposed to go dig around in the phone, because you extract the phone, and if there's something that you want in the Ring app, you look for it in the extraction. You don't go into the phone and thumb through the phone. Gets more and more incriminating, this law enforcement handling of this investigation. And we haven't even heard yet about Trooper DeChico's sticky note about the Ring footage. Last trial, it was during Trooper Proctor's cross-examination that we heard about that. DeChico wrote a note. He was tasked with reviewing the Ring footage and was tasked with identifying timestamps of pertinent time frames. Boy, what did he timestamp? He timestamped that section when Karen's car returned home. That's, according to them now, not produced. Wasn't produced by Ring. Don't know how that works if he watched it and timestamped it. So that was a little bit of a problem that got identified in the first trial. Are we setting up the defense calling Proctor? Probably. I mean, I think the text message chain is probably one of the big clues that we got just from this cross-examination. But we already know from the opening statement, he's allowed, Alan Jackson's allowed to get into these text messages that were with the other law enforcement officers because Bukhenik was part of that and he had knowledge of it when it was happening. But the ones that Michael Proctor was having with his friends the night of January the 29th, where he's, talking about how she's going to, have serious consequences and making some pretty grotesque, crude comments about her. And then, of course, that statement that was given in opening, homeowner's not going to get any shit because he's a Boston cop too. Bukhenik didn't know about that. So none of that has come out in this cross because Bukhenik, didn't find out about any of that, if ever, until after the feds got it. So it wasn't part of his investigation. It's not something they can go into under the Boden defense. But it needs to come in because you told the jury in the opening that you're going to hear it. And so the way to get that in is with Proctor. So yeah, I think we're setting the stage to hear about and from Michael Proctor. If the prosecution isn't going to call him, then the defense will. I got a special joy out of Mr. Jackson calling out the use of the passive voice. Oh, yeah. Always look for the passive voice in the police report because if they're using a passive voice, it's written, it was said, it was taken into evidence. What they are not doing is telling you who. Who. The phone was given to us by whom? The passive is always obscuring somebody. And so it should be a big red flag, a big highlight. What is being unsaid here is who. He called that out, forced it to be active. That's what was written. That sounds a bit passive, doesn't it? It's what Michael Proctor wrote. Yes, let's get the who out there, explicitly identified. Very well done. I don't know. I mean, I don't know. Is retarded really like the most vile thing you can say today? I kind of doubt it. I honestly think there's much more vile stuff in Trooper Proctor's cell phone. Much more vile stuff than that, in my personal opinion. But, you know, whatever. The point is made. But wasn't going to allow questioning about whether Trooper Proctor was actually looking for nudes, because Bukhenik wasn't there and he doesn't know. He just knows what was said. And even that, he's, you know, playing the game. Well, I didn't see it. I don't remember. I just thumbs up to acknowledge it. And it's, of course, it's up to the jury to decide if that has any credibility whatsoever. But that's why she's not letting him ask about, were you in fact looking for nudes? You know, he was, questions that imply he was in fact looking for nudes, because he doesn't know. He just knows what Proctor is saying. So that's why those objections were being sustained. No Sallyport. That would be surprising, but we'll see. We'll see. We'll get into scheduling. So let's take a look at some of your guys' comments this morning. Sean Patrick, good morning. I've enjoyed listening every day, all day. Can't chat, but love the insights. Cheers. Well, thank you, Sean. Glad to have you join us. Appreciate you popping in this morning to let us know. This is, I mean, all day, every day. It's quite a trial to take in, isn't it? Quite a trial to take in. Oh, it has the occasional dull moment, but quite a bit of excitement and entertainment. Miriam, good morning, Mom. Good morning. Good morning, Miriam. Am I the mom here? I don't know. I don't know. Mom's never been a role that really suits me all that well. Casey Cat, reports over the weekend said the Commonwealth won't call the Alberts, Higgins, or Proctor. How do you think that will play with the jury? It just gives the defense, you know, ammunition to work with. These are key people. Last people in the house, some of the last people to interact with John at all. They're the ones that have this kind of aura of suspicion around them because of their own behavior. And then, of course, Proctor, the lead investigator, you know, it makes it look like the Commonwealth is hiding information from the jury, being selective, cherry picking what they want the jury to know about. So it just gives the defense an opportunity to riff on that and to highlight it. Strategically, is it smart? I don't know. It's a gamble. There's trade-offs. There's trade-offs. It's going to come in either way. These problems with the story and with the behavior after the fact. So to me, it seems like a little bit of an own goal to not try to get out ahead of that. We'll see what they do. Andrea McBurnett. Andrea, have you seen the recent tweet the Glare posted regarding John's shoe? Court TV had a piece on it. I haven't. No, I haven't seen. I haven't seen. You know, like everything that's gone through on Twitter, guys. I know. I actually. Problem is, I don't have any white-soled shoes. I was literally all set to do a demo of this. Go out at night, shine a bright-ass flashlight, backlight a pair of white-soled shoes, and show you guys how you can make the sole look black because of the shadowing. I don't have any white-soled shoes. Like I mentioned, I'm kind of hard on my hard on my shoes. And so white soles, not going to last very long with me at all. Maybe Jeff has some. I'll have to check and see. I don't think he's got any white soled shoes either. If I can hunt down white soled shoes, guys, I will. I promise you, I will demo this for you so that you can see. Very easy to get this impression through the photography. We did on one of the prior streams go through the exhibits from the last trial, specifically the photographs from the CERT search. And I will grant that they're not, there's different angles and stuff, different lighting. There's snow on the bottom of the sole, so it's not always the clearest picture that you might hope for, but certainly at least a couple of those to me feel like you can see at least hints of the white sole under there. So this is my view, guys. I really don't think there's a there. I think this is bad photography. This is the wrong people being called out to document that scene on January the 29th. It never should have been CERT. It should have been Crime Scene Services, the people who are literally trained in how to take crime scene photographs and evidence photographs. They didn't call those people out. So we get totally, taking bad photos with bad lighting, with some potato of a camera. I really think it's as simple as that. I know there's disagreement. We'll just have to see how it plays out. I mean, surely if there's a there, the defense will bring it up, right? And they'll follow up on it. I think there's a reason why we're not seeing anything, guys. But again, that's just my view. I think it's a bad photography issue. But does your mom deny it? Thanks for your coverage. Thank you for the your mom reference. Your mom doesn't deny anybody. Dayan Lujic, here's to a good start of a new week. I was thinking all day, would it be beneficial for every jury to have a lawyer as a juror, in your opinion? Well, I mean, it depends, doesn't it? You're not necessarily supposed to bring in outside, like, technical knowledge like that. They're supposed to just take the law from the judge and apply it and not question it. Just be passive recipients. And it's, I think, naturally, it potentially a lot harder for a lawyer to do that because they know so much more of the context. Guys, I've been waiting 25 years. Friday afternoon, I go out to get the mail. What is in it? Oof. Cover up my info here. Yeah, guys. Yeah. Very exciting. I got summoned. I can't wait. I'm so excited. I haven't been summoned in like 25 years. I know there's like 0 chance I'll end up on the jury. But I will be ready and willing. Oh, you best believe it. Yeah, there's a reason why attorneys are typically, probably more often than not, going to be stricken from a panel by one party or the other. We know too much. You can't just passively absorb what's presented. Too much perspective on the process and all that stuff. So you're dangerous on the jury to one side or the other. So chances are extremely high you're going to get stricken, especially somebody like me. I'm in criminal defense on the side of the defense is how that's going to be perceived. But it's not like a rule. It's not a hard and fast rule. You're not like automatically disqualified because you've been a lawyer. So yeah, I mean, I think the problem is, as far as your question goes, I think the problem with it is that it's hard for lawyers to play that role of just accepting the law passively, not bringing in their outside knowledge into the deliberations. So if you want a truly passive jury, lawyer's probably not your best bet at that. Casey Cat, fun fact, the new pope grew up in my old hometown with me, Dolton, Illinois, just a few blocks from me. We are the same age. His house in St. Mary's First Church, he said, mass at, are still there. Oh, what a great little story, personal anecdote about the new Pope. I haven't paid any attention to that. Like the news has been not on my radar for quite some time anyway. I was only, I hate to say this, I hate to admit it, but kind of only vaguely aware that Pope Francis had passed away. Didn't pay attention to the conclave or anything like that. So I assume that happened if we have a new Pope now. That is exciting. And so he's an American? The new Pope is American? That's new. Have we had? I don't think we've had an American Pope before. I don't know. Now I'm intrigued. I'm gonna have to go follow up what's going on with the Pope. Dalton, Illinois, just a few blocks away. It is a very small world, indeed. Very small world sometimes. Track worker, Bev is incapable of making decisions from the bench. Well, she seemed to make a decision from the bench pretty rapidly this morning. Nope, we're not having your voir dire. Get the jury in here. I suspect there may have been a little bit of a conversation about what you're going to, what Mr. Jackson is going to get into, what kind of exhibit he's going to offer and so forth. And as long as he, does things within the parameters of the rules, there's not going to be a problem. That might be why she's saying argumentative. That was part of what Mr. Brennan was complaining about in the motion. Oh, he's using it as an opportunity to present these argumentative positions, and it taints the jury and so forth. So, yeah, you're not supposed to be argumentative. That's correct. That is objectionable, but you need to object when that's happening, and then she'll sustain it. And that's kind of my impression is, we heard more today about the basis for her rulings than I think we've heard at any other point in time. Got to admit the exhibit if you're going to publish it, right? Not just mark it for identification. It has to be admitted. And then the questions are argumentative. She came out and said that's why she's sustaining those objections. So I suspect there might have been some kind of, just came up at the bench. As long as you do things properly, don't get argumentative, it'll be fine. There's no reason to have a voir dire about that. So she did at least seem to get that one done quickly from the bench. Stacy LaBruno, if Bev grants this motion, then she'd better allow the defense's expert on police procedure. Can't have it both ways. She's going to limit their ability to get into Boden. Yeah, I would think that would be a problem. So she knows she has to allow them the full and vigorous cross-examination that she addressed in that order when she denied Michael Easter, excluded him as a witness. That was her justification. You can get this out through cross, so yeah, you better not be limiting cross then as a result of that. But the motion, it was incomprehensible. Keep out the hearsay, but you have to acknowledge this isn't for hearsay. It's not hearsay. It's not being used for hearsay purpose. He's not putting in any of this information because it's true. He's putting it in because it should have alerted investigators to facts that they should have followed up on. It should have raised suspicions. It should have caused them to look in other directions. It should have caused them to do other things. The Ford Edge, you get information that there's a Ford Edge out there at 3 a.m, right by where John's body is, and you're not hunting down the owner of that Ford Edge, who is an eyewitness. Under your theory, John's out there in the snow. This is somebody who may have seen him out there in the snow and can corroborate. Yeah, he was out there. At the very least, describe what they saw. Nobody else driving by this area. Matt McCabe, Brian Higgins, nobody in Matt's car. Nobody else leaving 34 Fairview. Nobody else sees John out there in the snow. You're going to tell me there's another potential eyewitness and you're not going to follow up on that? Of Of course you're going to follow up on that. Of course you are. Doesn't mean that it's true that there was a Ford Edge. It just means if information comes in, you should investigate it. So the point here is just the fact that they didn't. Joe Flipperhead, how about a Schwabomb? How about 2 Schwabombs? How about 2 of them? Looking forward to another week with you guys. Thanks again, Andrea. Yeah, another good week. Another good week. Maybe even some more good baseball. Oh, I realized last week I had forgotten we had already gotten a Ranger start since he came back from the injured list. Forgot we had gone. I might have blocked it out. Might have repressed that memory. Didn't go so well. But we got another Ranger start. Very good Ranger start. No runs, 3 hits, something like that. Very good, I think solid 7 innings out of Ranger. Yeah. We're back on track. We're back on track, boys. Thanks for being here with us, Joe. Let's have some more fun and maybe even some more Schwarbombs this week. Natasha, if the Commonwealth does not call Proctor, will the defense be allowed to call Proctor as a hostile witness? I haven't really been watching round 2. He is on the defense witness list. Yes, they can absolutely call him if the Commonwealth doesn't. That's part of why it seems to me to be such an own goal for the Commonwealth not to do that, because it's not going to keep him out. The defense will just call him. So the only limitations on the defense with this, you can't call a witness for the sole purpose of impeaching him. But all that means is that you have to have some information that you can elicit from him that's relevant and helpful to the case, in addition to however you want to impeach him. And so that's where the combative and evasive approach that Trooper Bukhenik was taking, Friday, last session. That's why that was maybe not so helpful. Because boy, if you don't remember anything and you don't recognize anything, well, now you've left the door open for we need to call Michael Proctor to substantiate those pieces of information. And now that's our basis for calling him for a reason other than impeaching him. You didn't know, so we got to ask Proctor. Maybe that wasn't the wisest strategy on Trooper Bukhenik's part. Definitely seemed to have a different attitude this morning, but I think the damage was already done. He's adjusted, but I think it might have come too late. Suddenly this morning, he's quite agreeable. I think that might have come too late. So they can't call him for the sole purpose of impeaching him. The only other limitation they really have is that they have to treat him like any other witness on direct examination. If they're the ones calling him, they have to treat him like their own witness. And it's generally only if he is uncooperative, combative, not giving them what they want, not understanding where they're directing him and his attention with their questions, then you'll get a little bit more leeway of the court to treat him as hostile, treat him as you would treat a witness on cross-examination, where you can be leading. You can focus him more directly. You can make it clear what point you're trying to elicit. If he's going to, get up and kind of play dumb about that. Michael Muddragon, I just knew Hank was a dirty liar when he said, I don't intend to, rather than I won't call the mean girls of Aruba. Weasel language, how expected. Well, you called it. You called it. He did. In that pretrial hearing. We don't have to address the 404B. I don't intend to call them. It was weasel language. You caught it. And now here we are. Haven't heard that motion yet. At some point, she'll probably, have a conversation with it. It should be on the record. I don't know why there would be any reason to deal with it at sidebar. We did get that little clue this morning. Okay, if they're going to sidebar, it's because they're talking about confidential stuff that's subject to the federal protective order. Not sure I buy that that's the only reason we've been going to Sidebar, but at least that explanation now is out there. And if that's the case, then there would be no reason to discuss this motion about the Sullivan sisters at Sidebar. We should hear about it in open court. How do you think that's going to sit with Bev? You think she's going to be pleased? This came up pre-trial. You said you weren't going to call them, so we didn't address it. Now you want to call them because the defense brought it up for a non-hearsay purpose. We had to go through and refresh Trooper Bukhenik's recollection of these text messages because he's the one who said, I don't know if I could characterize them as romantic or flirtatious. And without having reviewed all of them in context, I wouldn't be comfortable characterizing them. So we had to go through and review them all in context to see how he could characterize them after that. But none of that was offered for the truth. It was offered for the effect on the investigation. What did you do with this information that Brian Higgins provided to you? And the answer was nothing. Nothing. He didn't, he doesn't, does he know what a motive is? He didn't, a theory. He didn't know what a theory was. Didn't know if he should develop a theory about perhaps Brian Higgins having some antagonism towards John O'Keefe. Brian Higgins being at the home where John O'Keefe is on his way to. Brian Higgins even enthusiastically texting him, "You coming here? Question mark, question mark, question mark." Right at the time when that SUV is at or pulling up to the front of 34 Fairview. But he didn't know what a theory was, so he couldn't answer that. But that's the whole reason that questioning came up. So there's nothing to rebut in terms of the facts of Aruba. The facts of Aruba are not in evidence. In fact, pretty sure, let's just go back and look. Pretty sure Bev gave a limiting instruction when those texts came in, didn't she? Not offered to show the truth. She did specifically give them a limiting instruction. They are not.
We're back in session. You may be seated.
So there's nothing to rebut. This is a terrible argument. I don't think Judge Canoni is
So,
going to
Mr.
be
Jackson,
pleased.
I've considered your argument, and this is simply the wrong witness, so I'm not permitting that line of testimony.
Even for the singular request that I made a sidebar.
Even for that, so. All right, I think the jurors are, no,
Please rise to the jury.
So don't know exactly what that was about. The wrong witness, probably Proctor. Wants to get into the group chat. The one with Proctor's friends. He's not going to allow that. It's my best guess. But it could be some other aspect of the investigation. Maybe, the Sallyport video too. Proctor is ostensibly the one who requested it. He's the one that lost the file in his paper file. So it could be that she's going to require that to come in through Proctor because Bukhenik's role was limited to bringing the thumb drive or whatever from Canton Police back to the evidence, back to Norfolk County District Attorney's Office.
go right ahead whenever you're ready.
Thank you, Your Honor. Sergeant, I'd like to move to a different area. At some point during the course of your investigation, you and Michael Proctor interviewed Chris and Julie Albert, correct?
That's correct.
That was at the Albert residence, the Chris and Julie Albert residence, is that right?
Yes.
On or about February 10th, 2022?
Yes,
Does that sound right?
it does.
Okay. At any point before or during that interview, did Michael Proctor discuss with you a previous relationship that he and or his family had with Chris and Julie Albert or their family?
Yes, as we were walking up to the door, he stated that he knows them from he knows of them from around town and through friendship.
Did that cause you any concern that the case officer that had been assigned to the case, dealing with, obviously involving the Albert family, had a pre-existing familiarity or relationship with any members of the Albert family?
Yes, I followed up asking him if he hangs out with these people, how well he knows them. And he stated that he does not hang out with them. They're not his friends. He just happens to know them through people in town.
Did he tell you any specifics about communications he had related to Chris and Julie Albert?
No, he did not.
Did he tell you any specifics about communications Michael Proctor had with his sister as it pertained to Chris and Julie Albert?
No.
Did he volunteer any information about the relationship that he might have or his family might have, including his wife, with Chris and or Julie Albert?
That information did not come up.
Did you ever later learn, now I'm taking it outside of your conversation with Michael Proctor, did you ever later learn about friendship or connection that he and his family, Michael Proctor's family, had with Chris and Julie Albert or the Albert family?
I've learned of accusations. I don't know the extent of how familiar they are.
What accusations have you learned?
Through trial or through court proceedings.
Right, what are they? Give me the nature of what you've learned.
Objection.
Sustained. We need a time frame.
Sure. When did you learn of these, of this information?
That was July of 2023, I believe.
And what were the circumstances in which you gained this knowledge?
FBI told you?
There were accusations that Michael Proctor had familial friendship with these individuals, but the accusations were not factual.
Did you learn any specifics
of
the allegations? Did you use the word allegations? Or I think you used the word accusations.
Yes,
Were there any specifics?
there were.
You just said that what were some of the specifics?
Objection.
Sustained.
Well, by the way, did you say that you learned of these accusations during the last proceeding in this case?
Not the last proceeding.
Or prior proceeding in this case?
It was through court proceedings.
Okay, how did you learn that specifically, Sergeant? Did you watch some of the proceedings? Were they televised? Did someone report it to you? What were the circumstances?
I was present in court.
This was what year? 2023. 2023.
Yes.
And did you take any action to investigate further the accusations that you said came up in 2023?
No. Well, yes, I did. Yes.
Okay, what did you do in that regard? What were the accusations and what did you do to investigate?
The information had been learned and that it was not factual. So.
Okay, you're using the word information. Help me out. Details. What'd you learn?
There was claims that.
I object.
Sustained.
May we approach, Your Honor?
Yes.
Goes to his basis of knowledge, not being offered for the truth. She's now starting to get a little bit more restrictive about, I guess, what they can and can't do with the Boden defense. But the information wasn't factual. How do you know that? How do you know whether they were friends or not? You don't know. Did you ask Michael Proctor? Is that how you determined those accusations were not factual? Or did you look at the text about maybe giving Michael Proctor a present? I think that's what we're getting at here. There was a chat between Julie Albert and Courtney Proctor. Julie Albert was a babysitter for Courtney Proctor's kids, if I remember correctly. And they had a little chat very early into this investigation, thanking Julie, wanting to thank Michael Proctor for what he was doing and offering to give him a little present. I think this was a chat between Courtney Proctor and Michael Proctor. And Michael Proctor said, give it to Elizabeth instead, his wife. Give it to Elizabeth instead. This might be something that Bev is also thinking, just the wrong witness. You got to get this in through Proctor. I don't think that's going to be an issue. It came in the last trial through Proctor. So the issue here is whether it's going to be something that should have taken the investigation in a different direction once Bukhenik learned about it in July of 2023. This is now, well over a year after John O'Keefe is dead, well after Karen has been charged, but not yet having gone to trial. I don't see why not. If new investigation, new information comes up before trial, yeah, you should follow up on it. You don't just decide we're done because we have somebody charged now. You get new information that, say, exonerates that person. Yeah, you should be following up on that. And not doing that, I would think, would be pertinent to a Boden defense. So this isn't necessarily, quote unquote, exonerating, but it sure is impeachment evidence. This is Brady stuff. Should be disclosed, goes to Michael Proctor's credibility. The potential of receiving gifts from Julie Albert. I think it might have come up during Julie Albert's testimony too. I think it maybe came up then during the last trial. She was confronted with that during cross. So my suspicion here is that, Bev is questioning whether Bukhenik is the right witness to get into this, but he acknowledged that he learned this information and he didn't investigate it. That's what it's being offered for. It's not being offered for the truth of anything. It's based on what did you know and what did you do with that information? That's pretty clear, Boden. So given that foundation has been established, I think this should be allowed. But she does seem to be starting to get perhaps a little bit more restrictive. I think this is a good point. Details. How did you get the information? Well, yeah, he got it from the FBI grand jury. So now it looks like we're probably going to move on.
Final question, Sergeant. I think I asked this, but let me make sure I'm clear.
Final
Your
question.
interview, along with Michael Proctor, with Chris and Julie Albert, was February 10th, 2022, correct?
I believe so.
Okay.
I'm not certain on that, but I believe it was.
Okay. Well, let me just clear that up real quick. Will it refresh your recollection to look at your report?
Yes, absolutely. Thank you.
Does that refresh your recollection, Sergeant?
Yes, sir.
What was the date?
February 10th.
Thank you. Okay. I want to move to...
I guess just the last question about that. Not the last question, period.
Back to Canton PD. Did you at some point recover some videos. Or a series of electronic data that purported to be videos from Canton PD in furtherance of your investigation?
Yes.
And to whom did you deliver these videos, and whom were they requested by?
The initial request was by Michael Proctor. I delivered them to him.
Okay. Since that delivery, have you seen these videos?
Yes, I have.
Okay.
All of them? All the videos?
Your Honor, I'm holding a flash drive that I'd like to have, with the court's permission, I'd like to have marked as next in order for introduction, but I'll play the first couple of seconds of it and just establish the foundation first with the court's permission.
Have you shown it or discussed this with Mr. Brennan?
I've just discussed it with Mr. Brennan at the break.
What's the Commonwealth's position? I have no idea what it is.
Sure, we can mark, yes. Mr. Brennan said he'd like to review them before they get entered into evidence. We can mark them for ID for purposes of this examination.
I don't expect I'll object. I just want to review.
Okay, so we'll mark it for identification, please, Madam Court Reporter.
Exhibit JG for identification.
Just to establish the foundation so we know what we're talking about, did you see on some of the electronic devices that you picked up in furtherance of this investigation, video of somebody outside, now we're the outside cameras or outside camera view at Canton PD at about 1:30 in the morning on January 29th, 2022?
Higgins.
The digital video, one of the collection items. It wasn't a device. It was, well, I guess it is a device, but the digital storage that was collected had video from external view of the PD. I do not remember specifically seeing an individual, but
Okay.
I did review it.
Being of the parking lot area, at least one of them, one of the clips being of the parking lot area outside Canton PD.
I don't remember seeing outside parking lot. I'd have to see it.
I understand. Do you remember another clip being of the outside Sallyport with a pedestrian door? Not the big roll-up door, but a pedestrian door, someone going in and out of the pedestrian door?
I know the view you're talking about, but specifically what you're saying, I would have to see the video, tell you if I saw it or not.
And I'm asking a couple of these other questions. I think I may know what the answer is. There's another, do you remember another video being an internal corridor, looking down a hallway, seeing someone walk up or back?
Yes,
Do you
yes,
remember that one?
I do.
Okay, and then one on the outside, again, sort of passing from right to left, may not be intended to a parking lot, but at least an outdoor view of someone moving from frame right to frame left across the camera angle.
I don't remember that.
Do you remember that all these videos, I just mentioned 4, we've talked about 4, these videos were from January 29th, 2022, around generally 1:30, 1:45, 2 o'clock in the morning?
I'm sorry, I don't remember the exact time and date. I just remember seeing the file and reviewing it.
Do you remember Mr. Proctor asking for video attendant to January 29th? At least can we narrow it to that date?
From Canton PD?
Yes.
Yes,
Okay.
yes.
So these are all from January 29th, 2022. You just don't remember the specifics of them. It's been too long since you've seen them.
I don't know when each video was collected and then reviewed.
Okay.
Exactly.
With the court's permission.
Why not?
Well, may I have just a moment to confer with counsel?
Okay.
Why don't you know? Was it all at once? Was it in drips and drabs? Was it fed to you by
With the court's
Proctor?
permission, I'd ask
Was it
that,
booked into evidence?
what's been marked as GG, at least the first video, be published for the jurors.
All right, so there are 4 videos on this flash drive?
One video, 4 different camera angles as it's set from the window.
Are you ready to see this now? I thought you wanted to review it.
I'll agree, and if I have a problem, I'll let the court know. I have no problem.
All right, so for the first one, the first camera angle?
Correct.
Okay.
It's one video, but 4 different angles.
All right, we just have to keep a record. That's why I'm
Understood.
asking all these
It's a
questions.
little complicated, I get it.
All right, we can do that.
Thank you.
Hank also being pretty cooperative. This
And
is new
this
video,
is-
guys. Haven't seen
Your
this
Honor, just for the
before.
record, actually, let me do it this way. Sergeant, would you agree that we can call this the rear lot main side at Canton PD, just for identification purposes?
Sure, if you'd like. I'm not I don't know which side this is, so I can't argue with you about the location. So
Okay.
I'll agree with you that we can call it that.
Great. It looks like a parking lot. There's cars.
Yes, sir.
Okay. Just for purposes of, so it doesn't get complicated, we'll call this rear lot main side. That doesn't mean anything unless you adopt it. So just for identification purposes.
Thank you.
If we could move to runtime 1:26:32.
A lot of cars there for supposedly Higgins needing to go move cars.
With course permission, may I play it at this point?
Okay.
Thank you. Stop. Did you see a
Jeep
car
coming
pass
in with
front?
no plow.
Yes, sir.
Okay. What kind of car did that look like to you?
It looked like a 2-door Jeep Wrangler with a plow on it.
Okay. let's
It
go
did
and
have a
play it.
plow? I didn't see a plow. Oh, yeah, it does. Okay.
Okay, stop. Sergeant, did you, during the course of your investigation, learn whether or not anybody associated with your investigation had a 2-door Jeep Wrangler with a plow on it?
Yes,
Who is that?
Mr. Brian Higgins.
Okay, thank you. Let's go ahead and play this.
Remember, Higgins went back to the Canton Police Department so he could move the vehicles that he had parked there so that the parking lot could be plowed. That was his explanation.
Okay, stop. Sir, do you see a person who appears to have alighted from the car?
He
Yes.
stood there and
From the
listened to his
Jeep?
phone.
Sergeant, if you could turn your attention to the screen on the right. Does that appear to be the location of the person that you're describing?
That's the individual that came out of the vehicle, yes.
Okay. I know it's super blurry. You may not be able to at this point. Do you know who that is?
I do not know.
Okay. Let's go ahead and play it. Okay, stop. All right. Did you see the person walk off the screen?
Yes,
Did it appear that that person had something in his or her hands?
possibly yes.
Okay. May I have a moment, Your Honor?
Okay.
Thank you, Your Honor. If we could play the second clip on this same GG. Before this is played, Sergeant, do you recognize what's depicted in this photograph?
I do not know.
Okay. Let's go ahead and play this. Stop. What do you see on the video at this point?
An individual crossing the frame with a couple of cars parked, one of which has a plow on it.
Does it look like an exterior video?
Yes,
Does that appear to be an exterior video if you don't know exactly where, an exterior video of Canton PD?
from the facilities, yes.
Okay. And describe the person that you see in the foreground at the bottom of the screen.
Terrible posture. Terrible posture.
Appears to be wearing a black sweatshirt, a hooded sweatshirt.
Larger in stature, smaller in stature, can you tell?
I'd be speculating because there's no comparison, but possibly larger. I don't know.
Okay, let's go ahead and play it.
A bit rotund.
And that's it for that. Your Honor, if we could play the next video. By the way, can we agree before we move off of this, just for identification purposes, can we agree to call this rear lot cruiser side as opposed to rear lot main side, just to keep them separate?
Same as last time. I'm not aware familiar where that camera is, so I cannot argue with you nor adopt. But if for identification purposes only, we can agree on that.
Can you see from where you are, and I know the answer to this, can you see from where you are the timestamp on the bottom of this?
No.
Your Honor, with the court's permission, it's very, very small. Is it possible to ask the witness to adjourn from the witness stand just to get close enough to see if he can read the...
You can't increase the size of it?
Maybe we can. I'm not the tech guy. Mr. Wolk? Magic. Wow. I didn't even know he could do that. Okay, can you read that?
Yes, it says rear lot cruiser side.
Okay, what about the time?
The timestamp reads 1:27:41.
Do you see a date?
Yes,
What is that date?
1/29/2022.
Thank you. This was my fault. Your Honor, if we could move back to rear lot main side, I'd like to do the same thing. I failed to ask for the time and date on that one.
This was all impeachment from Higgy's first trial testimony. This is all Brady material that should have been turned over.
Is it possible to see from there the time and date?
Yes, the time is 1:27:32 a.m. and the date is 1/29/2022.
Thank you. Okay, if we can move to the third clip. If we could start, Mr. Wolk, by enhancing with the court's permission the time and date, let's just start with that. Do you see what the timestamp designates this camera angle to be?
It appears to be church side. And I can't read the third word there.
Exterior?
Oh, yes, exterior. Sallyport.
Okay, and if you could tell the jurors what you see in terms of the time and date.
The time is 1:27:43 a.m. and the date is 1/29/2022.
Thank you. Mr. Wolk, if you could play that with the court's permission.
Okay.
Stop. Do you see a person in that video?
I do.
Although it's somewhat blurry, can you describe that individual for us, please?
Individual wearing dark clothing, possibly. That's the best I could do, really.
Okay. Does it appear, given what you've seen in terms of the time of the main side, cruiser side, and now this exterior church side, does that appear to be the same person moving through on the outside of Kenton PD?
It does, yes.
Okay. And what are we looking at here, by the way? What is this door he's about to walk into?
I'd be guessing. I was never present on that side of the Sallyport.
Understood.
I don't know.
Let's go ahead and play this.
He's never been there ever.
Okay. And for the final clip.
I can't quite tell if he's wearing the same clothes or not.
If we could go down to the time
He had that
stamp and
skull
date.
hoodie on at the waterfall. Is it the same hoodie?
A little bigger, Mr. Wolk, if you could. Can you see what that is designated as that camera angle?
Yes, it says first floor corridor, and the time is 1:28:03 a.m. on the 29th of January, 2022.
Okay. Is this the corridor version or video that you did have some recollection of?
Yes, this is, yes.
Okay, if we can go ahead and play this. Stop.
It's the same sweatshirt.
Do you recognize the
looks
person in this video?
It appears to be Mr. Brian Higgins.
Okay, and what is he wearing? Describe it for the jurors.
Black sweatshirt with some sort of logo on the front. It appears to be blue jeans and shoes with a white trim.
And is the hood up or down on the sweatshirt?
It's up.
Okay, let's go ahead and play this. May I have just a moment? Could you pause this, Mr. Wolk?
As far as we know right now, all it proves is that Higgins lied about
Can you
his
make
timeline
note
in trial
of the
1.
time as it's paused right here?
Do you want me to say it again or
Yes,
write
sir.
it down?
Yes, sir.
The time is 1:28:16 a.m.
Okay, and if we could just continue playing this video.
See, during trial 1, Higgins says he left 34 Fairview almost immediately after getting there because they didn't have any Jameson. So he had himself coming to Kent Police Department about 12:30.
Stop.
A good hour before.
Now, if you could take a look at the time now. Okay, what's that time?
1:29:42
Okay.
a.m.
And if we could go ahead and go forward. Is it still playing, Mr. Wolk? Okay. If we could take a look at the time one more time.
Now it's, you want me to say it?
Yes, sir.
1:34:12 a.m.
Huh.
And in the time, just so the record's clear, in the time between you saying 1:28:16 to 1:34:12,
Lost about 5 minutes.
6 minutes has not gone by, correct?
Just under 6, I believe, yeah.
Well, 6 minutes for us in real time,
Oh, in real time, yeah, no.
it is not. So it
Sorry.
appears that the camera jumped, or the time jumped.
The time difference from what was displayed is approximately 6 minutes, yes.
Okay, which is much further, much longer than the time we've actually been looking at the video, correct?
That's correct, yes.
Okay, so it appears that it may be motion activated and it just jumped.
That's a possibility, yes.
Okay,
yes.
let's go ahead and continue playing this. And stop. Do you see someone in the screen now?
Yes.
And one more time, I know this is laborious, one more time if we could clock the time. Can you see that?
No, it's really blurry for me.
There we go.
Yes, now I can see it 1:34:15, if I'm not mistaken, a.m.
Okay, fair enough. And let's go ahead and play this all the way through.
It's a Harley Davidson hoodie.
Okay. Who did that appear to be walking away from the camera in this shot?
I'm not certain. I would be suspecting or guessing if I gave you an answer, but I'm not certain who that is.
As best you can determine, does he have the same stature? I know you can't see his face. Same stature, same clothing, jeans, shoes with white stripe around it, dark hooded sweatshirt. That should appear to be the same person as Brian Higgins.
It does appear that way, yes.
Okay. Is that it? Okay. There's one more clip that I'd ask you to look at on this same GG device.
That walk where he's swinging his legs out, that's a weak hip flexor walk. He's swinging them around instead of pulling them forward.
What do you see in this video?
Appears to be the church side Sallyport, and an individual came out of the door.
Okay, and can we highlight the time, please, or increase the size? What time do you see there?
1:34:40 a.m.
Okay, if we go ahead and play this through.
He's on the phone,
Pause.
isn't he?
Does it appear from this video that the person has anything in his hand?
I'm sorry, can you play that again? I wasn't looking at the hand, but
Sure.
I
Good
really
pause.
can't tell.
Okay.
I can't tell.
There should be another video of the rear lock cruiser side. Let's take a look at that. Pause. What do you see in that video?
It appears to
Phone
be an
lit up by his
individual
ear.
wearing a black beanie hat, black dark colored sweatshirt with some design on it, and something illuminating by his face.
Can we enhance the time, please? What time is that?
It says 1:34 and 53 seconds in the morning, a.m.
And if you could move the screen over to the individual. Mr. Walt. Does that appear to be
Yeah.
the same person?
It could possibly be, yeah.
And does it appear as something in his hands up to his face, the right side of his face or ear?
Yes.
What do you think that is?
It's consistent with a cellular device, possibly a phone or a tablet.
Okay. If we can move on, please. Play that through. And I believe there's one more video. And Your Honor, this one is a little longer. This is about 10 minutes.
Okay.
With the court's permission, I'd like to play this through. Okay, stop. Do you see a person in the video walking from screen right to screen left?
Yes.
Did that person appear to have something in his right hand?
I can't tell. I can't see his right hand.
Okay. When he first walked into the screen, could you tell?
I couldn't know. I'm sorry.
Mr. Walt, could we back that up with the court's permission about 2 seconds? Okay. Stop. Did it appear as something in his hand?
It's a possibility, yes.
Okay. And just for, I'm going to ask you for 2 times when we start and when we stop. What's the time on this video at this point when he walks into frame?
1:35 and 8 seconds in the morning, a.m.
Okay. And let's go ahead and play this through.
We're going to watch him sit there on the phone and then drive away. And that's going to completely contradict his testimony from the first trial about how long he was there, what he was doing, etc. That's going to be my guess. I can't believe they caught him with the screen all lit up. No denying that is a on telephone being held up to his face. That is indeed exactly what he said. His reason for going back to the Canton Police Department around 12:30, according to him, was because he had ATF vehicles, work vehicles that were parked in the parking lot, and he needed to go move them so that they would be able to plow the parking lot. And that's why he went back to CPD. So I'm kind of guessing this video is going to show none of that happening and him just being there for what, 6, 7, 8 minutes, talking on the phone, and then leaving in his Jeep. But we'll have to wait patiently to see. So he went around the passenger side of the Jeep towards the back of the Jeep, and we have not seen him since then. He hasn't come into view. So he didn't come around the back side of the Jeep towards the driver's side. We haven't seen him over to the left of the video. Far as we can tell, he's still back there behind the passenger kind of rear corner of the Jeep. I'll have to see if he comes back out. He moved a car behind the Jeep.
Pause it, please.
There he is coming back. Okay, so he went around the far side.
You see a person walking into the frame into the video from frame left to frame right?
Yes.
Okay, go ahead.
Did we see what car got moved? Now he's getting into this truck over there.
Can you pause it? Did you see something happen with the vehicle next to the Jeep in the last few seconds?
Yes.
What was that?
It appears as though the headlights are activated.
Okay, let's go and play it. Okay, pause it. Do you see a person that is walking from screen right to screen left in the middle of the screen?
Yes, he just or she just appears to have closed the door on that vehicle next to the plow.
Okay. And walking toward which vehicle?
The one on the furthest on the left.
Okay. From what you've seen, Sergeant, that you said he or she, does that person appear to be consistent with the video that we've seen of in other particulars of Brian Higgins?
As far as I could tell from here, the individual accessed Brian Higgins' vehicle, so I'd be speculating with the whiteout conditions or near whiteout conditions. It's tough to tell.
But no reason
This
to
is
believe it's
near
anybody other
whiteout.
than Brian Higgins walking.
See all the way to the
Brian
back of the
Higgins.
lot.
No.
Okay.
No.
Let's go ahead and play it. And what do you see Brian Higgins or that person doing now?
They accessed the vehicle on the far left.
Okay. And where's that person going?
Now they're accessing the Jeep Wrangler.
Oh, is he putting something in it? What on earth is he doing? This is very confusing. Is he cleaning off the windows? Sitting there in the blizzard with the Jeep door open.
Can you pause it? Where does that individual appear to be now in the video?
Last I could tell, they might be by the Jeep Wrangler.
Before that person got to the Jeep Wrangler, was he standing by the vehicle on the far left, SUV or truck?
It appeared that way, but with the heavy whiteout snow that night, I can't tell exactly what they were doing.
Did you see anything in his hand, like a bag or a satchel or a duffel bag or something when that person walked from this vehicle over to the Jeep?
I did not notice, no.
Go ahead.
One thing he is definitely not doing is moving a bunch of cars.
Now, has that person walked off screen to the left?
Yes, sir.
Okay.
That looks like a pickup with a cab cover on the back. A canopy. Can't tell what I know.
Entering screen from screen left.
Yes.
Now the Jeep lights are on.
What did you just see the person do?
They were carrying possibly like a snow broom, walking from left to right.
And what do you see happening now?
The Jeep Wrangler is leaving the spot it was parked in.
Okay.
It's about
Okay, we can
1:45.
set that down.
Pull up the timestamp, Alan. It's like 1:45:52.
Oh, I'm sorry.
What I saw.
I failed to ask you the time. I promised I would do it, and I forgot again. Can we look at the time real quick?
Yes, the time for the rear lot main side is 1:45:52.
And it appears that's the approximate time that the Jeep Wrangler drove off.
Approximately, yes.
Okay. Thank you. In are you friends with Brian Higgins?
I am not.
Do you know Brian Higgins?
I know who he is, yes.
Have you ever socialized with Brian Higgins?
Like out on private time?
Go out, have a beer.
No.
See him at a bar. Hey, Brian, let's grab a beer. Nothing like that?
No.
How long have you known Mr. Higgins?
I'd be speculating. It's before this case, he was a law enforcement individual that worked in the area. So I've had cases where he assisted on and that I've assisted on.
Would you consider yourself to have a professional relationship with him?
I knew who he was, so yes, I would consider a professional relationship.
But you would not consider your relationship to have gone over to the personal relationship? You don't
Not at all.
socialize, do any private get-togethers?
No.
Okay.
Funeral?
You would agree that this video pretty clearly shows, at least at one point, around 1:34 a.m., Brian Higgins was on his phone.
Is that the one that he has the device by his face?
Correct.
It appears that way, yes.
And just to be clear, when you interviewed Mr. Higgins, he did not volunteer to give you his phone, correct?
He did not volunteer, no.
And you didn't seek his phone through a warrant or any other mechanism?
I did not know.
Do you have any personal knowledge as to the status of that phone as we sit here today?
The one that he got the extractions from?
Correct.
No idea, no.
I want to shift gears to another series of videos. Last year at another proceeding, you were asked about a couple of videos from the interior Sallyport garage at Kenton PD. So now we're going to move to the interior. You remember those series of questions and answers that you gave?
Generally.
Okay. You were asked at another proceeding to describe when the SUV, Ms. Reed's SUV, first arrived at the Sallyport garage around 5:30 or so, correct?
Based on my recollection of it first arriving or what we were viewing?
What you were viewing.
I'm objecting to this.
Ask it differently, Mr. Jackson.
Do you remember being asked a series of questions concerning
What
the
video
arrival
showed?
of the SUV, just in general?
I remember that it happened. I don't remember the exact questions, what my answers were.
And you remember seeing a video about which you were asked questions concerning the arrival of that SUV, pulling into the Sallyport, who was who, what the time frame was generally. Do you remember that colloquy, that discussion?
I remember it taking place, yes.
That was Mr. Lally asking you questions, correct?
I believe so.
Under questioning by the Commonwealth, you were asked whether the video that you were looking at fairly and accurately represented the SUV arriving at the Sallyport garage, correct?
Yes.
And you indicated, in fact, it did fairly and accurately depict the arrival of the SUV at the Sallyport garage. Is that right?
That's correct.
And you described where people were in location to it?
I'd like to ask you a question about that particular video. Do you have anything?
Yes, he does. But it was fair and accurate. It was just inverted.
Your Honor, I'm holding a flash drive. May I approach?
Yes.
I'm going to have this phone, Your Honor.
The setup on this is very important, so I'm glad to see he's taking some care with it.
May I have a moment to consult
This
the
has
process?
got to land well. So establishing the foundation with the video. This is the video that we're talking about, that the jury was shown, and then walk through what he said was on this video.
Jerry, you know what? Let's take the luncheon break.
Thank you.
Oh, we're going to go to lunch a half hour early instead. Looks like we're going to go to lunch a half hour early. What's up, NBC 10? Did they just... I don't think they killed their stream, but lost the signal perhaps. Okay, we're back. Just making sure we don't have to hunt down another channel to see if there's going to be a chit chat in court before we have lunch.
Do is have the voir dire right now.
Oh, we are going to have the voir dire.
Knew regarding that line of testimony you wanted to get into. So let's do that now, and then you can all work out the video issues.
Deep sigh there.
Yes. Okay. May I inquire briefly?
Yes.
Thank you. Sergeant, we were talking before the jury left, we were talking a little bit about the conversation that you had with Michael Proctor, either during or just before or just after that first interview with Chris and Julie Albert. What I'd like to ask you is, what information did you have and what did you ultimately learn about their relationship? You said there were some accusations and we never really got to the heart of it. What did you know and what did you do to investigate? What did you learn?
What I knew as we were walking up to the door is that he had knowledge of the individuals prior to us conducting the interview. I asked him if he knew them personally. My words, do you hang out with them? Do you socialize with them? He said, no, I do not. I said, are you comfortable doing this interview? And he said, yes. And me being a complete outsider and his supervisor and realizing if there was any impropriety that I would step in and recognize it, report it, and act on that. The interview was conducted without issue, and we moved on.
As a matter of fact, one of the things in Trooper Proctor's report, it said, the report started with following formal introductions. Did that suggest to you that Trooper Proctor had no knowledge of who Chris or Julie Albert were from a personal standpoint?
Not at all. I believe maybe I wrote the report, or was it him?
I think it is you. I think it is you.
Yeah. So
Yes.
Just you.
Indeed was
Thank you.
his report.
Yeah. Since I authored the report, I wrote following formal introduction since I've never met them before.
Okay, so that was more attended to you than to Michael Proctor.
Correct.
Okay, but the report does say we introduced ourselves, basically. Following formal introductions.
Greeted, but I had formal introductions to them. I've never met them before in my life.
You said that subsequently you learned about, your word, accusations that had been made concerning possible relationship between Michael Proctor and the Alberts. What was that information that you learned?
When was it? I need that.
When did you learn it? I thought you said 2023.
You already said
but
July
I could be wrong.
2023.
When did you learn that?
It was during the July motion proceedings when you guys had pictures up of children.
July of what year?
I believe 2023.
Okay. And what was it that you
guys
learned in July of 2023 about
children.
the potential?
The accusations?
Yeah.
That those were Albert's or McCabe's kids in the photograph with Michael Proctor.
Okay. Did you ever learn about personal communications that Michael Proctor or his wife may have had with any of the Albert family, including Julie Albert?
Ever?
Ever?
Yes.
Okay. Tell me when you learned that and what you learned in that order.
Well, Michael Proctor had communicated with those individuals. Elizabeth Proctor communicated with those individuals due to the harassment that they've sustained.
Okay.
So with the crazy behavior that's been, imposed on them, and the torturous harassment that they've endured, the traumatic experiences they've had to live through, they've communicated. So I've learned about that, yes. I was taking in all of that evidence, hundreds and pieces of evidence that I've archived in order to...
Go ahead. In order to...
investigate it.
Okay. You're talking about Elizabeth Proctor well after the fact of the interview and the incident in 2022. That's what you were just describing.
It was after the harassment started, yes.
Which is well after January 29, 2022, correct?
January 20, yes, it is.
Okay. I'm asking about information related to a relationship prior to January 29, 2022. Did you ever learn about a pre-existing relationship that may have existed between the Proctor family and the Albert family before January 29, 2022, and maybe a couple of days after?
All I know is that there was a relationship explanation provided by Mr. Lally during one of the motions, and it was like 6 degrees separated by individuals residing in the community, living in the community, raising their kids in the community, working in the community, so making them community members and having relationship within that. I don't know the extent of those relationships.
Okay. Did you, during that hearing where you said there were pictures of the kids and et cetera, that July 2023 hearing, did you see a post, a Facebook post during the course of that hearing wherein the Albert family called the Proctor family their second family, or vice versa, where the Proctor family, Michael Proctor's mother, they called the Alberts their second family? You remember that Facebook post?
I don't remember seeing that post. I just remember there was like a picture of kids that weren't Michael Proctor's kids.
Okay, but you were in court that day.
I was in court in July. I believe it was 23rd of July, for the motion, yeah.
Leaving aside the photographs that you've talked about, did you see the post, the Facebook post about those two families, specifically Michael Proctor's mom, saying that the Alberts were their, quote, second family?
I don't remember seeing that post.
That didn't strike you, or that was not in your brain, in your head?
I don't think I've ever seen a post like that, so I just remember seeing the post of the kids.
What
I believe
about,
it was Miss Little that was holding up the poster.
What about the text messages, or what about any text messages between Michael Proctor and his sister concerning Julie Albert, very specifically concerning Julie Albert? Are you aware of those?
No.
Have you ever seen a text message between between Courtney Proctor and, Courtney Proctor and Michael Proctor, where the sister says, Julie wants to give you a gift because you're doing such a great job leading this, meaning this investigation? Have you heard that?
No.
Are you aware of a text message in which Michael Proctor responds, get it for my wife? Meaning, if you're going to give us a gift, get the gift for my wife.
No idea.
Okay. Are you aware of a series of text messages between and among Michael Proctor and Elizabeth Proctor in which they talk about, between Michael Proctor and Courtney Proctor, in which they talk about Julie Albert? This is 10 days before the incident, 10 days before January 29th, so mid-January, where they talk about the possibility of Julie Albert babysitting for Michael Proctor and Elizabeth Proctor's kids.
I am not aware of those text
This is
messages.
the first you've heard of any of those.
Of these text messages?
The text messages
Yeah.
that I'm describing, have you ever heard of any of those?
No.
Okay. Did you ever talk to or investigate the circumstance of the possibility, even the remote possibility, that Michael Proctor may have had a relationship with the Alberts that you were unaware of?
No, I never investigated anything like that.
So after your initial conversation with Mr. Proctor, where he said, I know of these people, and you said, is there any issue with you going forward? And he said, no, there's no issue. You took no further steps after that to investigate that relationship. And I'm talking about the relationship that existed on or around January 29th, 2022, not in 2023, not in 2024.
Once Michael Proctor stated that he was comfortable conducting the interview, and
Took it on faith.
I
Didn't
asked him if he was
corroborate.
sure, and he said yes. We moved on.
Yeah, just a moment, Your Honor.
Yes.
Didn't corroborate, just took his word for it. Good catch. Yes, remarkably articulate.
Two questions. Were you in court? I know you're indicating that you've never heard about these text messages. Were you in court in February of 2024 following the federal investigation revelation, the documents that we got from the both sides got from the federal investigation, which revealed and was revealed in open court the text messages about gift giving between Courtney Proctor and Michael Proctor? Hey, Judy wants to get you a gift, and Michael Proctor's response was, "Get it for Elizabeth, get it for my wife." Were you in court when those were revealed?
Following the harassment, intimidation that I experienced on the 23rd, being followed to the bathroom, then being followed outside, I stopped coming to court proceedings due to that. So I was not in court in February of 2024 and describing the information that you're revealing. I was not aware of that detail.
But all of these proceedings are televised. Sorry, you know that, right?
I'm not aware that it's televised now.
You're not aware?
I know it streams, but I'm not aware that it's televised.
Okay, streamed. However, whatever you want to call it. Streamed on the internet. You can find it.
You can, yes.
They're recorded.
Right.
Did you ever review the hearing in February 2024 talking about what's been referred to as the Fed dump and the revelations that were made pursuant to that federal investigation and the text messages attendant thereto?
I am aware of a Fed dump. I'm aware that it exists. I was not privileged to any information outside of the information that was revealed to me during the internal affairs investigation.
Right.
That was the first time I saw documents from that federal investigation.
By the way, were you privy to, Michael, there were three individuals involved in the investigation, yourself, Lieutenant Tully, and Michael Proctor, is that right?
In what
The
investigation?
internal affairs investigation.
I'm aware that I was. I know they were as well. I don't know who else might have been involved. I don't know.
In terms of your awareness of Michael Proctor's investigation, you're aware, obviously, that he was terminated, correct?
I am aware that he's terminated, yes.
Did you ever see or were privy to any of the documents or investigative materials associated with his termination as his supervisor?
No.
So nothing was ever shared with you, the final decision?
Other than the documents that he was attached in the text message that I was shown from that investigation, nobody showed me anything of his investigation.
Okay, so let's wrap this up.
Okay, that was basically all I had.
Okay, all right. Do you want to be heard, Mr. Jackson?
No.
Okay.
On that.
Yeah, I'm not letting any of this in.
I think it's all admissible, but I understand the court's ruling was if he doesn't have personal knowledge of it, didn't have it then you're not going to let it in. So our objection, but that's been noted.
Okay, so you got your idea, and I'm glad we fleshed it all out. So you have to be back here
Okay.
in 35 minutes. All right. When's the jury coming back, Paul?
Move to 20.
All right. Be back here at 25.
25 minutes. Good
All
Lord.
rise to the court, please.
This is Judge Goal-like with this scheduling. They're supposed to eat. They're supposed to, do all the stuff she expects them to do mid-trial as far as checking in the office and following up and doing research and yada, yada. 25 minutes. Oh, that will make it 20 after. We'll end. Guys, I'm going to take just a couple of your comments before I step aside. But he's not the right witness. That was her basis that she explained before as far as why they're not going to allow it in, because he's not the one that has knowledge of this. He didn't find out about it. He's saying he didn't find out about it. He's never seen the text message between Michael and Courtney Proctor about Julie offering a gift. Michael Proctor saying, give it to my wife, give it to Elizabeth, not to me, give it to my wife. Got to launder it very carefully. So this is legit. If he doesn't know about it, it didn't affect anything he did in the course of his investigation. They will be able to get into, should he have known about it, but they have to get it into evidence first. And so this to me is again, just indicating pretty clearly we're going to get Michael Proctor called by the defense. That's the pathway to get that text message in. It's going to get in. It's far too incriminating for them to just, leave that to the side and not make sure the jury knows about that. I'm still a little baffled by what we just watched on that video from Canton Police Department. This video of Brian Higgins, other than just, we watched his testimony from trial 1 be blown apart, both because the timeline is wrong, the length of time that he was there at Canton Police Department, what he was doing while he was there at Canton Police Department. None of this is adding up. Does it look like he's moving stuff in between cars? I mean, I just see doors opening, lights on. Very strange behavior. But overall, he's only there. He arrives at 1:27:32, and then that very last clip shows him driving away at 1:45. He's there for just over 15 minutes, not quite 20 minutes. Said he was moving cars so that they could plow the parking lot. Didn't see that. Very, very strange. So all I know is just because this contradicts Brian Higgins' trial testimony, it's impeachment evidence. Should have been produced well before the first trial, certainly after Higgins testified. That's what Brady requires. It didn't happen. This shows up, sometime in the interim between the two trials. Messy, messy, messy. Real quickly, guys, just a couple comments and questions, and I'm going to have to step out, check on the things around the house, and then I will be back. Psychometrics, Hank's strategy, insult the jury's intelligence. Well, that would be on par with how these law enforcement witnesses have testified, isn't it? They think we're stupid. They think we're stupid, that we don't have eyes or opinions of our own to be able to interpret what we see and the significance of it. They expect to come in and tell us what the truth is, and we will simply swallow it unquestioningly. That is the expectation. Sarah Griffith, I would so love to send some love to Karen Reed's parents. Do they have a Twitter or a way to show how much I admire their dedication for showing up every day? I don't believe that the Reeds are on Twitter. I don't know if they're on Facebook. I honestly don't know. If they're watching here, Sarah Griffith really appreciates your dedication and showing up every day. This is what a supportive family looks like, right? Really is. There every day. One of my thumbnails, I use the photo of Karen and her dad hugging. This is a close family. They have stood by her like a rock. Not easy for all of them going through this as well. So that often gets overlooked a lot of the times. Hypothetically, even if Karen Reed were guilty, which I don't think we've seen proof of, but hypothetically, even if she were, the family suffers. The family of the defendant suffers, but they don't get any sympathy for that. They don't get any recognition of the fact that their lives have been affected, the stress that they've gone through. A situation, if the person is guilty, sometimes is extremely traumatic. Having to accept that this is who their child is, their relative, their loved one, not who they thought, capable of committing crimes. The family of the defendant is very often an unrecognized victim, and they don't get any sympathy for their situation. So Kiwi Cal number 18, can you please link Special Sauce's Z account in the chat, her X account? Let me just pull that up for you. Dee Dee is at Suspicious Sauce. Suspicious Sauce. There's no second S, which might be why it's a little bit hard to find, but I have just posted it. So hopefully you can go find her. Great source for the legal documents. Gets them very quickly, screenshots them, and puts them up for everybody to be able to read. Lawyer nurse, so sick of him leaning on the box like it's a bar, drunk, and he's waiting on beer whilst turned perusing the girls in the bar. He is such a sleazebag. That arm that he's always got resting over there on the bar. It looks to me like, like he's on somebody's couch. He's there for the Super Bowl party. And you just lounge on the couch, with your arm up. You got your beer in one hand, your pretzels or whatever, right there within reach. It does look quite casual. Quite casual for courtroom presentation. Karen Duffy, could Brennan coach Bukhenik over the weekend? They are not supposed to have any contact with the witnesses between the time that the witness gets on the witness stand and gets off the witness stand. He's not supposed to tell, even after the testimony is over, he's not supposed to inform Trooper Bukhenik about any of the other testimony or other evidence that's been presented in the case. But this, they very specifically got an order on before trial. You do not get to discuss the witness's testimony with the witness while he's still on the stand, because that had come up with, I believe, Brian Higgins, possibly Brian Albert. Now, I don't remember the specific detail, but it came out that while the witness was testifying and there was a break, I think it was the lunch break, they had conversed about the testimony that was ongoing. That was Mr. Lally. So defense got a specific order clarifying you're not allowed to do that. So no, absolutely not allowed. That would be contempt of court if that had happened. CantonCrossCoordinates.com, never wrestle with pigs. You both get dirty and the pig likes it. The issue with being argumentative, sometimes it helps you make a point to the jury. Sometimes the jury might be feeling it with you, so you might choose strategically to do it anyway. But you just better hope it's landing the way that you want, because it is costing you something. It's costing you in terms of the judge is going to sustain the objections. She's not going to be helpful with that type of thing. And there is a cost that, the jury isn't seeing it that way. You've ceded the high ground and the reasonable position. When you're reasonable and he's fighting, that contrast is very clear. But if you start to get dirty, then the jury can kind of start to sympathize with, well, I understand why he wouldn't want to use that word, that kind of thing. So it's strategic and it's a matter of style, but Jesus Freak at Good Logic had a great green grass timeline. Oh, Joe Neerman over there at Good Logic, excellent lawyer, great commentator. Really enjoy his coverage. So I'm no doubt at all he's got some great insights into this case. Definitely go check out at Good Logic. He's a very good friend of the channel. We like Joe. Guys, I'm going to go ahead and take my pause right now. Gotta go and do the runaround and checks, and she's only giving me another 18 minutes. So we'll see. We'll see if they get started on time, but do need to do my rounds, check the trees, you know the whole routine. So I will be back shortly. Thank you so much for hanging tight. All right, guys. Had some very thirsty trees this afternoon, but looks like we have a couple minutes. I just wanted to share with you real quickly before we get back. Somebody over lunch found this screenshot from that testimony where we were watching the video. This is the screenshot that is the closest thing we can identify to Brian Higgins moving a car. Now, we didn't see him go over and do it. Possible this is just somebody else leaving at the same time. But don't know. This is as close as we get to moving a car. It's not letting me zoom in on it any closer. Well, let me see. Let me just see if I can get us a little bit of a better view here. We see that any closer? Can we tell what kind of vehicle that is? It's awfully hard to see. When I first saw this image come up, I'm looking at the back end. It looks like it might be a smaller SUV, sort of like a Ford Edge, but it also kind of looks like, honestly, guys, it almost looks like an old muscle car to me. You know, an old Plymouth or an old, even the old Mustangs had that that kind of racer back like that. That's what it reminded me of initially, but not real certain. Not real certain that that's what we're looking at. But anyway, I did want to share that with you guys because that looks like the vehicle that got moved. If he did, in fact, move any vehicles while we were there, that's the one. So any of you guys car people with a good eye for the back end of a car, shape of a car, might be able to give us a hint of what we're looking at there. I see a few different possibilities. Possible like an old muscle car is what it looked like to me, but possible it's a small SUV. I don't know. It's very very bad. Yeah, Dodge Charger I see coming up. Yeah, exactly. You guys are thinking kind of along the lines as I am. So not sure what we are to make of that. Do we know of anybody in any of this that has an old classic muscle car? That kind of back on it? Curiouser and curiouser. Robert DeVola noticing he seems more professional this morning. Interesting. Very significant change in attitude and demeanor, isn't it? Already another half day done with Trooper Bukhenik. And we're only just now getting into the Sallyport. They're going to have to work out some of those logistics of how to do it over lunch, but it's going to happen, guys. He is definitely going to be asked about this. But perhaps a little bug in his ear. Do we think he developed the insight himself independently to recognize that his combativeness and evasiveness, his denial, was not really working for him? Do we think he had the insight to recognize that himself, or did somebody maybe put a little bug in his ear over the weekend? Perhaps you should shift your approach, because he definitely has shifted his approach. Jesus freak, that wound is punctures and lacerations. That's what it looks like. These don't look like abrasions to me. Abrasion is a blunt type of injury. A laceration is a sharp type of injury. A puncture is also a sharp type of injury. That's what it looks like to me. I remember the medical examiner last year testified that they appeared to be abrasions. I think even Dr. Russell might have characterized them as abrasions. So I'm not sure how that's going to come out this time. But her explanation was because a tooth mark is blunt. You know, a tooth is blunt. It's not a sharp instrument that is slicing the skin. It's more of a tear that it creates. That's my recollection. But, the wound kind of speaks for itself in a lot of ways, doesn't it? Jesus freak, dog attack, not vehicle. Certainly doesn't look like any car accident injury I've ever seen. Have a hard time imagining state troopers who respond to car accidents all the time, maybe every day, routinely. Curious how many other incidents they've responded to, motor vehicle accidents, where they've seen injuries of this nature. The patterned abrasions. I do like how they describe that. It's very descriptive. Patterned is the key. Dan Greenwood, how much have the jury checked out on this guy? Can they ever interject and just be like, listen, can we stop this? We know he's full of shit. They can't. No, their job is to sit there and receive what is given to them, both in terms of the law and in terms of the evidence. Now, is it possible for them to communicate we're done one way or another? Yeah, through their body language, you know. Start staring at the ceiling, start twiddling your thumbs, start doing a little tic-tac-toe. Maybe tic-tac-toe on your paper isn't a good idea. It might make it look like you're very attentive taking notes or something like that. But no, they can't, other than just through nonverbal communication. If they get bored, perhaps that will show. Pro gamer Yuppie, prepare to cringe. Well, it's not necessarily a great morning for this witness. Don't think he was expecting such an aggressive cross. I don't think he was expecting the target to really be on his back. From a strategic standpoint, I think that's a smart move. Smart move by the defense. They caught him off guard. And so he didn't realize potentially that his attitude was going to be so significant, because he didn't realize the whole investigation is going to be pinned on him. If Proctor's still going to come in and there's kind of fallback positions, then you not knowing anything and not remembering anything and arguing about everything, maybe isn't so bad, because it's not like you're the lead or anything, but they've managed to put that hat on him and just not leaving a very good impression, I don't think. Sentient Dreamer having massive levels of schadenfreude already. Well, it couldn't happen to a nicer person, could it? We love this for Yuri. Roy Handy, Bukhenik lost 5 days of leave. He should be fired. I mean, most of these guys. Fanning? Why is Fanning? Haven't hardly heard his name at all in all of this. It's funny, the names that have disappeared so far in this trial. The one that really stands out to me that's disappeared the most, Brian Albert. I feel like we've hardly heard anything about Brian Albert. But Lieutenant Fanning is another one. The supervisor of all these guys. He's just kind of vanished in all of this. Wasn't he also sanctioned? Got some type of discipline as a result of that text chain? More failure to supervise? Boy, failure to supervise at all levels kind of suggests there might be a problem with culture in this agency, doesn't it? Maggie Beth, remember to acknowledge this stream. Good one, Maggie. Thank you for that. Yes, please acknowledge it. You don't have to have a feeling one way or the other, or even be paying attention to what it is that's going on here. Just go ahead and acknowledge it. Willow's Angel, it's my opinion that disgraced ex-Trooper Proctor planted all the snow in the yard. Good morning. That might be too competent for what we've seen from Proctor, honestly. It might be too competent. If there was snow planted, snow planted after February the 4th might be necessary for this whole explanation of the taillight pieces revealing themselves. Might be necessary for that timeline to work. Have to plant a little snow in the yard. Abdominal thrust. God, you guys are so fast with these names. Abdominal thrust just came out on Friday. Here you are. An Apple Watch notification allows 150 characters. The message Trooper B acknowledged is 51. You cannot like or thumbs up a notification without viewing the content. Thank you for this insight. I know nothing about Apple phones, never had one. Wouldn't know how the notification shows up or whether that is a credible explanation or not. With 18 people on the jury, I have to imagine that many of them have iPhones. They're going to know this too. it doesn't have credibility. Respond to acknowledge that you received it, but you didn't read it. Then why would you acknowledge it? Why would you don't need to acknowledge like the fact that it's sent. It's a group chat. It's not even to you. So even just from a common sense kind of standpoint, I don't think this explanation is particularly credible. But especially if there are folks on the jury who know this is what notifications look like, yeah, it does perhaps seem a little bit harder to sell that. Jason McClellan, Trooper Proctor has a constitutional right to call a suspect retarded, shows corruption, bias, and contempt for Reed. Bruising is inconsistent with the Commonwealth's case. I cannot believe he tried to hide behind the First Amendment on that. The trooper has a First Amendment right to talk this way about a suspect. Didn't age so well, he had to back off from that within just a couple of moments. That's how you're going to defend this? Oh no. Oh no, he had to walk that back immediately. We're not excusing it. Well, if he had a First Amendment right to do it, you seem to be saying it's fine that he did. It was okay that he did. He had a right to do it. Yikes. Yikes. The bruising on the shoulder does not seem to be super consistent with the Commonwealth's theory, does it? I don't know if it's lividity. I don't know if it's, an injury that he sustained. It looked a bit mottled. It didn't look like if you had, for example, a car hit you in the shoulder. I mean, number one, a car hits you in the shoulder. Sorry, your shoulder is fucked. Your shoulder is broken. Your shoulder is dislocated. I mean, something with that kind of force. But it didn't look like a big solid bruise like you might expect from a big hit like that, right? A big hit like that, it's gonna, hit your shoulder. It's gonna cause a large bruise on it. It didn't look like that. It looked like mottled kind of bruising at best, and so possibly lividity, possibly something like, I don't know, finger marks or something. I don't know. But we don't have an explanation for it in the Commonwealth's case. So I'm interested to see. That's the defense planting a seed. I'm interested to see how that is going to sprout. Probably something from the defense's forensic pathologist, their expert that they intend to call in their case, which we may start to hear this week, guys. We might be getting to the defense case this week, although if we spend another whole day with Yuri, might take a little bit longer, but we'll see. Oliver Olson, this is why after achieving the degree, I didn't become a police officer. I realized this is normal and couldn't stand to work with this behavior. Well, good for you for saying that and recognizing it. I don't want to impugn every police department everywhere in the country. I've definitely seen some that seem far more functional than others. And my experience, again, I think because I've spent a lot of time in rural communities, and I've seen a lot of those types of agencies where the police are more integrated in their community as a whole. There's less of an us and them divide between the policers and the policed. To me, I think it's that divide that contributes to a lot of these cultural problems. When you have cops that only socialize with other cops, only hang out, that's who they know. You just really entrench this us versus them and the who's on whose team. But when you live in a community where the cop goes to your church or runs your kids, after school sports program, things like that, you don't have nearly as much of that divide. And so I think you just tend to have less of this thin blue line type of mentality. So I don't want to impugn every department out there, but I think it's just hard to deny that this exists as the culture in a lot of places. And part of it may be the paramilitary organization as well. You know, if you're in the military, you're deployed, you're out in the trenches, you have their backs no matter what. If they mess up, it doesn't matter. Your priority is getting all of your guys back safe. And so that kind of mentality can trickle in as well, I think. You got to have your guys' backs no matter what, because you're the good guys. You're the good guys. So got to keep the good guys safe. It's unfortunate because I think this type of thing does discourage good people, honorable people, ethical people from wanting to be a part of it. And that's a vicious cycle then when it comes to the quality of the police department. Fighting Usyk, shoulder marks equals fingers dragging John O'Keefe. Oh, you saw fingers, maybe fingers too. It did look modeled, didn't it? It did look modeled. It didn't necessarily look like lividity, but I don't know. I don't know. Fingers from dragging, maybe fingers from grappling during some kind of a fight. Can't wait to hear what the defense is going to tell us about that. Linda LW gave us a super sticker. Thank you for that, Linda. Appreciate that. Jason McClellan, this case makes The Departed look like a documentary. I forgot about The Departed. Was that in this area? Was that in Boston? No, I can't remember. Can't remember where that was set. Yeah, I don't remember offhand. You know, at this point, the stories of police corruption, there's just so many. Yeah, everybody has heard one. Everybody's heard one. It's I mean, go back to The Godfather, and they had the police on the payroll. You know, back in the 1970s, this was no secret. It wasn't a hard thing to sell. Police corruption has existed as long as police have. Crime Finder, how is Karen Reed funding her defense? We don't know. We don't know. That's not public information. There's certainly been a number of fundraisers for the Karen Reed Defense Fund. We've also heard that these attorneys are working pro bono at this point in time. They're not getting paid, so expenses are dealing with expert costs, flights, hotels, food, that type of thing. But much of that is speculation. We don't necessarily have, verified public information about it. Master of None, really curious how the missing socks in evidence have not been brought up. They were on John's body, but not collected. Yeah, curious, isn't it? I went back to check. My my normal research resource here, which is of course Sleuthy Goosey, and her spreadsheet. Fabulous. She's got the a tab for all the trial exhibits from the first trial, and I went through there looking for socks. Anything having to do with socks? Didn't see anything about socks. And so we did see those socks on his feet. What happened to them? I don't know. We never heard. Curious. I do wonder if that will come up. What type of evidence might you look for on a person's socks? Don't know. 5 a.m. research. Our dog pulls socks from our feet. Just saying. My dog has never done that, but dogs do love to play, don't they? They will play with anything. Violet energy to truth in every aspect of life. Time to look within first. It's important to kind of self-authenticate. If you yourself are a dishonest person, then you probably are going to be more suspicious, maybe more likely to see dishonesty in others, that type of thing. Look within first for honesty, I think is generally a good rule. Melissa Garcia, trial by ambush from Hank. No surprise here, gross. This is the Aruba. Now we're going to go back. Now we're going to go back and want Aruba again after we said we're not going to, and we're not going to litigate it. Don't know if we're going to hear that motion today. Not clear to me that we need to from just a timing standpoint, but I can't imagine Bev is going to be pleased with that. A very hard time believing that. TCP, Bukhenik's face when he found out he had to read the messages is golden. Almost not quite deer in the headlights, but just more of a, ugh, did I really just step into that? Yep, indeed you did. Indeed you did. All you had to do was not be unreasonable about what was in those texts. But you wouldn't give an inch, so we had to go through it. Sabrina Heels, Yuri is on the Brady list for his conduct on this case as of May 9th, 2025. Can AJ bring this to the jury? Tolley, Proctor, and Berkowitz are also on it. So this comes up sometimes because what is the Brady list that we're talking about? If this is just a website that purports to maintain Brady lists of different officers, the answer is no. It's hearsay, it's opinion. It's often based on, like, I've seen sources out there that purport to maintain Brady lists for different departments. It's often based on just allegation, interpretation of disputed events. If it is from the department's own internal Brady list, if the Norfolk County District Attorney's Office or the Massachusetts State Police maintain a Brady list, then yes, I would expect it could. That would go to impeachment. It would go to dishonesty. But if it's just an outside source that's reporting, their opinion based on the prior trial, then no, you can't bring that in. That would be hearsay. It would be opinion. But what they'll do is they'll simply go through the same facts and circumstances that an outside agency would be looking at to say, this looks dishonest, this should get somebody on a Brady list. So I think that's essentially what the defense is doing here. Rather than telling the jury, hey, these guys are dishonest, they're showing them. And that tends to be a better strategy anyway. Show, don't tell. Josh H., did Higgins change his hoodie at the bar? He had on a USMC hoodie. Well, as it so happens, somebody took a look at that. Let me go ahead and see if I can pull that up. There's two images here for us to look at. Okay, let me go ahead and share that with you guys. This is Higgins at the Canton Police Department. And kind of zoom that in, see a little bit of that outline. Looks like a skull. Looks like the skull on the front. Then we have the one that he was wearing at the waterfall. Guys, it looks pretty similar to me. I mean, same type of thing. Looks like a skull. Looks like a skull on the front of the hoodie. Go back and look at that one again. Compare those back and forth. To me, it looks similar. What do you guys think? You can see that kind of pattern. If you look at we're looking at it, the eyeball from our perspective to the right, looker's right, skier's left, looker's right. It's got that vertical piece on it that kind of goes straight down. You can see that pretty clearly on both of those images. So to me, it looks like it's the same hoodie. What do you guys think? What do you guys think? We're still waiting on the fan there, so looks to me like it's the same. Marcelo, congrats on being summoned. What are your thoughts on bench trials in general? Have you ever litigated one? Many people think that if Bev wasn't the judge, bench trial would be a good choice for Karen. Well, thank you for congratulations. I'm very excited. So in the defense community, we have a word for bench trials. We call them a slow guilty plea. There is rarely a benefit from having a bench trial. In just very limited circumstances.
You are unmuted.
Often it's because you have a legal issue that you're preserving for appeal. You don't have a good factual case for trial, but you can't just plead guilty. If you plead guilty, you waive your appeal. So, say for example, you've litigated a motion to suppress. You think you should win it. It gets denied. So you have to preserve your right to appeal that issue. Bench trial is a very common way to do that. Judges generally are not known for being very defense friendly. That's not what lands them on the bench in the first place.
You see the court is in session.
All right, Mr. Jackson.
Thank you, Your Honor.
We will have to come back to this.
GG for identification.
Yes.
The hell was that? GG's been marked.
May I inquire? I'm so sorry. I did it again.
Thank you.
Thank you.
Yes, go right ahead, Mr. Jackson.
Thank you. Just before the lunch break, Sergeant, I asked whether you had engaged in a discussion with the Commonwealth at a prior proceeding in which you were shown a video and you talked about the fairness and accuracy of that particular video in the Sallyport when the SUV was first pulled in. And you indicated that you did indicate that it was fair and accurate, correct?
Yes, back then, yes. Yeah.
I want to play a copy, a bit of that video, if I could, please, with the court's permission.
Okay, is it in evidence?
It is not. I would ask that we mark as next in order. Thumb drive.
Are we marking this for identification, or is there an agreement it's going into evidence?
I'd like it in evidence.
We agree with the stipulation that it's authentic.
I'm not going to argue metadata issues or authenticity issues, so.
All right, so is there a stipulation that this is authentic? Okay, so folks, again, a stipulation means the parties agree, and with that, I will allow this into evidence as the next exhibit. Madam Court Reporter?
Okay.
That's it.
Exhibit 118.
Okay, now you may display it.
Thank you.
Lost track of what number that was.
Okay. Could we play beginning, what's the runtime, Mr. Wolk?
5:37:03.
This is at 5:37:03. If we just play this forward for a couple of seconds. A little bit further. Pause. Do you see what's depicted in this video?
Yes, I do.
This is the video that you were shown at a prior proceeding, correct?
Yes, it is.
Does this appear to be the interior of the Sallyport at Canton PD?
Yes, it is.
And this is what you were questioned about regarding the SUV being pulled into the Sallyport, correct?
Yes.
From a time frame standpoint, just the time frame, this is right after the SUV has been driven in from the flatbed after having been seized in Dighton, correct?
Yes, it was driven off of the flatbed after transportation from Dighton to Canton PD and driven into the Sallyport.
All right. You previously have identified individuals in this video, in this still shot, correct?
Yes.
And what you previously said, and then we'll get to subsequent testimony in a second, you previously indicated that the person to the right was you, person to the left, Michael Proctor, correct?
Yes, previously I identified that being Michael Proctor. I was mistaken. That is not me on the right.
That would be the tow truck driver, correct?
That's correct.
Okay. That is, in fact, Michael Proctor, however, in the two-tone jacket, correct?
I believe so.
Okay. And as the video is portrayed, at least as we're looking at it, and I'll get to the next question next, as we're looking at it, it appears that we're looking at the right passenger side of the vehicle, as it appears in this video, correct?
That's correct.
And you see a timestamp and a date stamp on the bottom, correct?
It is present. I don't know what it says.
Okay, can we highlight that just a little bit?
Zoom it in.
Can you see what that says?
I believe it says interior Sallyport back wall,
Okay,
53710 maybe.
okay. When you indicated that this was a fair and accurate depiction of the interior Sallyport when the SUV was brought in, you were specifically asked whether or not you or Michael Proctor approached or manipulated or touched the right rear taillight area of the vehicle, correct?
I don't remember the exact verbiage used, but in something along those lines, that's what was asked.
And you indicated that neither of you did, correct?
That's correct.
Okay. But in point of fact, this video is backward, correct?
Yes, it is a mirror image of what is actually taking place as recorded by the camera.
Can we play this forward?
Yes.
Do you see where Mr. Proctor, let's go ahead and pause it. You see where Mr. Proctor went?
Yes, the video depicts him going to that portion of the
What
vehicle,
portion?
but we can't tell how close he is.
Okay. And the back, from all appearances, importantly, it appears to be the back driver's side, back left of the vehicle, correct?
That's the way it appears, yes.
Okay. Let's play this forward for a second.
He sure is hanging out back there, isn't he?
Pause. Can I ask you to pay special note to the far rear side of the vehicle? Do you see what appears to be Mr. Proctor's head?
Yes.
As the tow truck driver walks past the rear of the vehicle, can you watch and tell me if you see Mr. Proctor do anything or move in any way?
By the way,
Let's
look
go
at that
forward.
tail light and how that tail light is lit up.
Pause. Did you see any volitional movement by Mr. Proctor as the tow truck driver moved past him?
Yes, it appears if that is his head, it shifted weight.
Okay. Let's go ahead and play it forward.
Shifted his weight, huh?
Stop. Did you see a person that appeared to morph toward the back of the vehicle? Right there.
There is some anomaly there with the footage, so it could possibly be used to describe that what took place.
Let's
Can
look
you
at the
recognize
timestamp.
that person?
I cannot know.
You indicated previously, does that person look large or small in stature
I can't tell.
as compared to, for instance, Michael Proctor, whose head you can see above the car? What about this
Looks
person?
shorter, doesn't he?
Taller, shorter than Michael Proctor?
I can't tell from here. I can't.
You indicated that Chief Berkowitz was a smaller statured person, correct?
I never said that.
I'm sorry?
I didn't know his height.
Larger or smaller? Generally. How about this? Larger or smaller than you?
He's shorter than me.
Okay. Can you tell whether or not that is Chief Berkowitz?
I cannot know.
Okay, let's go ahead and play it for him. And a little bit further. Pause. What does it appear that Mr. Proctor does at this point in the video?
He's walking.
Okay, do you see anything in his hand?
I cannot tell from the video, but he might be carrying something.
Remember we looked previously at a portfolio, black portfolio. Does it appear that he may have a black portfolio in his hand?
That is very likely, but I don't know exactly what he's carrying.
Okay, let's go ahead and play this forward. Okay, and did it appear that somebody just
Person
appeared at the front
operated?
right? The right-hand side of the screen toward the front of the SUV as well?
Yes, it appears that way, yes.
Okay.
Another anomaly?
Let's take this down.
Love to see the timestamps
Mark.
for all of this. If the timestamps are constant, that sure does debunk the motion activation,
I have another
wouldn't it?
electronic device, a thumb drive, that has another video on it, Your Honor. I'd like to have that marked as next in order. Court permission.
All right, so there's no objection, Mr. Brennan?
No objection, thank you.
Okay.
Is it 119?
119, is that what she said? I can't quite hear the exhibit numbers right now.
With the court's permission,
Yes.
now, Sergeant,
This is the correct
what is this show?
configuration.
It appears to be the mirror image of the previous footage. I don't know the exact timestamp there, but
Can we increase the date and time?
Perhaps not right this second.
Do you see, can you read the date and timestamp on this Chiron?
I cannot now.
It's because it's backward, correct?
I can't read it. I can't make it out, sir.
Can you make it any bigger, Mr. Wolk? Does that appear to be backward?
Based on me recognizing some of the digits, it does appear to be backwards.
Okay, let's look at the whole screen again. Sergeant, let's play this forward for just a quick second. Pause. Do you see Michael Proctor in this video?
I believe that's him. Yes.
And which side, and let's start with this. Do you agree that this is the correct version of the camera angle and the SUV as it pulled into the Sallyport?
This is the footage, the way that is depicted right now is very accurately very accurately represents what I remember.
Very accurately.
In fact,
Not just sort
this
of
side the
accurately.
vehicle that we're looking at that's closest to us, that I'm highlighting on the screen to your right, that is in fact the driver's side of the vehicle, not the passenger side of the vehicle. Is that correct?
That is correct.
Why is there
The
all that
far
white
side
showing on the
over
tail
here
light?
would be the right rear of the vehicle, correct?
Yes, sir.
Which area is Michael Proctor walking to? The left rear or the right rear in this footage?
It appears if that's him, he's walking to the right rear of the vehicle.
Can we play this forward? And do you see Mr. Proctor's head above the SUV?
Yes.
And watch him as the tow truck driver walks by. Did he appear to move?
Froze
He
it
shifted
right
late, yes.
And it appears that
mid-apparition.
There's another person that showed up in the footage, an anomaly of some sort, walking off screen left to right. Is that right?
That's what it appears, yes.
Is Mr. Proctor still at the right rear taillight area?
He's in that general vicinity, yes.
Let's go ahead and play it forward. A little bit further. Pause. Can you see anything in his hand? Let me just ask it closed in. Do you see the portfolio in his hand?
It would not be unlikely that it's there, but I can't tell exactly what it is in his hand.
Let's play it forward. Do you see anything in his hand now as his arms?
Yes, yes.
Does it appear to be consistent with the black portfolio that we saw earlier?
Yes, it is, yes.
Let's move forward. And he is now off screen, correct?
Yes.
So, in point of fact, Sergeant, when you were asked previously whether the prior video fairly and accurately depicted what you recall as it pertains to the SUV and the Sallyport. That was not quite true, correct?
Objection.
I'll allow it.
The way I understood the question is what I'm watching accurately depicts what's taking place. It is. Just because it's a mirror image doesn't mean that
Really?
it's not recording what the actions and what is transpiring.
You watch
But you
people
would agree,
apparate
at least, that
in and out?
the previous video showed exactly the opposite of what was true and correct, not just a mirror image. What is left is right, and what is right is left, correct?
Stand to that form.
Would you agree that in point of fact, a mirror image video is not a true and accurate depiction of what's depicted in a scene?
I think it just is a mirror image of what's taking place. If you see someone walking in or driving a vehicle and it's depicting the action of the vehicle being pulled in, and if it's mirrored, it's pulling in from left to right or right to left. It's still documenting the activity that's taking place.
Or if someone walks to the left rear of the vehicle versus the right rear of the vehicle, those two things will be switched, correct?
That is correct, yes.
And you'll agree that the prior video that we showed, that you and I just talked about, the inverted video, appeared for all intents and purposes to show Michael Proctor stay away from the left, from the right rear taillight, walk all the way around and position himself to the left rear taillight. You'd agree with that, correct?
Objection.
Do you agree with that? I allow it.
It appeared that that is what was happening, but he was standing next to the taillight that was already damaged.
But in the corrected video, which is this one, it actually shows unequivocally that Michael Proctor walked directly to the right rear taillight portion of this SUV. Correct?
I'm sorry, can you repeat that?
Sure. In the corrected video, this video here, this unequivocally shows that Michael Proctor walked toward the right rear area of that SUV, where the right taillight is, correct?
Yes.
And you'll also
And
agree
testified
that this
previously.
video was taken before any taillight material was ever found at 34 Fairview, correct?
Can you zoom in on the time?
Not on this one, this is backwards.
I know that the SUV pulled into the garage at the Sallyport at 5:35, and we were still on scene at 5:51, almost 52. So yes, if that's timestamp before 5:51, before we left Canton PD, then yes, taillight pieces had already been found.
So 5:35, 5:37 is before the first taillight pieces were found. All right.
I'd have to see a timestamp of when they were exactly found, but if
Well, let me
that's,
ask you a different way. 5:37, 5:35 is before 5:45.
yes.
Good try.
May I have just a moment, Your Honor?
Yes.
Would like to have hammered in the testimony you previously gave using this video. You said it showed Proctor going nowhere near the right rear taillight. Asked specifically if he or Michael Proctor approached the right rear
Sergeant,
taillight
Canton
on that
PD
video.
is about a mile and a half.
He
from
said they never
34
did.
Fairview, is that right?
Approximately. I don't know the exact distance. I never measured it, but I would not be shocked if you were accurate in that.
Maybe a 3 or 4 minute drive.
Depending on the traffic conditions and the weather conditions, that could be a possibility depending on the speed you travel.
I'm sorry. Your Honor, I have a photograph that I'd like to have marked with the court's permission. If I may approach.
Marked for identification.
Marked for identification for the time being.
Okay.
May I approach?
Yes. Let's mark it first, please.
To the page H.
Thank you.
Quite black.
Let me take a look.
Thank you. Let me ask you a couple of other questions. We just looked at the videos of the interior of the Sallyport. Harkening back to what we just looked at, the corrected video, there would also be a camera on the other side of that Sallyport garage pointing down toward the right rear taillight area of the SUV, correct?
Yes.
There's a camera situated on the opposite side. We'd be looking at that camera, correct?
Yes.
Okay, taking a look at that photograph. I know the quality of it, but can you tell if that appears to be a still image from that camera?
Yes, it appears to be a still image from that video camera.
I'd ask that this be moved into evidence, Your Honor.
Is there an objection?
No objection. Thank you.
620.
Thank you. If we could display this for the jurors, Your Honor, just the photograph.
Okay.
Let's publish it.
Do you see what's depicted? I know the photograph that you're holding is very poor quality. It's a little easier with this lighting. Do you recognize what's depicted in this photograph?
I'm sorry, your laser was bouncing off onto the ceiling. I
I was trying to
apologize.
make it easier for you.
Yeah.
This photograph here.
That appears to be the seized SUV belonging to the defendant with it being situated inside the Sallyport.
And what is that vehicle there?
It's an antique police cruiser.
And who is this person?
I do not know who that is.
Does that look like Michael Proctor?
I don't know. I'd have to get a zoom in. I don't know.
Don't recognize his bald head.
I don't know.
Chief Berkowitz.
It could be Chief Berkowitz. I don't know.
Can you tell me the date that's on the the date and timestamp at the bottom?
I cannot. I think I might be able to make it out in the actual photograph you printed out.
1:30.
Could I take a look at that?
Sure.
11 something
Yes, please, Your Honor.
a.m. on 1:30.
It appears the time is 11:08 and 59 seconds in the morning of possibly January 30th of 2022.
Okay. Let's go ahead and pull this back out full frame.
Thank you.
I wanted to ask you, do you have a point of reference? Does that appear to be the interior camera facing the other direction where the SUV was depicted in the Sallyport earlier?
It's the opposite of what we had viewed earlier, diagonally across, I believe.
So this would be the right rear of the vehicle, correct?
That is correct.
Now I'd like to ask you to take a look at a video.
So this one's not mirrored. Only one side of the Sallyport is mirrored.
I have a final video. I can have that marked as next in order, Your Honor.
As next in order, so there's no objection, Mr. Brennan?
I have no objection to that being entered now.
Exhibit 121.
Your Honor, with the court's permission, could we
Yes.
present this? Go ahead and play it. Pause. Can you make out, now that that's paused, can you make out what's depicted toward the top of the screen?
Now it says 5:07 p.m. on
Yes, it appears to be a
129.
distorted image of that antique police cruiser.
Okay. And does the area next to the police cruiser appear to be empty? Some snow on the ground?
Yes, it does. Actually, yes, it does look that way, yes.
Okay. So there's nothing next to the police cruiser, at least at this point, correct?
That's what it appears to be, yes.
Can we take a look at the timestamp on this document or on this frame? I'd ask you to let the jurors know if you can see what the actual run time is on this.
I could see the timestamp. I don't know the runtime, what it's going to be.
It's 5:07, 10 or 12, something like that?
That's the timestamp, yes.
Okay.
Yes, PM.
Now, if we could just play this forward, go back to full screen. Pause. Now, how many seconds would you estimate, just in your head, just went by in real time?
Approximately 5 seconds.
Okay. Do you see something in the video now?
Yes.
What is that?
It appears to be the seized Lexus SUV.
And now let's look at the timestamp.
5:50.
What time is that?
43 minutes.
5:47 PM.
So in about, according to your testimony, in about 5 seconds, the time jumped from before the SUV was in the Sallyport to about 5:50 PM after the SUV had already arrived and is now situated in the Sallyport, correct?
Yes, that is correct.
The time frame that we just saw earlier of about 5:35, 5:36 or so with you and, with the tow truck driver and Michael Proctor in the video. That is not in this video. It's not captured in this video. Was it?
It did not present itself, no.
That's all I have now.
Mr. Brennan?
Interesting. Get our captions back in a good spot.
Good afternoon, sir.
Good afternoon.
You had just asked questions about some of the video footage from the Canton Police Department Sallyport area. Is that fair to say?
Yes, sir.
I'd like to ask you further questions about that. In your investigation, did you obtain camera footage from a number of different angles from the Canton Police Department Sallyport area?
I did.
And one of those series of footages, did that include the interior Sallyport back wall for January 29, 2022?
Yes, it is.
Is that the video that appears inverted? And then we saw the second where it was present as you would see it?
Yes, sir.
Did you look at that video? Did you invert the video in any way?
No, I did not.
Did you investigate and learn whether or not there was any other video in addition to that interior Sallyport back wall where video was set up by the town of Canton that appears inverted rather than forward?
Objection.
I'll allow it.
Yes, the investigation revealed that multiple cameras had a lens applied to it that was inverted.
In addition to the Canton Police Department Sallyport interior back wall, where else did you learn around town there was video that appears
Around town?
inverted?
I believe it is inside the Canton PD, the hallways possibly. And if I am not mistaken, the other locations within the town of Canton. And the,
Objection, Your Honor.
Ask the question. No, is that your answer? Is that your final answer?
I wasn't finished, but yes.
May we proceed?
I'm not sure what other videos elsewhere in the town of Canton are particularly responsive to. Seems like that's not really much of a rebuttal. It goes to the Sallyport itself. Okay, maybe the hallway's inverted. I find it very strange that looking inside the Sallyport, one wall has a mirrored camera and one does not. I find that quite strange. Why would that be? I don't really understand why it would need to be mirrored in the first place, or why that would be a good practice, why you would do that. But assuming there's a reason, I don't know, visibility, clarity, something. Why is that only apply to one side of the Sallyport? I just don't get it. Don't get it. So what is there a camera on some public building somewhere in town that also has a mirrored image, and this is going to rehabilitate what's going on in the Sallyport? I don't know. Perhaps. But I don't think the problem here is necessarily the Sallyport. It's not necessarily the video. It's how they presented it and how he testified about it. What he said it was showing, and what he said it was showing was neither him nor Proctor going anywhere near the right rear taillight. And that didn't. I'm not sure that really got hammered home, or that.
Jurors, I'm going to strike the portion of the answer that follows hallways of the Canton PD.
And so when
didn't-
you
didn't
obtained
show that.
the video from the interior Sallyport back wall, which was inverted, did you provide a copy of it?
Yes, I did.
When you looked at that video, does it have time and date stamps on it?
Yes, it does.
May I approach?
Yes.
I'd like to introduce a copy of that.
It didn't come out that was only elicited on cross-examination. He had the whole story on direct about how it didn't show him and Proctor going near the taillight, and it only came out on cross that it was a mirror image.
When you provided the video for January 29, 2022 for that inverted video, did you do any further investigation to see if it was an anomaly that happened just on that date, or whether that was historically the way the video appeared?
I'll look into that matter, produced the fact that it's been recording that way previously to January 29th.
Why did you want to historically go back and see if it was historically the same way?
To show that it had not been manipulated or altered in any way, and it was accurately recording what was taking place on January 29th, 2022.
As part of the investigation,
Yes,
was
the
the video
operating
taken
was
from
real.
January 1st, 2022?
Yes.
And is that before January 29, 2022?
Yes, it is.
I'd like to approach and move to introduce this.
No objection.
Okay.
Exhibit 123.
Do you know how many cameras are inside the Sallyport?
I don't know exactly. I know that there's at the very least 2 inside the Sallyport.
You were shown a still photograph, not from the inverted video, but from a different video or a different camera.
Yes, sir.
Do you remember that photograph?
I do.
And you were asked about gaps in time. Do you know what the health was of that camera around that time?
I do not know.
Did you obtain and look at video from that camera?
Yes.
May I approach?
Yes.
I'd like to introduce. And have you look at this before introduce if you recognize what that is.
Yes, I do.
What is it?
It's a Sallyport videos, the original disc or thumb drive. I apologize, not disc.
And we'll introduce this to the exhibit, please.
No objection, Your Honor.
Okay.
Exhibit 124.
When you saw that dark photograph, you later saw a picture that was clearer, and you were asked questions about that. Do you know whether or not the video from that Sallyport area was clarified?
It was.
What does clarified mean?
It means it was enhanced to look clearer.
And that image you saw, was that a clarified photograph taken from the video that was not clarified?
It appears that way, yes.
Do you know who clarified the video?
I do not know.
May I approach?
Yes.
Clarified. He's using clarified, not enhanced or altered or anything like that, because they know it was them that did it before the first trial. It was somebody from law enforcement who did it before the first trial. They testified about it. So he's not going to say enhanced, even though Hank's trying to imply it was maybe defense that did it. Suspect we might get some redirect on that, or recross. We'll see.
Getting you a zip drive, you know what is on that?
Yes,
What is it?
it's Sallyport clarified video from the front wall.
Thank you. I've moved into this as an exhibit.
No objection, Mr. Jackson?
Sorry, Your Honor, no objection.
Exhibit 125.
With the court's permission, could I play a portion of the clarified video for the jury?
Yes.
With Ms. Gilman's assistance, could you take us to the clarified video of the Sallyport, and could you take us to about 5:35?
Having some tech issues.
As Ms. Gilman searches, I have other questions I can proceed with.
Okay, we'll turn the light on again, please.
Oh boy.
Go ahead, thank you.
Defense is definitely winning the tech battle.
Did you obtain video of outside the Sallyport to show what time the tow truck arrived with the defendant's Lexus?
Yes, it did.
May I approach?
Yes.
So now we're doing the trial equivalent of a discovery
Hey,
dump.
you recognize it.
Let's just give them lots and lots and lots of video, and maybe they'll forget which one they're looking for.
Yes, I do.
What's
And
what?
is it?
It's a disc containing CPD exterior Sallyport video.
Move to introduce this, please.
No objection, Your Honor.
Exhibit 126.
Similarly, did you obtain video from the front driveway of the Canton Police Department depicting the arrival of the defendant's Lexus?
Yes.
May I approach again, Your Honor?
Yes.
Thank you. And you another item, do you recognize this, sir?
Yes, I do.
And what is it?
It's Canton PD driveway video.
And is this a copy of the video you obtained?
Yes, it is.
I would move this into evidence.
No objection.
Thank you. Exhibit 127.
Do you recall when you arrived with the defendant's Lexus on January 29, 2022, what time you reached the Sallyport?
To the best of my recollection, it was 5:35 p.m. is when the vehicle was placed into the Sallyport.
To the best of his
When
recollection.
you left Dighton after the tow truck lifted the defendant's Lexus and put it on the tow truck, did you follow the tow truck back to Canton?
Yes, I did.
Did the tow truck stop at any point between Dighton and Canton Police Department?
Other than red traffic lights, no.
When you were following, how were you following the tow truck?
I was keeping a safe distance, always keeping line of sight behind the vehicle. I was following it from Dighton residence all the way to Canton PD.
Was Michael Proctor with you in your truck?
Yes, he was.
Did you take any detours on your trip back to the Canton Police Department?
No, we followed the truck driver. He led the way.
At any point, did you take any turns to Fairview Road?
No,
Did you know whether or not there was a CERT team at Fairview Road searching while you were driving back to the Canton Police Department?
I knew one was dispatched, yes.
Did you go to Fairview Road to speak to any of the CERT team members?
No,
Did you watch the CERT team members conduct their search?
no, I did not.
In any way, did you, at any point during that search, see it happening?
No, I did not, no.
When the CERT team members were there, do you remember that they arrived at 4:54 and 4:56?
I don't have a specific memory, but I know that they arrived sometime between
Yeah, because you
that
have
hour.
no knowledge.
When you arrived at the Sallyport, at the Canton Police Department with the defendant's Lexus, what was your understanding of where the CERT team was?
My understanding was they were at 34 Fairview.
When you first arrived around 5:37 at the Canton Police Department, were any members of the CERT team at the Canton Police Department?
Objection.
I'll allow it. Lay a foundation.
Facts not in evidence,
Now, I asked you, do you
537.
remember about what time you got back to the Canton Police Department? Do you know specifically what time you got back?
I know we pulled in to the driveway at 5:30 p.m.
Did you see some of the timestamps that you have shown on cross-examination?
Yes,
Did you see the timestamp 5:37:18 when it was shown to you by the defense?
yes.
At that time, when you were arriving and bringing the defendant's Lexus into the Sallyport, was there any CERT team members at the Canton Police Department?
No,
Were there any troopers who were speaking to you or receiving items or evidence from you or Trooper Proctor?
absolutely not.
Was there any items exchanged between you and or Trooper Proctor and anybody else for that matter that you saw?
No,
While you were at the Canton Police Department in the Sallyport area, do you remember how long you stayed in that area?
approximately 15, 20 minutes.
And so you were asked when the first items were found at Fairview Road. Do you remember that it was around 5:45?
Yes,
So at the time those items were first found at Fairview Road, where were you and Michael Proctor?
at Canton Police Department.
When you were at the Canton Police Department and you had brought the Lexus back
Did you
Bruce
ever see
Burke.
Michael Proctor leave the Canton Police Department without you?
No,
You ever see him hop in a car and take a drive,
no,
a 3-minute drive or a 4-minute drive?
no.
Did you ever see him leave for a 6-minute, 7-minute trip?
Objection, Your Honor. You've made your point. Next question.
Never went to the bathroom
When
or
you were
anything?
at the Canton
Eyes on
Police
him the whole
Department,
time?
were you separate or with Michael Proctor?
We were together, not obviously tied at the hip, but we were within eyesight, traveling together.
After you left the Sallyport area, did you and Michael Proctor immediately leave the Canton Police Department?
No, we stuck around.
Why did you stick around at the Canton Police Department?
To make sure that evidence was properly being protected with yellow tape around it. And we were making plans to go get dinner.
When you were making plans, did you go anywhere else in the police department after you left the Sallyport area?
Yes, I believe we went to the conference room.
Was there anybody else that you saw in the police department when you went to the conference room with Mr. Proctor?
I remember talking to Chief Berkowitz in the police department. We were in the dispatch area at one point in time as well. So there was multiple people that observed us there.
At any point, did you give any items to Chief Berkowitz?
No,
At any point, did you ever see Michael Proctor hand or give an item to Chief Berkowitz?
absolutely not.
You said Michael
Absolutely
Proctor
not.
had a folder with him.
Yes,
Is that typical in an investigation?
yes.
Did you ever see him place taillight or any item in that folder?
No, that would be absurd.
Did you ever see him retrieve an item or taillight pieces and give it or sneak it over to Chief Berkowitz?
Objection, Your Honor.
Did you ever see Michael Proctor ever hand any piece of taillight
Objection.
to
That's
Chief
been
Berkowitz
answered.
or any other officer for that matter?
No,
The entire time you were there, did either you or Michael Proctor, from what you saw, provide any items, physical items, to anybody else that was there?
Objection. That's been answered.
I'll allow that.
no, we did not.
Okay.
Asked and answered, outside his personal knowledge, et cetera, all that stuff. Suddenly now Yuri gets to testify about we again. Remember? They weren't joined at the hip or anything. When it came to whether anybody touched the taillight, she did not allow Bukhenik to testify to what Michael Proctor did or did not do, only to what he himself personally observed. So asking him whether Michael Proctor gave evidence to anybody else seems to be a little beyond the scope of what she has allowed so far. Not necessarily something that he personally knows. He can testify to what he saw with his own eyes. This is a long day for nobody to take a bathroom break, isn't it? A little pit stop? Or you guys do that all in eyesight of each other too? No, that would only take 5 minutes or so, wouldn't it? Been this very long day. They've been together since approximately 9 in the morning when they first got to Canton Police Department. No separation at all, huh? Close partners there, huh? Getting all of that video into evidence, not even showing the jury, it's just for purposes of confusion. So they don't know which one is which. They don't know which one to ask if they want to see it again. They can't designate it by exhibit. They'd have to describe it. That's my read on that.
May I?
Yes.
At any point from when you first arrived at the Canton Police Department with the defendant's Lexus to the point when you left to go to dinner or to get something to eat with Michael Proctor, did you ever provide any physical item to anybody at the Canton Police Department?
No, other than dropping off the vehicle itself, we did not exchange anything.
Oh, don't say we, I'm just asking for you. Now I'm going to ask
Don't
you,
say
at
we.
any point when you got to the Canton Police Department until you left to go to eat with Michael Proctor, did you ever see him hand any physical item to any other person whatsoever?
No, I did not.
And after, do you know about what time you and Michael Proctor left the Canton Police Department?
I would have to estimate it to be around 6, maybe well after 6.
And at the point you left, do you know how many of the items had been found by the CERT team at 34 Fairview Road at the time you left the Canton Police Department?
Objection.
Outside of his knowledge. He's already insisted he wasn't
When
there.
you left with Michael Proctor, where did you go?
I went to Norwood, Massachusetts.
Is that where you ate?
Yes.
Where'd you eat?
When you left and then
What'd you
arrived
have?
in Norwood, did you stop along the way at any other place, including but not limited to 34 Fairview Road?
I did not.
Did you eat?
Yes.
After you ate, where did you go?
Back to Canton Police Department.
Why?
We were having a debrief for that day on the investigation so that everybody could get on a good understanding of what had been learned, what had been collected, and where the investigation stood, and to assign tasks on the next steps.
Who were you
Not
meeting
because,
at the Canton Police Department when you returned?
You needed to
It
lay out
was
that wet
Detective
clothing.
Lieutenant Tully, members of the Norfolk SPDU.
Do you know at about time you returned to the Canton Police Department?
I want to say it was after 7:30, but I'm not positive.
When you left
Would you
the
be
place that
speculating?
you and Mr. Proctor ate at and returned to the Canton Police Department, did you take a swing by Fairview Road?
No.
Did you stop anywhere from the point you left where you ate and came back to the Canton Police Department?
No, sir.
When you came back to the Canton Police Department, did you get debriefed?
Yes.
Did you learn whether or not the CERT team had found any physical items at Fairview Road?
Objection, Your Honor.
I'm going to allow that.
Yes, I did.
Did they give you any details about what they had found at Fairview Road during the CERT team search?
Objection.
I'm going to allow that.
I learned that
Objection, Your Honor.
I'm going to allow this.
the second sneaker was located. Also, a large piece of red taillight was also located.
After you were
That's
debriefed,
it?
did you
One large
leave the
piece of
Canton Police
taillight?
Department?
Yes.
Who did you leave with, if anybody?
It was myself, Trooper Proctor, and Trooper Keefe, I believe.
When you left the Canton Police Department, do you know what time that was?
I do not, but I would have to estimate to be around 8 o'clock, maybe 8:15.
Did you leave alone?
I was in my truck, yes.
Did you
So,
see
Mr.
where
Brennan,
Mike?
what I'm going to do is just interrupt you for a minute. Folks, a couple of minutes ago, when Sergeant Bukhenik testified as to what he learned at the debriefing, that's not offered to you for the truth of what he said was learned, but only so you understand that the police, what Sergeant Bukhenik and the police knowledge was at the time, that it was told.
Cautionary instruction.
Go ahead, Mr. Brennan.
Thank you. When you drove away, were you alone?
Yes.
Okay. When the Lexus was brought to the Sallyport, did you have a chance to again look at that right rear taillight?
Yes.
And did you make observations of it?
Yes.
Did you document it? Photograph it?
Which one's the right rear taillight?
If I were being conspiratorial, I'd think she gave that cautionary instruction only because he said they found a piece of red taillight plastic, and O'Hara testified they found 6 pieces of plastic.
The right rear taillight.
It's not for the truth, just to show what they learned.
While you were at the Canton Police Department and in the Sallyport area, did you ever see anybody take a piece or in any way remove part of that broken taillight from the Lexus?
No, I did not.
If you had, what would have you done?
Objection.
Sustained.
May I approach, Your Honor?
Yes. So, Mr. Jackson?
Working his mouth quite a bit there.
Can I have Exhibit 13 displayed, please?
Mouth a little dry.
Could you zoom in a little, please, Ms. Gilman? Do you recognize that photo?
I do.
What do you recognize it as?
I recognize it as the damaged and missing pieces of the right rear taillight on the defendant's Lexus SUV.
When the Lexus was brought into the Sallyport, was there still snow on it?
Yes, there was.
Was there any snow on it that covered parts of the vehicle?
Yes, there was.
Was there any snow in that area
Currently, no.
when you first brought it into the Sallyport?
I'm sorry, in the area of the vehicle?
No, the area of that taillight.
Yes, there was, yes.
How close did you get to take a look at that?
I was within a foot of it.
Is that a fair and accurate depiction of what you saw?
Yes, it is.
From what you saw, was the damage you saw when you looked at the car for the first time in the Sallyport area any different than the damage that appears on this Exhibit 13?
It is not.
As part of your investigation, did you look for, you can take that down, please, and lights on, thank you. Did you look for other evidence that the taillight was broken before it came into the Sallyport area?
Yes, I did.
Did you have a chance to view the ring video from Meadows Road at 5:07 in the morning?
Yes, I did.
And when you looked at that, did you have an opportunity to look at the defendant's Lexus backing up and then leaving that driveway?
Yes, I did.
Did you have a chance to see if there was any evidence?
Yes, I did.
And what did you see that stood out to you about the taillight?
The taillight is shining white and not covered by a red taillight cover, which would have produced a red light.
Did you further look at any video from the Canton Police Department dash cams to get a view of that taillight and determine whether it was broken before it was even brought to the Sallyport area?
Yes, I did.
And did you in fact look at video or still photographs from the Canton Police Department dash cam?
Yes, I did.
Could I have Exhibit 11 displayed, please?
I sure would like to know still when. When did you look at this? Because at 8 something in the morning, they didn't know or think it was significant. So when did you
And
decide?
during your investigation, when you were making this analysis, did you view this photo?
Yes, I did.
Did you make any particular reference or anything that caught your attention in this video?
Yes, the right rear taillight of the Lexus SUV is missing the red lens cover, and it is damaged.
You mentioned the observations. You can take that down, please. You mentioned your observations when you got to Dighton about what you saw relative to the taillight. And then at some point, video was provided of the tow.
Yes,
Did you study that video as well?
yes, I did.
And did you see anything in particular when you were making these determinations that stood out about the video of the Lexus being put onto that tow truck relative to the taillight?
Yes, the video indicated that there was white light coming through, exposing the missing red right rear taillight cover.
We saw that on the
You
Sallyport
told us
video
on
on the
direct
agreed
examination
one.
you've watched a number of videos and interviews of the defendant.
Yes,
Without getting into the content, did you watch any videos where the defendant talks about the broken taillight prior to the Sallyport?
Objection, Your Honor.
In that form, I'll sustain it.
Did you listen to any interviews of the defendant relative to the taillight?
yes,
I want to
Problem
go
is on
back and I want you to
Sallyport.
take us through your investigation. And I want to be specific about what you learned and when and what you did with that information relative to the decisions and the direction of your investigation. When you were called on the morning of January 29, 2022, when you first got a call, where were you?
I was at home in bed.
You mentioned that after you received the call, you called another trooper at that time.
Yes, sir.
And who was that?
Michael Proctor.
After you spoke to Michael Proctor, did you have any firsthand knowledge about what had happened prior?
No, I did not.
Did you have any firsthand knowledge about what had happened the night before?
I did not, no.
Do you have any firsthand knowledge about the participants or the people that may or may not have been involved?
I did not, no.
Did you at that point know, or were you friendly with Brian Albert?
I knew who he was. I was not friendly with him. I did not know who he was.
Had you ever socialized with him?
No.
Nicole Albert?
No.
Were you friendly or ever socialized with her?
No, I've never.
Jennifer McCabe, did you know who she was or socialize with her?
No, I did not.
Her husband, Matthew McCabe, did you know him or socialize with him?
No.
How about Julie Nagel? Did you know who she was or had you socialized with her?
No, I did not.
Ryan Nagel, was that familiar to you?
No, it's not.
Sarah Levinson, did you know that person?
I did not.
You mentioned that you knew who Brian Higgins was.
Yes.
And you had worked on a case or some involvement in the case with him?
Yes.
Did you owe him any particular favor or kindness at that time?
I'll sustain it.
Did you have any loyalty or friendship with him?
I'll allow that.
I did not, no.
At this point, you are how far into your career as a Massachusetts State Police officer?
In 2022, I was approximately 10 years in.
And you had been honorably discharged from the military,
Yes, I was.
served the president?
Yes.
And so at this
Gotta bring
point,
that back up.
how about Heather Maxon? Did you know that name?
I did not know.
But you should
When you
have.
first received the call, did you have any firsthand knowledge whatsoever?
No, just what I was told over the phone.
You mentioned you went to the Canton Police Department first and spoke to Canton police officers.
Yes.
Was it at that point you learned about a physical item that was found at the scene?
Sustain.
What did you learn from them that was important in your investigation when you first got to the Canton Police Department?
I learned that there was a broken, shattered cocktail glass that was recovered from near where Mr. O'Keefe was found. And also his phone was underneath him at the scene.
And were both those items available to you?
Yes.
Did you also learn any statements made from any witnesses that were attributed to the defendant at that time?
Yes.
And what was the statements?
At that point in time, while at the Canton Police Department, the statements were, "Oh my God, did I hit him? Did I hit him?"
In a question format, question it.
Yes.
And based on that information, was it somewhere around that point when you called the hospital or medical examiner's office?
Yes, I made a call to the medical examiner's office.
Is that all the information you learned that morning?
No, it's not.
After you learned that information, did you ask the police officers, well, let me ask it this way. After you learned that information, did you want to go somewhere?
Yes, I did.
Where did you want to go?
I wanted to interview the individuals that were with the defendant when Mr. O'Keefe was located and get their accurate and most first-person information from them directly.
So Carrie Roberts. Stream is frozen up on us.
Differently witnesses.
At this point in time, prior to speaking to them, I just knew that they were eyewitnesses for the location of Mr. O'Keefe, but I did not know if they were eyewitnesses or witnesses.
And who did you speak to?
I spoke with Ms. Jennifer McCabe, Mr. McCabe, and Mr. Brian Albert.
When you spoke to them, did you
not
separate
Carrie.
them or speak to them as a group?
Not
I
who you just
separated
said
them.
you wanted to talk
You went to
to.
whose house to speak to them?
The McCabe household.
Is it typical to go to a person's house rather than bring them to the station under these circumstances?
Objection, Your Honor.
Ask it differently, Mr.
Why did you go to their house rather than ask them to come to the police station?
Well, there were multiple factors involved in that decision. One, the driving conditions. Two, these are witnesses that had suffered some sort of traumatic event, finding their friend on the front lawn of their own town. So going to their home would provide hopefully a more comfortable scene for them to recall information in the comfort of their own home.
When you spoke to them, did you receive any information from any of them that Mr. O'Keefe went into 34 Fairview at any time that night?
No.
When you were asked questions about scene versus crime scene, was 34 Fairview, the home, the inside of the home, a crime scene in your mind?
No.
Was the area where Mr. O'Keefe found an important or unimportant area?
It's very important.
Did you know whether or not any of the Canton Police Department officers at that time had done any type of limited search of the area?
Objection.
Just whether you knew.
At that point in time, we did know, yes.
What did you learn about the scope or the breadth of that search by the Canton Police Department?
Objection.
I'll allow that.
I knew that it was brief based on the weather conditions and the item that was recovered.
Okay. After you spoke to Jennifer McCabe, and did you say Brian Albert?
Jennifer McCabe, Matt McCabe, and Brian Albert.
Okay. At that point, did you have any reason to want to go into 34 Fairview?
No, I did not.
Did you learn whether or not Canton police officers spoke to those particular people who lived there before you got there?
I had learned, yes.
What did you learn?
I learned that Canton police officers went inside the home, spoke with members inside the home as well.
When you speak to witnesses, you've done many interviews over your
Yes,
career?
I have. Yes.
In addition to asking questions, what are you looking for when you speak to a witness?
We're looking for
Oh,
body
getting that
language, how
credibility
willing
stuff
they are
again.
to provide the information. And as is with everyone, we always trust by verify. We corroborate their statements.
Did you see anything about these witnesses
Wasn't
when you
there.
spoke to them that cued you or concerned you to do a further investigation?
Objection, Your Honor.
Ask it differently.
Was there anything about their mannerism or demeanor that stood out to you?
Objection.
I'll allow it.
No.
After speaking to the witnesses, in your mind as an investigator, what did you need to do next?
I needed to take a look at Mr. O'Keefe's injuries for myself.
And you share with us detail about when you went down to Good Samaritan Hospital and make observations.
Yes, sir.
On direct examination, I pointed out you're not a medical examiner, are you?
I am not, no.
Not a biomechanical engineer.
I am not, no.
In your experience, when you looked at Mr. O'Keefe and had a chance to study his body, what impression did that leave with you with relative to your investigation?
Objection.
I'll allow that.
At that point in time, after viewing Mr. O'Keefe's injuries, my impression shifted from him possibly being struck with the glass that was located at the scene where he was found to him being struck by a vehicle.
Why?
Due to the abrasions and cuts on his
His
right
arm.
arm, and the amount of force, in my experience, the amount of force one would have to generate to produce the wound to his head.
Objection.
I'm going to strike that last part.
After coming to the conclusion, or strike that,
His arm.
after making your
You had to look for a
observations
vehicle
and your
collision.
determination, did your focus shift at that point?
Yes, it did.
Where did you want to go next?
I wanted to observe the vehicle that the defendant was driving.
What were you going to be looking for?
Any damage to the headlights, windshield, and other parts of the vehicle that would have come into contact with Mr. O'Keefe.
You mentioned the windshield and the headlights. Those are in the front of the car. Did you have an impression at that point?
Yes. Majority of the cases that I had exposure to with pedestrian vehicle strikes, the strike comes from the front of the vehicle. So in my assumption, speculation at that point in time, based on the limited information I had, that was my theory.
Oh, now you know what
When
a
you got
theory
to
is.
Dighton, did that theory change?
Prior to our arrival to Dighton, the theory had changed.
Based on information you received from Jennifer McCabe?
Objection.
Sustained.
What was that based on?
It was based on information I received from Jennifer McCabe's phone conversation.
And what was that information?
That the defendant told her that she had damaged her taillight and showed Mrs. McCabe and Mrs. Roberts the missing pieces and damage to the rear right taillight of her vehicle.
When you got to Dighton and had a chance to look at the defendant's Lexus, did your focus of your investigation develop in any way?
Yes, seeing for myself that there was actual damage, coupled with the statements made, did I hit him? Could I have hit him? Along with the my observation, obviously, of the vehicle, my focus began to concentrate on the defendant.
You share with us that you went inside and spoke to the defendant.
Yes.
Why did you speak to her at her home rather than ask her or force her to come to the police station?
Same reasons we interviewed the witnesses, the driving conditions, the time that it would take for her to respond, the comfort of her own home, her parents' home, where she had just experienced a very traumatic event, being concerned for her well-being. We interviewed her in the comfort of her parents' couch.
When you interviewed her in her parents' home, where was she seated?
On the couch of her parents' living room.
Where was her mother?
She was in the home. I don't have a specific memory of her being in the room with us, but her father was in the room with us.
Did you ever try to separate the defendant from her father when you interviewed her?
Objection. I move approach.
I'm going on with this line of questioning. Oh man, so many little problems with this testimony. Who caught? What did you want to do next? You wanted to interview the people who were there with the defendant that morning. So you spoke to Jen McCabe and two people who were not there with her that morning, and you didn't speak to the other person who was with her there that morning, Carrie Roberts. This is a problem with the explanation for what exactly you were doing with your interview strategy that morning. That's your actions don't align with your explanation. The cuts on John's arm are what made him think, oh, we're focused in on a vehicle collision now. The cuts on the arm look more like something that glass would cause than a car. You got to be kidding me. Nobody is buying that. Nobody on the jury is looking at that photo of John's arm and thinking, yeah, obviously you had to investigate a car crash. He thinks we're stupid, guys. He thinks we're stupid. The injuries to his right arm, unbelievable. Unbelievable. So you learned about Jen McCabe's phone conversation with Karen Reed, and where Karen supposedly told her about the damaged taillight and showed her the damage, but you hadn't focused on on Karen before going to the hospital, but you just interviewed Jen. Jen had already called Lank back to tell him that, so it's fresh in her mind. This timeline is not adding up either. If Jen told you that and that's what got you to focus on the defendant, that happened before you ever went to the hospital to look at John. It happened before you were heading out to Dighton to investigate your theory, now that you remember what that is. Now that you know what a theory is and developed one and how that works, your timeline of how your theory unfolded doesn't add up either.
Bless you.
Right ahead.
Thank you. Trooper, to get back to my question, when you decided to speak to the defendant, did you ask her father to leave the room?
I did not know.
Why not?
We just simply wanted to get her recollection. Her father did not pose a safety risk to us. He was not present, to the best of our knowledge at the time when Mr. O'Keefe was injured. So him leaving the room just didn't appear necessary. Again, my concern was for her well-being, having known that she was sectioned, and we wanted to make sure it was a safe and comfortable environment for her to do the best she could to tell us what she remembered.
What was her demeanor when you spoke to her?
She was calm, stoic. She was sitting on the couch with a pillow on her lap, a laptop to her left. She was, I guess, maybe poised when she was answering our questions.
When you finished your conversation with the defendant, had anybody in that home ever mentioned the idea of whether or not John O'Keefe went into 34 Fairview that night?
No.
When you went outside to get in your truck and follow the tow truck back to Canton, did you have any information whatsoever that there was any animus or animosity between Brian Higgins and John O'Keefe?
No.
After speaking to witnesses and the defendant at that point, when you got back into your truck to go to Canton, did you have any information that there was any animosity between Brian Albert and John O'Keefe?
No.
We've already talked about, out of order, your return back to Canton, the Sallyport, and then you and Mr. Proctor going out to dinner and going back. So I'm going to skip all of that. After you went home that night, did your investigation continue?
Yes.
How long do investigations continue for?
Until they are completed and exhausted, sometimes years, sometimes decades.
If you were to receive new information tomorrow, would you consider it?
Absolutely.
Sustained.
When you write police reports, is there a time limit on when you can file a report?
No.
Throughout this case, did you write a number of reports over time?
Yes.
Did you engage in tasks after the case began?
Yes.
Have you engaged in tasks recently?
Yes.
As you were investigating this case, did you speak to a number of witnesses?
Yes, I did.
Did you consider reports that were provided by other troopers who interviewed witnesses?
Yes.
But he doesn't remember
Mr.
any of
Proctor
them.
was the case manager of this case?
Yes.
You were his supervisor?
Yes.
Were there other troopers who participated in this case?
Yes.
Do you know whether or not Lieutenant O'Hara participated in this case?
I do know.
You do know?
I do know
Did
that he
he?
participated, yes.
Did he?
Yes.
Do you know if he had a team with him of other troopers?
Yes,
Do you know if Trooper Prince engaged in any interviews?
I do know. Yes.
Are you familiar with the name Nick Gianturco? Guarino, I saw.
Yes, I am.
And do you know if he engaged in any tasks in this case?
I do know. Yes.
What did he engage in generally?
He generally conducted the digital forensics portion of the investigation.
Why was that so
Extractions.
funny?
Trooper
that
Keefe, is that a name?
speaking?
Familiar?
Yes, it is.
And do you know whether or not he was involved?
Yes, I do know.
Were there a number of other troopers who were involved in different aspects of this case?
Yes, there are a number of different ones.
Trooper Evan Brent?
Yes.
Did you look or seek other information after you left the defendant's house?
Yes.
Did you look for other witness statements?
Yes.
Did you try to obtain further evidence?
Yes, we did.
Was there an interview with firefighter Timothy Nuttall on February 8th?
Yes, there was.
And that was about 10 days after the incident?
Approximately, yes.
Did you learn any statements from him in addition to the earlier statements you learned that added to your investigation?
Yes.
I'm going to allow it.
And do you remember what Timothy Nuttall told you on February 8th, 2022 about any statements of
I hit him, I hit him, I hit him.
So folks, again, this is being offered not for the truth of the statement, but simply to show that the information was provided to the police.
Yes, Mr. Nuttall was one of 3, I believe.
So talk about Mr. Nuttall, please.
Mr. Nuttall told me that the defendant stated, I hit him, I hit him, I hit him.
Was that information different than the statements that you were first learned about that she had allegedly made earlier that night?
Yes, it was.
I wouldn't mind if you said one of 3 firefighters.
Firefighter Daniel Whitley on
we know,
February 8th, 2022.
Kelly
I
didn't.
did.
When you spoke to him, do you remember whether he shared any statements about the defendant telling him anything about her interaction with Mr. O'Keefe at the end of that night?
I believe that he stated that they got into a fight.
Do you remember the words that he used when he described that fight?
I do not remember the exact words. Those will be reflected in my police report,
Would your police report potentially refresh your recollection?
potentially.
May I approach?
Yes.
Thank you. Handing you a document, I do not want you to read from it.
Okay.
I want you to look at it, determine whether it refreshes your memory, and then I'll ask you if it refreshes your memory. If it does, I'll ask you about it. If it doesn't, then I won't.
Okay, sir.
After reviewing your report, does it refresh your memory about your conversation with Daniel Whitley on February 8, 2022 about statements made by the defendant to him?
Yes.
And could you share with us
what the statements were as related by Mr. Whitley back on February 2022.
The statement was,
Objection, Your Honor.
Again, jurors, this is an offer for the truth that's contained in the statement, simply to show that this information was provided to the police.
the defendant made a statement questioning whether Mr. O'Keefe was still alive.
In anything about the nature of their disagreement?
Mr. O'Keefe and the defendant got into an argument.
Objection.
So for the same purpose.
As you're learning this information, does it in any way shape your continued investigation?
Yes, it further supports witness statements. It further supports and corroborates information that we're learning. The more information we collect, the stronger the case becomes.
Did you interview a person by the name of Anthony Flamate?
Yes, I did.
And when you spoke to him, do you recall whether he shared any statements that the defendant made to him?
Objection.
Yes.
And do you recall what those statements were?
I do have a general recollection of what they were, but
I don't want you to guess. Would your report potentially help your memory?
yes, it would.
Rolled his eyes a little bit at Hank
Can I
there.
approach?
Yes.
Don't want you to guess. Why not? You don't know your line in all this? Let him just riff. Let him riff. Don't you trust him, Hank?
Thanks, sir.
Same protocol that I mentioned before. Take a look, see if it refreshes your memory. If it does not, let me know. If it does, I'll then ask you some questions about it.
Get back into
Yeah,
your
for sure.
lean pose.
Yes.
Get back on that couch.
After looking at your report, does that refresh your memory at all?
Yes, it does.
And when you were learning information to shape your investigation, did you consider anything that Anthony Flamati told you?
Yes, we did.
Okay. And what did he tell you that the defendant told him that helped shape your investigation?
Objection, Your Honor.
I'm going to see counsel at sidebar for just a minute here on this one.
Gonna have a sidebar. What do we want a continuing objection so she doesn't have to keep giving this in limiting instruction? AJ's objecting because it's potentially hearsay. You know, what did she say? So Bev is giving this limiting instruction to the jury that it's not offered for the truth. It's just offered to show what they based their investigation on, what information was provided to them. So she's having to give that, you know, every time, and that's fine. That's fair. Anytime a statement that is coming in that could potentially be hearsay, if the jury isn't allowed to consider it for that purpose, they should be told that. Did you talk to Matthew Kelly, firefighter? Did you talk to him? What did he tell you? Matthew Kelly is the firefighter who, according to Mr. Nuttall, was down at the feet of John O'Keefe while they were doing the CPR. And that Karen said, I hit him in front of Nuttall, Flamati, and Kelly. But Mr. Kelly does not have any recollection of that. For the first trial, he didn't hear anything like that. Weird. Of course, we've already heard Flamati and Nuttall's versions, their accounts of that statement. Different circumstances, different descriptions. of what was going on. Katie McLaughlin, same thing, completely different context, completely different story. So many vivid memories, but they're not the same.
In addition to trying to get or obtain information about statements of the defendant, was there physical evidence
Moving
that was
on.
important?
Yes.
Was there any data evidence that any of the team from the Massachusetts State Police, were you aware of them pursuing any data type evidence?
Yes, there was.
Was there some phones involved?
Yes, there were.
What phones did you understand or pursue that you thought might be helpful for your investigation?
For one, Mr. O'Keefe's phone was a device that we were looking into. We also had seized the defendant's phone, and we're attempting to access that device.
You heard the question.
There was other digital information that we were seeking as well.
Was the potential data from the defendant's Lexus important to the team of investigators?
Extremely important.
And did any of your team or the team pursue that black box, so-called black box data?
Yes, we did.
You were asked whether you interviewed or present for interviews of Nicole and Brian Albert?
Yes.
And after you spoke to them, including and considering all of the prior information you had, was there any evidence that John O'Keefe went into 34 Fairview Road on January 29, 2024?
There was not.
Relative to the information that could be stored in the computer systems on a Lexus, do you know which troopers, or do you know if Trooper Galino was involved in any process regarding that?
Yes, I do know. And yes, he was involved in conducting that portion of the investigation.
As part of the investigation, was it important or was it considered to look at John O'Keefe's phone to see if there was any specific or particular information on it that would be helpful?
Yes, it would be.
What were you looking for? What was the team looking for on Mr. O'Keefe's phone?
Well, the all-encompassing data includes location of the device. It includes communication, the party's identity with whom an individual could possibly be communicating. In this case, Mr. O'Keefe, his text messages, phone calls, emails, other applications like Signal and WhatsApp could have been also in use.
How about voicemails?
Voicemails, yes.
Did you ever review or consider any of those things that you just mentioned in your investigation?
Yes, I did.
Speaking of interviewing witnesses, did you, along with Michael Proctor, interview Katie McLaughlin on January 30th, 2022?
Yes, I did.
Was this the very next day?
Yes, it is.
And as part of your investigation and the direction and scope of your investigation, did you consider the interview with her and what she might have told you?
Yes, it was.
And when you were speaking with her the very next day, is there any statements that she attributed to the defendant that you considered in the next days of your investigation?
Yes, there was.
Do you remember what she told you the defendant said that was part of your consideration for your future investigation?
Yes, I hit him.
Objection, Your Honor.
I'm going to allow it. Remember that the statement is not being offered for the truth of the statement, but simply to show that the information is provided.
Did the statement that Katie McLaughlin attributed to the defendant that very next day, January 30th, 2022, did that shape your investigation at all?
It helps attribute to the investigation. Again, all the evidence, all the statements, all the digital, all the circumstantial, all of that information is coupled and then put together, capped off by the defendant's statements herself to form the case.
All of the evidence and information capped off with her statements. Sure sounds like how Hank tried to present it in opening, huh? Not that it's a I hit him case.
By the name of Brian Laughlin. When did you first hear or learn of that name?
Lucky.
It was quite some time after the case had made its way through the court system.
When you learned of his name, did you attempt to speak to him?
Yes.
And before you spoke to him, were there any issues you identified relative to Mr. Laughlin before you actually spoke to him?
In regards to him, no, I didn't know him. I've never met him.
Did you, in fact, speak to him and interview him?
Yes, I did.
Was that interview, did anybody attend that interview with you?
Yes.
It was asked whether or not there was a car that was seen. And that was what type of car?
Ford Edge.
Was he specifically asked whether or not that was a Ford Edge owned by the Albert family?
In our interview?
Yes.
I don't remember specifically, but it is along the line of questions that would have been in my report and transcription of the audio recording.
Oh, you audio recorded an interview?
And
You
one
know how to
last
do that?
interview, did you speak to Brian Albert Jr.? Or did you consider a report of his interview?
I saw a report and
Did you
considered.
attend that interview?
I did not know.
What did you understand his relevance to be in your investigation?
He was at the home, at his parents' home, when some of his relatives and parents' friends came back to 34 Fairview.
And after you considered that interview, did it change your perspective or knowledge about whether anybody had suggested that John O'Keefe went into 34 Fairview Road that night?
No, it did not, no.
When I asked you questions earlier on in the case, days ago now, we went through a number of pieces of evidence that was found at different times at 34 Fairview Road. Do you remember those questions and going through that process?
I do remember, yes.
When we went through that process, were there any items that I did not ask you about?
Yes, there were.
And the items I did not ask you about, were they retrieved or found on different dates?
Yes, they did. They were, yes.
And the items that I did not ask you about on those different dates, do you remember how many different dates other items were found?
I want to say 3 different dates.
And on those other items I didn't ask you about, who recovered those items of evidence from 34 Fairview Road?
Michael Proctor.
Were you with Michael Proctor on any of those 3 dates when he turned in or reported the recovery of other evidence at 34 Fairview Road?
I was not, no.
And do you understand whether anybody was with him on those 3 dates?
I'll allow that.
My understanding that nobody else was with him.
And I did not ask you about any of those pieces of evidence?
No, you did not, no.
On cross-examination, you were asked about those 3 pieces of evidence?
Yes, I was.
Were you shown what are now exhibits containing pictures and a photograph of the bags in which those items were bagged?
Yes, I was.
Do you have those physical pieces of evidence?
I do.
Now I'd like to ask you about those 3 pieces of evidence. Was there evidence produced from February 8, 2022?
There was.
Who produced that evidence?
I was Michael Proctor who recovered it.
And you were not there that date when he recovered the items?
I was not, no.
I'd ask you to retrieve 7-13, the items that were found on February 8, 2022.
Yes, sir.
Do you have gloves?
I do.
Do you have gloves? We got to make sure we go through the theater correctly. Don't forget your role. Don't get out of character. Oh, we might be back for recross tomorrow. Oh my goodness. Handle all those bags before you handle the scissors and the mic.
7-13.
The mic. Make sure to handle the mic before you handle the bag.
No objection.
Exhibit 128.
Can you describe what is in that bag? And if necessary, you should open it and show it to the jury.
The description is 1 large piece of plastic, red in color, 1 small piece of red plastic, and 1 piece of black plastic. I will open it to further show.
Make sure you kind of stab the bag and like cut your fingers. There you go, the hand that grabbed the scissors. Now handle it with both hands, including the one that just touched the mic. Yeah.
This one's labeled 22-02-184-7-13 as the bag, and this is letter number or a letter labeled A as an alpha.
Now handle the other items.
Could you again tell us the date that was recovered?
This was recovered on February 8th, 2022. This appears to be a black piece of plastic, same identifying numbers, but this one is labeled with the letter B as in Bravo. This small piece of red plastic is not labeled.
Thank you. You mentioned this was on February 8, 2022. Earlier in, are you done with that package?
Yes.
Earlier in your testimony, you had shared that you went back to 34 Fairview on February 10, 2022.
Yes, I did.
And on that date, you recovered pieces of taillight.
Yes, I did.
At that point, on February 10th, 2 days after that February 8th production, Was there still any snow on the ground at 34 Fairview?
Yes, there was still snow on the ground. Obviously not in the amount that was there the first day.
You said before it was the piles.
The
Piles.
second production from Mr. Proctor, do you know what date that was?
Don't hold me to it. I want to say the 11th of February.
And did you bring 7-14 and 7-15 with you?
Yes, I did.
Could you produce those, please?
Oh man, this is going to be the end of the day. Looking at more pieces of plastic, all kinds of bad evidence handling practices. You said before it was the piles of snow that CERT team had shoveled that were left on the ground. But of course,
Let's take one at a time, please.
7-14 and 7-15.
Let's start with
Carefully
7-14.
sifted
I'd like
it.
to move that into evidence, please.
No objection, Your Honor.
Exhibit 129.
Thank you.
Regarding 7-14, can you show us what Mr. Proctor found on February 11th, 2022?
Yes, sir. There appears to be a variety of wax, like stamp bags, as well as plastic containers. And this is consistent with having glass in it, as it was earlier.
Does the packaging, it seems different than the other bags. Is there any reason you know of that the packaging is different?
It appears that these are small fragments of glass, so for safety reasons, it appears that they were placed into a hard containers to prevent injury or maybe possibly losing it.
Could you just hold up a few examples for the jury to see?
Yes.
Handle them all. Make sure you handle
This
them all.
one here is labeled 714 and then A. This here is B. This here is C. And then there's fragments in here.
You don't need to take them out, just describe them generally.
Small pieces of what appears to be glass inside the wax paper.
If you can rebag all that, we'll move to the next item.
Yes, sir.
If you're going to change his gloves, you got to commit to the bit. Oh, no.
7:15?
No, he's not going to change his
Please, I'd
gloves
move
in between
7:15
items.
into evidence.
Mr. Jackson?
No objection.
Were 7-14 and 7-15 the two separate bags both found on February 11th, 2022?
I can confirm that as soon as I look back at the bag.
Exhibit 130.
Yes, February 11th.
If you could open that and show the jury.
Yes, sir.
I mean, of course, it doesn't matter anyway. Golf theater, but ran into a little continuity problem there.
This item is labeled with the same limbs number 715 and the letter A.
Boy, Bev's got a strong big downturn mouth now too. So many frowns
This is
on these
two
faces.
pieces of clear plastic that are taped together. The longer one here on the left is labeled H, and the one on the right is labeled F, if my eyes are not failing me. This is a canister labeled debris collection with the same numerical identifiers.
What is the debris collection
When would you use a canister as opposed to just
container
putting it
doing in
or
that
a plastic
bag?
Is there a reason it's in a canister?
I do not know the reason behind it. I would strictly be speculating.
Hey,
This small red piece of plastic is labeled E as in echo.
Why is it in that bag? This is supposed to be what the lab got from
There are
his
more
shirt?
small pieces of that, similar to that size that I just showed, but
very well. If you can rebag that.
What on earth is it doing in this bag?
You mentioned there was 3 different days where Mr. Proctor found pieces of taillight at 34 Fairview. I'd like to go to that last day.
that'll be the 18th, I believe, of February.
Do you have a bag?
I do.
Could you produce it, please?
Barehand it first before you rub your gloves all over. Oh no, okay. Gotta
It's
get the gloves on
7-16.
first.
Yes, it is.
Do you have it?
I do.
I'd like to move that into evidence, please.
No objection, Your Honor.
Exhibit 131.
Thank you.
Come on, it's late in the afternoon. Give us something to entertain us.
If you could open it, please, for the jury.
Yes, sir.
Handle that mic with your gloves. Oh man, the discipline is terrible. Glove discipline
This one's
is so
labeled
bad.
B.
Oh, and now with the other hand, make sure you rub both hands all over the dirty
Here we
mic.
have 3 red taillight pieces taped together. Appears to be mechanically fitting, labeled A, C, and D.
Do you typically label items?
No.
Do you know where those labels and the taping come from?
I believe that's from the crime lab. They identify each item according to their protocols to help them facilitate their portion of the investigation.
Pretty remarkable that 218 found all 3 of these pieces from the same area that just happened to fit together. Pretty remarkable.
Small clear piece of plastic labeled E as in echo. Small piece of clear plastic labeled G as in golf. And another tin canister labeled piece of plastic.
Thank you.
Yes, sir.
You earlier mentioned that the tow truck brought the defendant's Lexus to the Canton Sallyport. Do you know if there's a video depicting that arrival?
Yes, there is.
With the court's permission, I would like to play a portion of Exhibit 127.
Okay.
Have you seen that video before?
Yes, I have.
What does it depict?
It depicts a tow truck from Diamond Towing arriving at Canton Police Department, followed by my personal pickup truck that we're following the vehicle in.
That video, that's before the video of being in the Sallyport?
Yes, it is.
When you were considering the physical pieces of evidence as part of your investigation, were you considering the weather conditions that night?
No.
Yes.
When you were evaluating pieces of physical evidence that were found at 34 Fairview, were you making any assessment about their location or depth or closeness to the ground when you were evaluating them?
Yes.
And why were you considering the closeness of items to the ground?
Oh, good Lord.
Well, common sense will dictate that if a item is found on the grass and there's snow covering it, that it would have to have been placed prior to the snow accumulating. If an item is shoved into the snow, it will be exposed as the snow melts prior to it reaching the ground level.
If it were shoved in, why would that occur to you? That someone would
to-
shove it into the snow?
Would the court's assistant retrieve?
What if it were just placed on top of some snow and not actually shoved in? How would the
Exhibit
snow melt then?
85. Yeah, approach.
Yes.
I can't believe he said shoved in. Oh, man.
I'm sorry.
Just right across there.
My apologies.
No, that's okay. Sure. I'll bring it.
If it had been shoved in, it would be
Some
different.
questions while we wait?
I can't.
I didn't go with your mom on the shoved in, guys. No. I didn't go there.
When you retrieve pieces of taillight on February 3rd, did you consider their location, not only where on the lawn they were, but about the depth of where they were found?
Yes, I did.
And based on the items that you found on February 3rd, how close to the ground were they?
They were on the ground, or in the instance with the hat, it was frozen almost in a solid piece to the grass blades, to the ground.
And was that significant to you, how the hat was found?
Yes, it was.
Frozen to
I
the
could
grass
have
blades.
99 feet.
The rock solid grass blades. Remember how hard is the rock? They would have to be to cause that injury to John's head.
And we now have 99D. Beneath the hat on the left side next to the ruler, what do you see?
Yellow grass and a leaf, I believe, a brown leaf.
Was that of importance to you?
Yes, it was.
Sure does look like they dug straight to it, doesn't it? Well, footprint right
If you could
there.
turn the
The
lights on
bottom
and take
left.
that down, please. Thank you, sir.
But the hat ain't one.
85. Could you take the item out of the bag, please, sir?
Yes, sir.
Handle the mic a couple times first. Make sure you do that once you have your gloves on. The jeans. Are you going to show us the ripped back pocket again?
Can you look at the
Indeed.
back of the pants, please? As part of your investigation and the significance of the evidence, did you consider any debris on the back of the pants as part of your analysis?
He doesn't know how to answer that.
Yes, the grass stains on the left,
Objection.
the appearance of the
Go ahead, I'm sorry.
the staining that's taken place or had taken place on these jeans was significant in the fact that it appears to be green and grass stain.
What did that suggest to you as part of your evaluation of your investigation and the decisions that you made?
What about the stains on the front of
It
those
suggests
pants?
that Mr. O'Keefe impacted the grass area with his left glute, transferring green staining onto his pants.
Are you or do you know from your investigation the amount of snow that was on the ground at about 12:32:09 to 12:32:12 on January 29th of 2022?
Yes, based on my investigation and review of video from surveillance footage, it appears to be very little to a coating of snow in some areas.
You could repackage that for us, please?
Yes, sir.
Your piece pants. I have just a few final questions for you, Trooper Bukhenik.
Yes, sir.
You were asked questions about interviewing Brian Higgins,
Yes.
and you shared with us that he provided you a number of text messages between him and the defendant.
Yes.
You began to explain that you vet information during your investigation.
Yes, we do.
What did you tell him you were going to do with the messages he was giving you?
I explained to Mr. Higgins that we have in our custody and will eventually get into both the defendant's phone and Mr. O'Keefe's phone, so that protect his integrity as a law enforcement official. I told him that the information he was providing better be true and accurate, or else he would suffer the consequences of the ulterior.
Why would
Did
you
you in
even think
fact
that?
vet what he gave you?
Yes.
And
Why would it
before
even
you
cross
vetted it,
your
did he
mind
make any
tonight?
changes, additions, or subtractions from that information?
No, he did not.
And when you vetted that information, was there anything different from the alternative source, that being the defendant's phone, from his phone?
Not that I noticed, no.
Your Honor, that exhibit or that document has been marked for identification. I'd like to introduce it as an exhibit.
Check.
Identification number is that? My apologies. I'll need to look. I don't know the number offhand.
I think the clerks might have it.
It's marked for identification.
Yeah, it's actually marked. It was EE, now it's,
Oh, it was introduced.
it was.
I didn't realize that this has been introduced as Exhibit 115.
Yes, the texts are already in.
As part of your investigation, did you look to see if there was any animus or difficulty between Mr. Higgins and Mr. O'Keefe prior to Mr. O'Keefe's death?
Yes,
Did you look at text message records to see if there was any motive that was
Now he knows what a motive
evidenced in
is.
those text messages for Mr. Higgins to want to murder Mr. O'Keefe?
I did look.
May I approach?
Yes.
I handed you a document. Do you recognize that package of materials?
Yes, I do.
And what is it?
It's the extraction printed out from Brian Higgins' phone, dated 2/3, meaning February 3rd, 2022. And it is a conversation between the defendant and Mr. Higgins.
Does it extend a number of different dates?
Yes, it does.
Did you look through those conversations or text messages to identify whether there was any animus or motive?
Yes, I did.
I'd move to introduce those documents as the next exhibit.
Thought we already had Karen's text in.
Did you find any?
Hold on.
132.
Thank you. Trooper Bukhenik, did you find any evidence in the conversation?
Hold on, I'm sorry. Proceed.
You guys. You guys.
Sorry, go ahead.
My apologies.
No, that's okay. So,
Problem is definitely not all
When you
inside his
studied the
head.
materials, the conversation, communications between Brian Higgins and John O'Keefe, did you find any evidence shaping your investigation that there was a motive to harm, hurt, or murder Mr. O'Keefe by Mr. Higgins?
No, there was not.
So clearly, unless they say explicitly, I
further
have
questions at
motive
this
to
time.
murder you, there's no motive,
Your Honor.
no evidence.
If I may?
sure.
Few things that have been left on the table so far. Karen's passcode. He hasn't mentioned that yet. Don't know if we're going to get it out in recross. But
You
them
just
having
asked about Brian Higgins and your
Karen's
interview with
passcode.
Brian Higgins. Where did that take place?
In Sharon at a, an attorney's office.
At his lawyer's house, correct?
I'm not sure if he resides there, but it was an office.
With his lawyer present, correct?
Yes.
Did you find that unusual?
Objection.
Sustained.
He wasn't under arrest, correct?
No.
You hadn't read him his rights.
No need to know.
No need to, because he wasn't in custody, right?
Correct.
He was just a witness in a case that you're investigating.
That's correct.
But he asked that you interview him in his lawyer's presence, correct?
Yes.
You were asked about any evidence of Brian Higgins having a motive to murder John O'Keefe just a few minutes ago by Mr. Brennan, right?
Yes.
And you said, no, I didn't find a motive that Brian Higgins would want to murder John O'Keefe. Is that right?
That's right.
What about a motive to confront him about a girl he was interested in? Did you see that?
I believe the text messages speak for themselves. Everybody heard me read them out loud.
Yep, the text messages do, but I'm asking you. You were just asked about your opinion, whether or not there was a motive that you found for Brian Higgins to want to murder John O'Keefe. I'm asking you a different question. Did you, in your mind, in your opinion, after having read those texts, find a motive for Brian Higgins to perhaps want to confront John O'Keefe because of jealousy?
If you're asking for my opinion is that he would need to confront Mr. O'Keefe. Mr. O'Keefe was not the one pursuing Mr. Higgins. It was your client that was pursuing Mr. Higgins.
Okay, so, well, the text messages, like you said, speak for themselves. You'll agree that show that there was a mutual interest, right? It just wasn't one-sided.
At times there was flattering text messages from both sides, but your client reached out to him first.
Right. I mean, somebody's got to reach out, right? Everybody's got to reach out to somebody. First, someone's got to do it first, right?
If there's going to be a conversation.
Depends.
Doesn't mean that there's not mutual affection for one another. Is that right? Or at least perceived mutual affection.
Felt like that from the
I don't understand the
beginning.
question.
Did you
Super
see those
interested
text
in you,
messages in your
attracted to
mind?
you.
A motive that might lead to jealousy on the part of Brian Higgins.
No, I think Brian Higgins was pretty clear in his request for explanation of what the defendant wanted out of this, and stated that he's friends with Mr. O'Keefe. So he wanted clarity from the defendant about what was going on.
Actually, sorry, go ahead.
I didn't read it to be that he was jealous as I sit here thinking back on the content.
What about after drinking Jameson and ginger all night long and sending a text that said, well?
Objection.
Might that
Jameson and
change things?
ginger.
I don't know what Mr. Higgins's state of mind was. Well, could mean many different things. They could have had a face-to-face interaction, a look. We'd be strictly speculating what was intended by that, or was the intent of communication by that text message.
After weeks of communicating with Ms. Reed in a romantic manner, and then seeing her walk in the door with John O'Keefe and sending the text message, well, after having been intoxicated, you see that, detective, as an investigator, as a reasonable, objective investigator, as a possible scenario for Brian Higgins to be jealous about John O'Keefe.
There's a possibility there, but I didn't see it.
Did you explore that possibility when you got all these text messages?
We did not follow up on that aspect based on the totality of the entire investigation.
Did you pull the tape at the waterfall and review the tape as we did here in court?
That happened, yes.
Okay. Did you see on the tape a time just before Brian Higgins left the location where he was confronted by Chris Albert?
Objection.
Change the wording.
Sure. Did you see a circumstance, did you see a situation on that tape where Brian Higgins is standing and Chris Albert physically puts his hand on Brian Higgins' arm, on his left arm?
I don't have a specific memory of that.
You remember a circumstance on that tape where Brian Higgins pulled his arm away and looked past Chris Albert over toward the bar, which is where John O'Keefe was standing. You see that?
I do remember you pointing that out, but we couldn't tell him who exactly he was looking at based on the video.
Did you see a circumstance in which Brian Higgins then put his hand on his forehead and began rubbing his forehead like this?
I don't have a memory of that.
Did you see a circumstance in which he then motioned over toward that side of the bar with his left hand?
That I remember, yes.
Did that seem realistic to you? Let me ask it a different way. Did that seem to you as a reasonable interpretation? Hey, come on outside. Or come here.
Very reasonable, since they've been invited to 34 Fairview.
Did it look, in your opinion,
Like an invitation?
just a hey, let's go together, or did it look more to you like, hey, come outside, or let's step outside?
The totality of the investigation, the fact that when they stepped outside, there was no confrontation and they were invited to the address. Again, totality of the investigation suggests otherwise.
Let's talk about that totality of the investigation. You're aware that Brian Higgins left first. He was the first to arrive at 34 Fairview, even before Brian Allen.
I am, yes.
And you're also aware that John O'Keefe and Karen Reed were among the last to arrive. So they didn't step outside together, right?
They didn't step outside, but once he was invited, according to your narrative, wouldn't they have a discussion outside where he was invited to come out?
So, Mr. Jackson, I just want to ask you, how much longer do you think?
Not long. I can finish this up if you give me probably 10 minutes.
Okay. Jurors are saying yes. Is it okay with all the jurors? We usually break at 4.
I don't want to overstep. I'm happy to stop now, but I think I can get it finished.
I'd like to finish with this witness and not have to bring him back again tomorrow. Thank you.
Thank you, Your Honor. I appreciate the accommodation.
Third full day for Yuri, but that's
You're
going to be
aware
it.
that, according to the tape, John O'Keefe left about 10 minutes after Brian Higgins, or so.
I'll take your word for it.
Okay. You would agree, as a homicide investigator, not every death starts off as an intended murder, correct?
I will agree to that.
Sometimes a fight could go wrong, and you intend to fight and duke it out. Something goes wrong, something goes south, someone dies, correct?
Objection.
Is that something that you it's beyond the scope? So move along.
Beyond the scope.
You were asked on redirect examination about taillight pieces that were found by the CERT team. I want to ask you real quick about that. Your testimony was you recall that the CERT team found a large piece of red taillight material during their initial search. Is that correct?
That's my recollection, yes.
Okay. Did the CERT, you had a debriefing with the CERT team, correct?
Not the CERT team. I had a debrief with the members of our unit at the Ken PD conference room. I do not have a memory of the CERT team being there.
Do you recall ever being told or informed that the CERT team actually recovered maybe 5 or 6 pieces, maybe 7 pieces of small plastic material in addition to the shoe? As opposed to a large piece of red taillight?
The memory that stands out to me that I have is that there was a large piece of plastic recovered. It wasn't a shard. It was significant enough that, shown on the photograph taken by Detective Lieutenant Tully.
And do you recall that the CERT team, or were you ever informed that the CERT team found those, according to the CERT team, within inches of one another, within about a 2-foot square radius?
I don't have a memory of where they found them exactly. I wasn't there.
Okay. You were asked about the taillight. You were shown a photograph of the taillight where almost the entirety of that lens material is missing, gone, correct?
Yes.
And you remember talking to Jen McCabe originally, interviewing her within days of this incident happening, correct?
It was The 29th, we
As a
interviewed.
matter of fact, the day.
That day is.
Do you remember her saying that the taillight was cracked/broken?
She communicated that over the phone to Michael Proctor, which was then documented later on in the interview report
Okay.
from
In that
earlier.
I'm sorry, go ahead.
And it was documented within the interview report.
Okay. And in that interview report, it doesn't say the entire lens cap of that taillight is gone. Correct?
Correct. The report does not say that, no.
And she didn't describe that, did she?
I don't know what she described to Michael Proctor over the phone.
You pulled out a pair of jeans belonging to Mr. O'Keefe just a second ago.
Yes.
And you noted that on his, what would be his left rear pocket, there was a stain.
Yes.
You said that that was an apparent grass stain and it was green.
Based on my observation here holding them, that's what it appeared. Yes. Maybe dirt, maybe other substances.
That was my question. Did you seek to analyze what that discoloration was from? Or have caused that to be analyzed by the crime lab or anybody else?
The genes were processed. I don't know what their protocol is to analyze it. They process those genes. There's pieces missing from cuttings and stuff like that.
Understood. So as you sit here, you have no evidence at all that those are grass stains, correct?
Strictly my experience of knowing grass stains and observing it.
Could be dirt,
Could be.
could be oil or grease.
I don't know about that, but
They look brown. Stains look brown, doesn't it?
there's different parts of the stain. Some has brown, some has green, different parts of it.
Could you get, in your experience, stains on the back of pants from being dragged?
I've never dragged anybody, so from my experience, I can't tell you.
Never
I didn't ask if
dragged
you ever dragged
anybody?
You've never murdered anybody either, but you're a homicide investigator, right? Did you get those stains from being dragged? It's just a common sense question.
My common sense dictates that it was not a drag, a mark, because it would have linear characterizations, and it would be both buttocks that are engaged in contact with the ground while being dragged.
What if he was being dragged and he had something in his pocket, or being dragged at an ankle? Dragged through a crease spot that was only on the left. What about all those possibilities?
Again, my opinion, common sense dictates it was not the case.
Common sense, huh?
But you certainly didn't take
You're
any
to
action
reject
to investigate
these possibilities.
forensically what those stains actually were.
I did not know.
By the way, can you lose a shoe from being dragged?
It depends. I guess you can, depending on how loose it is.
You said that there was no information that you had regarding Brian Higgins and John O'Keefe having any animosity toward each other prior to January 29th, 2022, correct?
Correct.
But you did, we talked about, now let's talk about on January 29th, 2022. In your experience, does drinking alcohol increase the likelihood or increase the possibility of getting into an altercation?
I would say, in my experience, in my opinion, the alcohol could become a social lubricant and exacerbate emotions. But to speak in a definitive form here, I can't.
You've heard of beer muscles. That's a
Beer
common
muscles?
phrase, right?
Never heard that before. No.
I've never heard that before
Beer
either.
guts. You ever heard that one?
I've heard of beer gut, but not beer guts.
Having the guts to walk up to someone you might not otherwise walk up to in a bar because you've had too much to drink.
No,
Is
beer
that what beer
goggles.
muscles could mean?
I would say maybe liquid courage,
Liquid courage.
What does liquid courage mean?
giving you courage that truly shouldn't be there.
That you might not otherwise have if you weren't drinking.
Yeah. Yes.
Can we wrap this up, Mr. Jackson?
I'm trying, Judge. I won't be much longer. You had evidence that Brian Higgins had been drinking most of the afternoon and evening that night, or most of the night, that evening and night, at the time that John O'Keefe and Karen Reed walked into the waterfall, correct?
I had information that Brian Higgins had returned from a police officer's funeral and then went to Waterfall after he
Went to the hillside
changed
first.
clothes and took a shower.
Went to the hillside before he went to Waterfall, started drinking there, correct?
I don't have an independent memory of that, no.
But you did, at the time, you didn't pull the tape at Gesundheit. At the time, you didn't pull the tape at CPD that we saw with Brian Higgins on the phone at 1:30 in the morning, correct? You didn't have that information.
I'm sorry, can you give me a reference when at the
Sure.
time?
At the beginning of your investigation, January 29th, and probably the next, let's call it a couple months.
Mm-hmm.
You did not have that information, correct?
No, we did not.
And you didn't seek that information from CPD at that time.
No, I had no information that he went there.
Okay, and you didn't extract his phone, correct?
That's correct.
And finally, you indicated that you were asked on redirect examination, did you have any evidence that John actually went into the home? Did you ever interview Trooper Guarino during the course of your investigation, at any time?
Interview him?
Talk to him
No.
about his extraction of John O'Keefe's phone and any of the data that came off of his phone.
No.
You did not realize that Trooper Guarino had information that John O'Keefe took 36 steps covering a distance of some 84 feet that would have placed Mr. O'Keefe inside the residence at 12:32:16.
Objection.
Did you have any information from Trooper Guarino about steps that were logged on Mr. O'Keefe's phone?
No, I did not.
Is that it, Mr. Jackson? You said finally, that's what I'm wondering.
May I have just a moment?
Yes.
I'm trying to wrap this up. I only have a couple more things, but I may be able to finish it with one question. As you sit here now, are you aware of whether or not there's evidence that John O'Keefe, the phone describes John O'Keefe's phone taking 36 steps, covering a distance of about 84 feet at 12:32 and 16 seconds on the morning of January 29th, 2022?
Objection.
Can you answer that? Are you aware of that?
I am not, Your Honor.
Okay, the answer is,
The answer was,
No, I'm not aware of that.
all right.
Brutality of the
I
investigation.
appreciate you staying late. So Trooper Bukhenik, we do not have to recharge.
Thank you, Your Honor.
So
Thank you.
folks, those same cautions, please do not discuss this case with anyone. Don't do any independent research or investigation into this case. If you happen to see, hear, or read anything about this case, please disregard it and let us know, and be careful with your social media use. We'll see you tomorrow morning.
It's funny how the totality of the investigation can always point squarely at Karen Reed when you ignore the stuff that doesn't point at her, like the steps that don't fit your timeline. Like the text messages, the motive, now that you recall what that is, what a motive is on redirect. Now that you recall what a motive is, nothing about jealousy of any kind. Because we got to switch back and forth between the totality of the investigation and then, of course, common sense. Common sense. Ooh, that's a tough one because, you know, the jury gets to exercise their common sense in the jury room. They'll be specifically told that. Your common sense doesn't align with the jury's common sense about something here that suggests maybe Brian might be jealous of John O'Keefe. You might be out of alignment with the jury on that one. And they're not going to necessarily trust your interpretation if you see things so differently from how they see them. Just waiting to see if they come back and do anything else here. Probably not. We do still, of course, have that motion outstanding about Aruba. But we're just waiting to see. Of course, as soon as I take it off, they'll come back. Well, I'm going to go ahead and gamble. Well, so we started off with the voir dire right after lunch. So Hank won his motion to that extent. There was going to be some limited voir dire of things to be asked about. And this is those text messages that Michael Proctor had with other people, ones that Bukhenik himself wasn't involved with. So the relationship with Julie Albert and those texts about the gift that should go to Elizabeth. Judge Bev is not allowing those because he claims he knows nothing about them. Apparently, still to this day, knows nothing about them. Totality of the investigation he relies on so thoroughly that just coincidentally fails to turn up evidence that tends to impugn their conclusions. But so that's pretty clear. It's got to come in through Proctor. Proctor, or one of the other witnesses who was part of the conversation. So the pathway for the defense there is very clear. If the Commonwealth doesn't call Proctor in, they're going to have to if they want any of that in. I can't dispute that, as an evidentiary ruling. That's appropriate because he can't authenticate something he's not aware of. And so we can't presume that it's in or that it's admissible, something to be talked about substantively at this point in time. So then the jury came back and we had that stipulation to the authenticity of the Sallyport video. Hank Brennan says he's not gonna object to the defense bringing it in as long as there's a stipulation to authenticity. And Mr. Jackson said he's not raising any issues regarding the metadata. Well, no, they probably never got the metadata, right? That was what we learned from pre-trial. Metadata was going to be destroyed by how the Commonwealth was handling the video. There was the whole series of actions to try to compel a forensically sound copy of the Sallyport video. Commonwealth was advised their method is going to erase the metadata. They did it anyway. But apparently those issues are not going to come out at trial. Authenticity stipulated to. Well, we can see with our own eyes, people apparating in and out, that whole problem. Didn't show us the timestamp. That's what I would really like to see. Did the timestamp jump? Because their explanation in the first trial was, well, it's motion. These cameras are all motion activated. And that's why people jump in and out. It doesn't really make a little sense because we're seeing action happening in the video when people are apparating in and out. So I'm not sure that's the greatest explanation, but if that is the explanation, then just like we saw in the hallway video with Brian Higgins, you would expect the timestamp would jump. So does the timestamp jump to show, lost section of time? Or does it run continuously? I don't know. Jury has the video. They can watch it if they want. But that was a question I had after all of that came in. Just not real sure. We got it hammered home that he testified at the prior trial that that video showed him and Michael Proctor going nowhere near the right rear taillight. That was the issue. Not just that it was inverted, but it was misleading because of how you talked about it. I'm not sure that got hammered home. And then the fact as well that the fact that it was mirrored didn't even come up until cross. Was not elicited during the direct examination with Mr. Lally, where they were discussing this video and what it showed to the jury. It was the defense that had to point out on cross-examination, oh, and by the way, this video shows the opposite of what you think it does. That didn't get brought out. So just some opportunities with the video that I'm not 100% sure, fully took advantage of everything that's there. But definitely taking the chance to point the finger at Berkowitz. Right now, Chief Berkowitz is dead. Chief Berkowitz is not going to be available to come in and testify as a witness one way or the other. But we're identifying him in these videos, suggesting he was the one that was there at the search. So he's the mule for the taillight pieces, perhaps? Is that the implication? It's very, very subtle, if that is the implication. Not sure that the jury has picked up on that. That might have to be made a little bit more explicit somehow, but I'm just not sure how they would do that. They might just have to do it in argument. Not sure that that has really been hammered home. So we got to watch both the inverted and then the corrected one. We did see that missing time where it was 5 seconds, but it was really, 43 minutes that was missing based on the timestamp. Oh, that was the opposite wall. My bad. That was the opposite wall. All right, the live stream is done, so I am going to go ahead and just take it down now. That was the opposite wall that was missing the 43 minutes, the one that would have had the direct view of the tail light right there, right in your face, and just happens to be missing those 43 minutes when the SUV was brought in. That's where he concluded the recross after lunch. Also, the only other thing I can think of that I don't know what their theory is or how they're pursuing and arguing and stuff like that. But John O'Keefe's phone to me is such an important piece of this case, particularly the chain of custody. There's the implication that was raised. Yeah, MPD is who got into the Ring app on John's phone after it was in their possession. So there's concern about the integrity of this evidence, the chain of custody, and potentially tampering with it. But there's also Karen's phone. They're the ones that took Karen's phone, and they got the passcode that came out at the first trial. Bukhenik testified to it. Proctor also testified to it. They watched her enter her passcode during the interview at her parents' house, confirmed it with her. But we heard Trooper Guarino say they couldn't even get into her phone until July because they didn't have the passcode. So to me, that is a big discrepancy. And maybe it doesn't matter. Maybe it doesn't matter for purposes of the case because we're not going to try to make anything about whether they got into her phone before that. I mean, I don't know that we have proof that they did. So maybe it just doesn't matter and there's no reason to get into that. But it is a discrepancy. And it seems to be an important part of the story of Karen's phone as well. Guarino saying we didn't have a passcode. That's why we couldn't get into it until July. Bukhenik and Proctor both saying, oh, we got the passcode. We watched her put it in and we confirmed it with her. So you could have gotten into the phone earlier, but you didn't. Don't know about that. The redirect. This redirect. I mean, missed or, deliberately didn't address some of the particularly damaging stuff from the cross. Certainly the group chats, we just let that go. Didn't revisit that in any way. His supervisory role with all that, the honor and integrity and so forth. Just let that lie. Don't try to rehab that. There is no rehabbing it. We all know that. But he's going to introduce a whole bunch of other pieces of video, 6 separate exhibits, none of which is even shown to the jury. So why is this coming into evidence? I don't know, but maybe it's to confuse them about what's what they've seen, what they haven't seen. This is the trial equivalent of the discovery dump. Bury them in video footage from Canton Police Department. Not very useful to the jury to have all of these discs containing video that they haven't even seen, is it? So why did we do that? If we see it in closing, that would be an explanation. Get it in and then use it in your closing. Do you think we're going to see all 6 of these videos in closing? I'm skeptical. I am skeptical. And of course, suddenly Sergeant Bukhenik's memory is restored. Now that he's back on redirect, he knows that CERT arrived at the scene at 4:56 to 4:58. Doesn't need a report to review that, even though he wasn't even there. He can just confirm that information off of his own personal knowledge. Isn't that remarkable? It's a small memory. Perhaps we need to thank the new Pope. It's been restored. He's been healed. That whole nobody ever provided any physical evidence to Berkowitz or any other officer. And he tried so hard. He tried so hard to make that a we. Of course, we never did that. We never did that. No, Judge Bev specifically corrected him again. Don't say we. Testify about what you did. And so Hank had to clarify, you didn't do it. You deny that you did that, and you never saw Proctor do it. But you don't get to speak for Proctor and what he did or didn't do. We've already acknowledged a lot of this stuff, this very evidence that we're talking about, there on his own at 34 Fairview when he recovered it, when he took it into evidence, when he handled the evidence, all the stuff that sat there unattended in the Canton Sallyport. They're rushed back to Canton to do all this stuff. Why? Well, what's the one thing he doesn't mention? Because we had this very important evidence that we've been carrying around in a bag in the back of my truck all day. John's clothes, John's wet clothes that we gathered from the hospital. Somehow that wasn't on his mind at all as part of the reason why they needed to go back to CPD and hang out there after they got the car into the Sallyport. Learned that the CERT team had found the second sneaker in a large piece of taillight. Definitely not what O'Hara testified to. He said 6 pieces. Mr. Jackson caught that, brought that out on Recross. The damage the damage to the tail light there in the Sallyport. So Hank shows him the photo. Guys, go back and look at that photo again, because remember, this one was now taken, 5 days later? This was taken by the crime scene investigators, the criminalists from the lab, once they got there to process the taillight. Haven't heard from them yet. Is Hank going to call them? I have no idea at this point. But the snow is long gone, is my point. The snow is long gone. It's melted off. That was their whole justification for bringing it to this location in the first place. Look what's all over the back bumper. Kind of looks like snow all over that back bumper. That's our view of the bumper sprinkles, guys, right there on that photo. That's the bumper sprinkles we haven't heard about yet, not in this trial. But interesting, he looks at that photo. He can absolutely confirm that it's the same damage that he saw on the SUV in the Sallyport. Why? Because he was within a foot of it. That's exactly the opposite of what he's previously said, where he's denied over and over again that they were anywhere near the right rear tail light. Spin a hole. First trial, bringing up inverted video and narrating it to emphasize the point. We were never anywhere near that right rear tail light. Of course, you're lying because the video is inverted and it shows Proctor exactly there. But that's been your position. You were nowhere near that tail light, but now you're within a foot of it? Oh, you got to pick a story. You got to pick a story, bro. The other evidence of the taillight, the ring video. The ring video was evidence because it showed the taillight shining white. It was not covered by a red taillight cover, which would have produced a red light. Look back at that inverted Sallyport video. Now that we know we're looking at the driver's side taillight, look at that and tell me if you see any white light. It's right there. White light is right there. We don't even have to get into the whole structure of the taillight, the mechanics, the LED colored lights. It's not a white incandescent bulb. We don't even have to get into that. Just look at the other taillight on the driver's side. And it's showing white on the side. Pretty much exactly like we saw on the ring camera video. Went through the whole I hit him narrative. The explanation of why he went to Jim McCabe's house to do the interviews, because he wanted to interview the people who were with the defendant that morning, but you spoke to one who was there, two who were not, and the other person who was there you didn't speak to. And then the firefighter, paramedics, and all those people who were there that morning, you waited 10 days to talk to them. This is an explanation that doesn't add up with the actions that he actually took. You didn't want to interview the people who were there. At best, you wanted to interview one of them. You wanted Jen's story. And then you had other people there who weren't with her, didn't have anything to do with her finding him that morning. Doesn't support your explanation, what you actually did. After that interview, it was very important for him to go see John O'Keefe's injuries and quickly turned him from the glass being thrown that he had previously reported to the ME's office to a vehicle collision because of his arm, because of the injuries on his arm. That screamed, no, this is not flying shattered glass from a cocktail tumbler. Doesn't look anything like that. It's clearly a vehicle collision. He thinks we're stupid. He thinks we're absolutely stupid. Don't think the jury's going to buy that. I mean, talk about common sense. You really want us to believe that? Told you car accident? Anybody on the jury who's ever been in a car accident, anybody on the jury who's a healthcare worker is not buying that. Juror Ronnie told us that the healthcare workers in the first trial, that was their hangup. These are not vehicle collision injuries. But Trooper Bukhenik saw that arm and that told him it's a car. That told him it's a car. So now we have to go look at Karen. We have to see her taillight, but we didn't document it once. That also didn't really get hammered in recross or cross-exam. It's fine. They can argue it. We already know they didn't document it because it's not in evidence. But wasn't specifically confronted with that. Literally the point of why you went to Dighton, according to you, to see the car. You wanted to take a look at the car, and then you didn't document it. You went, you saw the car, you saw what you expected to see. Why? Because remember the explanation, you were going to look at the taillight or the headlights and the windshield first. But then you got that information from Jen McCabe where she described in the call that she had cracked her taillight and then showed them the damage. So he knew it was the taillight. When did he get that information? Because he interviewed Jen McCabe before going to the hospital. So the timeline of the theory evolving doesn't add up either. He already knew the taillight was the focus. By the time, according to him, we knew we're looking at a vehicle because we've seen John's body, he would have already known it's the taillight that's in focus because of what Jen told him. We're supposed to believe Jen told him about the damaged taillight and the thing Karen was saying, but that didn't focus him on a car at that point. He had to see the arm. Suddenly, he remembers every single person who had their hands on this investigation. He can identify them by name. It's a miracle. The way his memory has been restored. Brennan was listing off name after name after name of people involved. Yep, he sure was. He knew that. He read their reports. He was familiar with them. But couldn't remember anything when he was on cross that first day. The black box evidence, that was very important to him. Guarino was involved in it. We didn't hear anything from Guarino about that. Did we? Or did he just introduce an extraction and that was that? If that's an extremely important piece of evidence and Guarino was involved in that piece of the investigation, why didn't we hear more of that from Guarino? My suspicion is we're going to hear from it. We're going to hear about it from either the accident reconstructionist or some other data forensic analyst type person if the Commonwealth has hired somebody. But these are new. These people are new to the investigation, hired long after the fact. So how interested in it were you if your own law enforcement or somebody at the time wasn't involved in that analysis? Because the only name we got there was Guarino. He didn't say anything about it. He identified an extraction and that was it. Okay, but there's analysis needed, right? That's what Jessica Hyde and Ian Whiffen both spent a long time telling us. You got to be able to understand the significance of what's in the extraction. So who did that? Interesting that in trying to rehab what he did and what he learned over the course of the investigation, he brought up, Brennan brought up Brian Loughran and the information that he got? Okay, so first off, audio recorded with a transcript. Is this the only interview so far that we've heard in any way was audio recorded? It's the only one I remember. Anybody remember any other witness interview being audio recorded, or just Lucky's? He knew because he reviewed the audio recording, the transcript that was prepared from the audio recording. But he interviewed him and the Ford Edge. He doesn't remember if he specifically asked him if that was one of the Albert's cars. Now you gotta think about what he didn't ask in this line of questioning. What did Hank Brennan didn't ask? What steps did you take to follow up on this information? A Ford Edge there at the property, a 3:30, is a potential eyewitness to John's body being there or not being there. This is extremely important. And yet nowhere in this is a question about what did he do with that information? What did he do to find out who the owner of that Ford Edge was? Why? Because he did nothing. And that's the totality of the investigation, also includes the nothing that he did. When presented with information that might contradict your theory, they just don't do anything with it. Some more theater. It was even worse this time. Wasn't it worse this time? He literally put the gloves on, manhandled the microphone with both hands, and then touched all the different pieces of evidence inside the bags on top of the dirty scissors and all that stuff. And then the two bags didn't change his gloves. Just handled this one bag, then handled the other bag. It's such ridiculous theater. I mean, once again, I have to assume if there is a healthcare worker on that jury, surely they understand. A healthcare worker who worked during COVID and understands the protocol for avoiding cross-contamination, avoiding keeping things sanitized, the things that are sanitized not being tainted. Surely they know that. This would stand out as a bunch of theater. So he thinks it's grass stains on John's back left buttock, but for some reason it would only leave grass stains on one side if it's a car accident and not if he was dragged. I don't understand the logic at all. I don't understand how that's even supposed to make sense. And as far as Brian Higgins goes, to protect his integrity of a law enforcement officer, making sure he knows we're going to have John's phone and Karen's phone, and so these better match up exactly with what you're providing to me. Why would that even be on your mind? That he might fake it? Might alter it? That the kind of credit you give your fellow law enforcement officers? Huh. Well, maybe the jury should follow your lead then and do the same. Now he understands not only what motive is, but also animus. Suddenly on redirect, he's got quite an impressive vocabulary. And so then back to Recross, starting off with this emphasis that the interview took place at Brian Higgins' attorney's office. I got mixed feelings about highlighting that, of course. Of course, you should always, if you're going to say anything at all to the police, have your attorney there. So it shouldn't be unusual. Shouldn't be weird. Shouldn't draw any inference from it. It should be the most normal thing ever, other than people simply not talking to you at all. That should be normal. But I understand why Mr. Jackson kind of has to highlight this. He's just a witness, so why does he have his lawyer? What's he concerned about? I get it. I get it. Nevertheless, don't love it. Everyone, you should always, if you're ever going to speak, which you probably shouldn't, but if you ever do, yeah, you should do it with a lawyer present. Denying the jealousy. I don't think Trooper Bukhenik trying to interpret these text messages in the way that he is suggesting is common sense and reasonable. No jealousy, no type of rivalry here at all. Nothing. Nothing to see here. I can't imagine that's going to resonate with the jury. And then the Jameson, Jameson and Ginger, we'd be speculating. Okay, but you develop theories. You develop theories based on the information that's presented to you. So you can develop a theory that there was a jealousy motive, and then you can investigate that and corroborate it, right? Because when you first heard, did I hit him? That would have been speculation too. But you followed up on that one. Really sunk your teeth into it. So that would be speculation, but yeah, the jury is going to have their own interpretation about whether that is a common sense thing to do. The liquid courage. I hadn't heard of half of these expressions that Mr. Jackson was using. Beer guts. Beer gut is, the physical. I've never heard beer guts. I've definitely heard liquid courage. Beer muscles, never in a million years heard beer muscles. I've never heard that. I don't know if that was helpful, but liquid courage, definitely heard of liquid courage. I think we've all heard of that. And yes, every single person, again, certainly in healthcare, any relationship with law enforcement, and frankly, most of us, I think with common sense, yeah, people drink alcohol. Alcohol is linked with violence, with fights. People get in fights. Anybody that's, been to college parties on a weekend, stuff like that. Very common sense. It's just such a strange thing to resist, but he has to because of this corner he painted himself into with the totality of the investigation. But that highlights what he didn't pay attention to as much, if not more, than what he did pay attention to. Jen said the taillight was cracked on this January 29th interview. Didn't say anything about the entire lens cap being gone. Is that semantic? I don't know. Maybe. He doesn't know what she told Michael Proctor, so all that's documented in the report was that it was cracked or broken. The stains he never followed up on. It couldn't be dragged. I did like that little quip that Mr. Jackson got in. I've never dragged anybody. Well, you've never murdered anybody either. Have you? Have you? Are we sure about that? You didn't actually ask him. You've never murdered anybody either, but you're a homicide detective. Yes, you can know things beyond what you personally have done. Possible that it was being dragged? No, because it would be on both sides, and also it would be linear. It would be linear if it set and fermented in the moisture, the layer of snow that was on the ground, the small coating, the clothes are soaking wet for hours, sitting in the back of his car. That might affect it. Don't know. Don't know, but definitely can't be a drag if it's not on both buttocks. That clearly means that it only happened from a car accident. Again, just not following this logic. Seems like one of these areas to me where if the jury wanted to believe him, okay, that's his explanation. We can just accept that as his explanation. But you really got to want to believe him. At this point, do they want to believe him? Is that where we're at with this guy? I'm really not sure. Oh, and yeah, by the way, you also could lose a shoe from being dragged. Great point. Great point to bring out. No memory of Brian Higgins drinking at the hillside. I remember that. Once again, now we've got the tainted memory. He remembers very well that Trooper Moore took a report at one point in time. I'm not sure I even know who Trooper Moore is. Remembers he did a report at some time, but no memory that Brian Higgins, when he recounted the events of the day, and also Brian Albert, whose interview he was present at 34 or at 12 Country Road on the morning of January 29th, their timeline of the day, got back from this funeral and started drinking at the hillside before they went over to the waterfall. I remember that. But somehow he's lost his memory again. He doesn't remember that detail. And didn't follow up on Brian Higgins being on the phone. Didn't look for the Canton Police Department video. Why? Because there was no information he went there. So Brian Higgins didn't tell you that when you interviewed him? He didn't mention that he went back to the Canton Police Department? That seems surprising and also inconsistent. And of course, the final totality of the investigation that he relied on to conclude that the only viable theory here was with Karen Reed as a suspect. Totality of the investigation included John taking 36 steps at 12:32 in the morning after Karen's car would have left because she connected to the Wi-Fi 4 minutes later at John's house. Took those steps, but he's not even aware of that. That's the totality of the investigation. If it helps their theory, he knows about it. And if it came up, but it doesn't help him, he's not aware, he forgot, not sure about that. Not sure if the document can be authenticated, et cetera, et cetera. So that I thought was a decent close. I mean, obviously it highlights an important piece of evidence because that is going to be critical to the defense's argument that there was no collision. And that's point 1, 2, and 3 from the defense opening. No collision, no collision, no collision. The 1232 is going to be an important piece of that. So it's good to close on that, both as a reminder, but also because it really does highlight you just disregarded anything that didn't support your case. I mean, you're literally willing to get here on the stand and say, oh, it was his arm that made it clear to me that we needed to investigate a vehicle collision, when all of the medical examiner, the forensic folks, nobody was like, the first responders, nobody was like, oh yes, obviously we're dealing with a vehicle collision because didn't you see his arm? Not a single one has said that. But Trooper Bukhenik, that was dispositive for him. So boy, oh, you guys are riffing on the gloves, huh? He does give Glove a bad name. Oh, brother. Oh, man. He's just a part-time glover. Oh, hilarious. You guys are so clever, so whiffy, so witty, fun stuff. Well, 3 full days with Trooper Bukhenik. That was quite a marathon. It was quite a marathon, but we are done with him. We will get something new tomorrow. Exactly what? I don't know. Remains to be seen. The facts and data and science we've been hearing so much about, are they finally going to start making their entrance? It's got to be soon. We're getting close to the close of the Commonwealth's case. They said 3 to 4 weeks. Here we are in week 4. Should be looking ready to looking about time to be getting it done. I want to turn back to this because I didn't get to answer it before court got into session. Bench trials in general, slow guilty plea. They are a slow guilty plea. There's almost never, in my view, a good reason from the defense side to opt with a bench trial. Judges tend not to be defense friendly anyway. That's not what gets them in their position as judges. They get in their position as judges often because they have recommendation. They're endorsed by law enforcement. Law enforcement organizations, unions, etc., very powerful in politics, powerful lobbyists. So their thumbs up or thumbs down tends to carry weight. You want to win a judicial election in cases where it's elected, you better go and you better court those law enforcement unions. If you're not in a situation where judges are elected, you're being appointed. And who is doing the appointed? The guy who was elected with the support, again, probably most often with the law enforcement unions, powerful unions and stuff. So typically don't tend to be defense friendly. If by chance you have one that is defense friendly, that might be a reason for you to opt to a bench trial. But even that, it's a big gamble because with a bench trial, the burden of proof that the prosecution has, they only have to convince one person. And with a jury trial, you got to convince all 12 of them beyond a reasonable doubt. So convince one versus convince 12 is a lot easier, just from a strategic standpoint. The only other reason where people will sometimes justify it, I already mentioned you got to preserve issues for appellate review, so it's a formality. But there is another circumstance where if you're dealing with a case that involves particularly not favorable accusations against the client, conduct that is, really beyond the pale, but you got maybe a partial defense, or you've got guilty of some, but not guilty of all of it. Situations where guilt or innocence might depend on carefully parsing facts that lay people just may not be inclined to parse that carefully. You hear about some of the accusations and the evidence supporting them, and you're like, yeah, okay, we're done. This guy is guilty of everything. A judge might be more careful about taking things case by case, incident by incident, charge by charge. Those are really the main reasons to proceed with the bench trial. But the overwhelming majority of the time, no, it's a slow guilty plea. So you're doing it for issue preservation purposes. You're not doing it overwhelmingly the majority of the time because you think you'll get a better outcome than a jury. That's my view of it. Little Mighty was the video of the leaf blowing before they found taillight pieces, because there are 0 in that video, which makes no sense. Indeed, it doesn't make any sense, does it? But that is precisely what the timeline is. They went out there, according to Gallagher, Lieutenant Gallagher. It worked extremely well. It was a great method. There was only about 3 to 4 inches of snow on the ground at that time. We heard from the weathermen. We also can see, with our own eyes on the video what they're doing. And they blow away that snow. Not sure that they clearly elicited in this trial that they took it all the way down to bare ground. That did come out in the first trial. Not sure they really hammered that in this trial. But the whole area, approximately 10 by 10, 12 by 12, it might have shrunk now. Don't remember exactly what Paul Gallagher said the area was this time. But the area right there where John was found, fully leaf blowed it that morning, didn't find any of the taillight. And not only did they not uncover it, but like one of the chatters pointed out last week. Great point. They didn't step on any of this. These big, massive pieces that Trooper Proctor is supposedly finding out there on the 11th and on the 18th. Great big pieces of taillight, and nobody likes, you would notice that if you stepped on it. 4 inches of snow is not so much that it isn't going to compact. If there's like a rock under there, you're going to feel it. So not only did they not uncover it with the snowblower, they had no hint that it was there at all. And yes, you're right. It doesn't make any sense. Doesn't fit what you would expect, that you went and searched for it that morning and it wasn't there, but then later on when there's a foot more snow, suddenly you can find it. It doesn't make a lot of sense, does it? Jason McClellan, AJ is building the stack against Higgins' car. Higgins' car, connections to family, Proctor, text messages, closed circuit TV, Jeep Wrangler with snowplow at 34, then Canton PD. Higgins lying about moving vehicles to plow snow. The timeline doesn't fit. You know, he had himself in the first trial going over to Canton PD at least an hour earlier. Never, anything about making a phone call. You can see the phone lit up while he's holding it to his ear. What else is he doing? What else is he doing? What else is he doing with that phone? We see that phone by his ear. Sure looks like multiple times during this video, walking from the Jeep the first time before he goes inside. Then when he's outside again, definitely looks like he's on his phone. Explanation, yeah, I just went there to move cars. He had left the ATF cars there. He needed to move them so that the parking lot could be plowed. Didn't see that. At best, we see one car move, and it's not clear to me that that is Higgins moving a car. That could just be some unrelated person leaving, at least from what I saw. But he's definitely doing stuff with other cars there that's not moving them. And it's weird. Opening doors, getting out of doors, turning on lights. Very peculiar, this activity. And not consistent with his explanation about what he was doing. So yeah, I think AJ is certainly achieving his goal of pointing out that there are questions here that should have been asked that weren't. Should have been asked but weren't. It seems obvious that this guy should be under suspicion given the context, the text messages, the call out, the well, and then you come in here, question mark, question mark, question mark. But didn't pursue any of that because the totality of the investigation, includes these explanations that don't comport with the evidence. Exactly what you said you look for when you try to corroborate a victim's statement or a witness's statement. Piece by piece, that Boden defense is being constructed. Greg, so now Higgins either A, keeps his testimony from 1.0 and gets confronted with the video, or B, changes his testimony and gets confronted with 3 previous testimonies. Either way, he's screwed. He does seem to be pretty trapped. No good way out. My suspicion, he'll just pull the same thing Jen McCabe did. I forgot who I called. 3 out of 5 people that I called before I let the FBI in my house. I just forgot. It's going to be his explanation. They think we're stupid. They think we'll buy. You just forgot what you went to the Canton Police Department to do. You just forgot what time you went there. You just forgot about being on your phone. They think we'll buy that. Jennifer Devine, maybe he turned cars on and off to imply he moved them. Maybe. I mean, maybe, but so if he's like trying to like create an evidence trail like that, what's the source? I mean, the vehicle key cycle, it seems very unlikely, that they're going to go through and forensically examine these cars that he turned on and off to prove that he turned the cars on and off at this time. No, it seems like it would be the camera. It would be what he would know about. So you'd at least move it to a different spot or something. I just don't know. I really don't know. I'm very baffled by this activity, other than it just does look like he is perhaps moving things between the vehicles. I don't know. I look forward to his explanation with great anticipation. Sola fide. In my opinion, as long as they can't mess with the jury, his case is a piece of cake as opposed to the Commonwealth being toast. The jury is always a wild card. You never know what you're going to get. You never know what you're going to get. You can lose a lot of money betting on thinking you know what the jury is thinking. Juries can get all kinds of ideas. So I would like to think this, and it seems common sense to think this, but I've learned too many times the hard way. You cannot take the jury's perception for granted. I said early on in this case, the fact that there were so many people during jury selection that knew about the case and had opinions about the case, and yet we didn't get a motion to change venue, could imply the opinions are largely favorable to the defense. That's kind of the perspective at this point. So maybe we can have some confidence in that the jury is already leaning in that direction and none of this is fooling them. But it doesn't mean that there isn't anybody on that jury who hasn't formed a contrary opinion and is just looking for any reason to justify what the Commonwealth did and what their witnesses say. So you would think so, but you just really don't know. You just never know. Deep state thrombosis. He was getting a Faraday bag from Canton PD car. Hey, that's a theory. That's a theory. John's phone. I don't think John's phone moved in this time frame, did it? We go back and look at the Apple Health data. John's phone last moves 12/32/16 with those 36 steps. And then it doesn't move again until beginning at 6:04:01 when it starts taking steps again. 432 steps at that point. Awful lot of steps at that point. So the Faraday bag wouldn't block the movement. It would certainly block the location, but it wouldn't block the movement if he had the phone. But maybe he doesn't have the phone. He just has the bag, goes back to 34 Fairview and gives him the bag. This is a possible theory. I don't know. I wonder what we'll wonder if we'll find anything out about that. I just don't know that there is a way to know. But that is a theory. Can't rule that out, at least not from what I saw. Z, before TB started, Turtle Boy, Elizabeth Proctor would find FKR supporters on Facebook, harass them for not trusting LEOs, and call their employer to get them fired. I did hear about that, about Elizabeth Proctor's Facebook activity. I'm not myself on Facebook. Don't pay attention to Facebook. So this wasn't something I saw or, ever really knew about. But yeah, I saw she liked to do that. She liked to go after people's employees or employers. How dare you have this person on your staff or whatever. Now these same people are terrible that they're horrified that these same tactics have been turned back on them. That is hypocrisy in a nutshell. Skippy 1, BH swapping jack levers to hide the murder weapon. I couldn't see what was in his hand. Bukhenik tried to say it was a broom. I don't know if it was a broom. I don't know what it was, but it does seem like a weird thing to kind of have and put in a car and then not have. A jack lever, possibly. I don't know. Interesting theory. Erica, Higgins went into the PD to change his clothes. His hoodie appears different. The front of the hoodie, we had that side by side that we looked at. You can go ahead and pull that up real quickly again. It does look like the pattern on the front is the same. There's that one with the eye that's on that looker's right, and then the one that he was wearing at the bar kind of has that same pattern. It looks like on the eye. So to me, it looks like the same hoodie. Can't say with 100% certainty though. So possible it's a different one, but I don't think we have very good evidence that it's a different one. James Casatelli, why would the Commonwealth not turn these videos over for the first trial, but then turn them over for the second? Seems like bad strategy. I mean, this is kind of the $1 million question, isn't it? Why turn any of it over? It doesn't seem like the defense knew that it existed until slightly before the first trial. They turned over the inverted Sallyport video, and they turned over the one from the far wall that had the 43 minutes missing. And I think they might have turned over the one from the front that had the flatbed arriving at 12:30, 12:31. So the only explanation I can really have is that the Commonwealth turned stuff over because they wanted to use it for their benefit. They had this evidence that would, in their mind, take the issues with the search and the timing of when the vehicle got into their custody versus when CERT began discovering taillight plastic, that it would take those off the table or at least like minimize them as issues. So they wanted to use it to their advantage, but the problem is then once they turned it over, it alerts the defense that this video exists at all. And so now they can go, looking for other evidence, digging into it. Nobody predicted a mistrial. I think that's part of it too. I mean, you should never take it off the table. In that sense, it's not smart. If we think Karen was not smart for doing the interviews, that's part of that calculation too. Didn't anticipate that it was going to end in a mistrial and that then these statements would be available for a retrial. Possible the same assumption that the Commonwealth made. They would get away with the selective sharing, discovery of the video evidence because they didn't anticipate there would be a second trial. Beagle Mom, have you heard how jury is responding? You look pretty. Oh, well, thank you so much. Nice to hear. Always got that extra hour of sleep on Monday. It always does me good. I have not heard how the jury is responding. I'm not sure if we have Jess Machado in the courtroom this week. I'm going to have to go check that out once we get done today. So not sure yet at this point. Erica, I was wrong about the hoodie. Higgy was hiding evidence in one or more of those vehicles. He is guilty as sin in the murder of John O'Keefe. His behavior around the vehicles looks really sus, doesn't it? It looks really sus, and I don't know how you mistake that for I went back to move the cars so that they could plow the parking lot. Are all of those those cars in the parking lot? Do all of those belong to him? Because wouldn't they also need to be moved if that's the explanation for why you're even there? Doesn't add up. So it's very, very sus, whatever he's doing. He's going to be asked. Surely he's going to be asked. Bird, it's amazing how much more clear these videos are compared to others. Like the waterfall video suddenly got very bright and washed out. I did see, I don't think I have that right at hand, but somebody did go and hunt down what the video, oh, here it is. I do have it. Let's just go ahead and share this. Let me get this up here. Go ahead and take a look. What it looked like in the first trial versus what it looks like in this trial. Huh. Peculiar. Look at how nice and clear and visible that one on the left is from the first trial. And now this blinding washed out thing that we're seeing in this trial. Why is that? Why would the video quality be different? Surely they're the same video, the same original video, just what you received from the waterfall. But they sure don't look very similar, do they? Amazing. Amazing indeed. Jen's nefarious 507 call to Coco. There's nothing nefarious about that. Why would you think it was nefarious? Had a thought, could they have hosed the yard off to remove drag marks and footprints from the snow? J.O.'s bloodstains on shirt looked watered down too. I don't know. What would there be evidence of that? If the ground was already frozen solid and impenetrable, then if they're hosing it down, the water is not going to seep into the ground. But is it going to flow somewhere? If this ground is not perfectly level, then I would expect it to flow somewhere, accumulate somewhere. I don't know if it would leave a trace. A little bit of a difference in the snow quality down there at ground level where John was versus further away from where he was, where it didn't get watered down. If it gets watered down, say the grass is frozen, hard as a rock. Nobody believes that, but let's just say it's frozen. You hit it with water that's flowing, by definition above freezing. If it's coming from your city water, you know, it's normal. Probably going to melt whatever ice, snow is on that grass. So then it's going to refreeze. Is that going to be observable? I don't know. It might. So this is a theory. I don't know if we'll get evidence to prove it or disprove it one way or the other. But can't say that didn't happen at this point. KS Wheels, hashtag LNC Wrestling. Is there a way for the defense to make an issue out of who the state aren't calling? I think it's viable to raise that in argument. You had to hear it from us. If the Commonwealth is so proud of this investigation and stands by it and its thoroughness, why didn't they present all that information to you? Why did you have to hear it from us? And this is a fairly standard line of attack for defense to take in a case. Suggests that the Commonwealth is hiding stuff that was available to them. Why didn't they want you to know that? Why did they want to wait for us to have to show you? So I would think this would be a viable line of attack. K, just an FYI, you can easily move an iPhone around without adding steps by sliding or dragging it. I spent a decent time testing this out. That's an interesting theory. Yeah, if the phone is registering, you know, movements, gait, and up and down, then it seems like you could just sort of deliberately, you know, hold it or move it in a way that would not replicate that. If you think about if it's in your pocket and how your pocket's going to move when you're taking steps, what that's going to be like, it's going to be rhythmic, it's going to be relatively consistent, then yeah, maybe you would just know As long as I don't mimic that movement, it won't register steps. Possible. Dragging it or sliding it. I'm picturing them now bear crawling on the lawn with like the phone on the ground, moving the ground along with the bear crawl. I don't think these guys have the fitness to do that over that length of time, plus with just the one arm, because the other one's got to be moving the phone. As bear crawls get pretty tiring. That can be some cardio. Maybe there's other ways to move it or drag it with their feet or something. I don't know. Good information. Herbert Whittard. Was it established how high in the snow column the Solo Cup bloody snow was collected? Not specifically. No, we would have probably gotten that from Gallagher. What we do have are just the photos of the snow and the blood droplets on top. And, as they are snow blowing those areas, the snow gets blown away, but the droplet is kind of still there, like you're chasing it down. In the first trial, he testified specifically that that's what they did with the snowblower, is blew the snow away so that they could follow the droplet down to where they could get the sample. I think he kind of implied it here where the snow was pink at the top and they blew it away till it was less pink, less pink, more blood. So same general implication there. They had to follow it down from the top of the snow where it's not supposed to be. So how did it get there, and why is that what they were interested in? I mean, you tell me the logic of that. Doesn't make sense to me. Dee Marie is a new member. Welcome, Dee Marie. Thanks for joining us here in the channel. Jesus Freak. Why snow under John O'Keefe's prone body? Why blood on shoes? Why indeed? Why indeed? They're trying to insist that there wasn't snow under John's prone body or supine body. No revisiting yet of that statement Jen McCabe made on the 911 call about turning him over. They're turning him over now. If they had turned him over onto his back as he was found by everybody else, then that means he was initially prone, but nobody said that. And that's not consistent with his, the lividity that later develops on his body. But they're trying to tell us, oh yes, because witnesses said that they saw grass under his body when they moved him, but we have the photos. We have the photos of the scene. And there's no grass under his body where he was found. Just more compacted snow. Believe what they say, not their eyes. Why blood on his shoes? Yeah, why indeed? Why would there be blood on the top kind of insole, inside piece of John's shoe? Why would it be there if he's lying on his back having been hit by a car? Don't know how blood would get there. Now, if he's upright and in a fight and his face is bleeding, his nose is bleeding, his mouth is bleeding, Karen described from the clip, blood's coming out of his nose and mouth when they found John on the ground, or in the interview. Sorry, this was Bukhenik reporting her interview at her parents' house in Dighton. Blood coming out of his nose and mouth. Yeah, if you're upright and you sustain an injury by, I don't know, a fist or something that makes your face start to bleed, it bleeds all down in front of your clothes and sometimes even on the top of your shoes. Well, that makes sense. But of course, no evidence of that. No evidence of any of that. Carolyn Smith, did you hear the juror who said, wow, when B admitted he lied about when the Lexus was taken in? The camera is right on top of the jury, so sometimes you didn't hear them. Sometimes you hear them react. I did not hear that. I didn't hear that. When they talked about Proctor, Proctor had made all the prior sworn statements in his affidavit that they took the car in at took it into custody at 5:30, when in fact they'd seized it in Dighton a good hour before that. And he did nothing to correct that, Bukhenik. Did nothing to correct that, despite it being in search warrant affidavits and so forth. I did not hear a juror say, wow, I might have to go back and try to listen for that now. Avec gas, it's National Police Week. Oh, the irony. Oh, the irony. Michelle, could her car insurance be paying for some of the defense? Would they have to pay out a claim if she is found guilty? So they're almost certainly not paying for the criminal defense. That rarely happens. I can't think of a situation where that's happened. They're potentially liable for a civil judgment. And so there is a civil case that is being pursued by John O'Keefe's family against Karen Reed, also against C.F. McCarthy's and the Waterfall for over-serving. So her insurance is almost certainly defending that, because the nature of the accusation is that, it was a car accident. She hit him with the car. If she hit him with a car and, they win at trial, they prove that theory, then car insurance is going to be potentially liable for that. So they're defending that. Don't know of any situation where they would be defending in the criminal case. Now, I can think of legal justification why they potentially could, because if Karen Reed is found guilty, if she's found guilty at trial, then you run into issue preclusion issues. The extent to which you get to relitigate the same set of facts in different cases. And so, for example, OJ went to trial. OJ is found not guilty of the murder of Nicole Brown Simpson and Ron Goldman. But Ron Goldman's family sues him civilly. That goes to trial, and he's found to be civilly liable. So the issue preclusion doesn't apply in that case, because the Goldmans weren't a party to the criminal case. They don't have an opportunity to present their own version. Plus, it's a different standard of proof. Civil is quite a bit lower than criminal. But if Karen were found beyond a reasonable doubt to have killed John O'Keefe with her car, is that going to translate into insurance being liable? Well, potentially it could, except for the fact that they're not a party to this case, and so didn't necessarily have an opportunity to defend. Yeah, I don't know. All I can say is I've never seen it. I've never seen an insurance company contribute to the defense of somebody in a criminal case. It's just kind of me talking out loud about conceptually how they might end up on the hook, but I think you're going to have a tough time asserting issue preclusion against an insurance company who's not a named defendant in the criminal case. Andrea McBurnett, did Higgins grab a Faraday bag at CPD? That's a good question. You see him getting in and out of those cars. I don't know what he's doing. $1 million question, what he's doing. AKA Trad's photos, look at the back of his hoodie. So I remember the back of his hoodie looked like, when he was in the hallway, it looked like a motorcycle, looked like a Harley Davidson. Thought that's what it looked like. I don't remember what was on it at the waterfall. Maybe somebody will screen grab some of those at some point. Caught the quick screen grab of the front. They did look very similar, but don't know about the back. In Wings, does Whack Job C and Hope She Ends Herself need to come in with Michael Proctor? If they weren't conversations that Bukhenik was part of, then yes, they would. I know some of those were with DeChico, weren't they? When he was texting with DeChico about leaning on the medical examiner. They probably have to come in with her. And then Hope She Ends Herself, I think, was in the chat with his friends. So Bukhenik wouldn't know anything about that either. Both conversations he wasn't a part of. So yeah, they will have to come in through Michael Proctor. Teddy Bear 1287. My town, North Bend, Washington, just voted to get rid of our police force and only rely on the sheriff's office. Thoughts? Does the Tri-Cities area have their own police? There's been a lot of I don't even know how to describe the kind of competitiveness almost that's gone on in the state between not just law enforcement, but also law enforcement and the county commissioners in particular. We have a county commissioner style of government in Washington at the county level. Kind of common thing that has gone on in multiple places is that sheriffs traditionally ran the jail. And there have been multiple instances now where the county commissioner has gone in and yanked away the jail administration from the sheriff, decided they're going to do it themselves. It's been very political, very chaotic. So I've seen some of that. I have not seen anybody besides North Bend get rid of their local police and just rely on the county. We do have local police departments here in Kennewick. We've got Richland Police Department, Pasco Police Department, Kennewick Police Department, in addition to Benton County Sheriff's Office. I'm not sure how this is going to work out for y'all. I'm intrigued to see how it works because I don't know how prepared the county is going to be to cover all of the investigation that normally takes place in a particular jurisdiction. So is King County Sheriff going to do like all of the criminal investigation in North Bend, even for misdemeanors and things like that? I don't know. I don't know if that's feasible. I mean, we'll see. We'll see. So I think I had heard about this, but I haven't like looked into it or followed it particularly closely. So you've kind of intrigued me. I might have to take a look. I don't remember when that happened. This is really recently, or if it's been in effect for a little bit. Thanks for bringing that up. I'm going to have to check that out a little bit closer, see how that's going. Keep it real. I work with tow companies. They must take video or pics of entire vehicle for liability purposes. Where are those pics? $1 million question. The tow driver is on the defense witness list. And that's been, I think, on people's minds since before the first trial. If somebody is loading a damaged car onto their tow truck, surely they are documenting the condition that it was in, because you don't want to be blamed for it being busted when you get to your destination. You document the condition it was in when you take custody of it, because you are a bailee. It's the legal term for it. You are taking temporary possession of it. You're responsible for taking it until you deliver it back to who rightfully owns it or is entitled to possession of it. So yeah, it's pretty typical to have some way to document the condition that it's in. I would be surprised if that is not there. It looks like, oh, check this out, guys. Check this out. Trad's Photos was on to something here. Let me pull up these images. Somebody has already gotten a hold of the back of the photographs, or the back of the sweatshirt. First at the Canton Police Department, and then over there at the waterfall. We're going to share that. Oof, guys, check this out. Here's at the waterfall. We see that big logo there on the back. Zoom that way in. It's something big and round. Can't really see exactly what it is, but we certainly have an idea of the pattern. But then when we look at what's on the back in the hallway, it's writing. It's writing. Doesn't look the same, does it? That doesn't look the same. Is the pattern even the same? Does that look like writing? Is that even, I mean, any way that those are similar, kind of shape is sort of similar. I don't know. There's a big gap in the top of the writing when we're here at the waterfall. I'm just trying to think if this is all blasted out, whited out. You can't see the detail because it's overexposed. It looks like that. I don't know, guys. That doesn't really look the same, but it does look kind of similar. Curiouser and curiouser. What do you guys think? I could see a maybe if the details of the photo at the waterfall are just too burnt up from that overexposure. That burned out video that we're being shown, it does kind of look like the same general shape. I don't know. I could definitely see an argument that that's not the same hoodie, but I could see an argument that it is. Track worker, cops intentionally blurred and reversed the Sallyport video. I want to see those timestamps with the people operating. Does the time jump? And we didn't get the explanation this time because I think they stipulated to the authenticity. Why are the people jumping in and out of the video before we're told it's motion activated, but people are moving on the video when this is happening? We are watching Trooper Proctor walk on the video when somebody mysteriously appears elsewhere on the same footage. So kind of hard to see that explanation. I'd love to see the timestamp. If it's motion activated, the timestamp should skip. I don't know if that's what we're seeing or not. There's not going to be an argument to this effect because there's been a stipulation to the authenticity. So that might be the case, but it's not going to be litigated here for this jury. Les, love watching every day with you, Andrea. The chat keeps me laughing. Me too. Thank you for hanging out with us. Thank you guys. How many other Glove songs did you guys come up with? You give Glove a bad name. Oh my God, you guys in the chat, you are too much. You are too funny. Thanks for being here with us, Les. We're glad to have you with us too. 333 Damon, AB, please explain this to the chat and how it applies to this case. Falsus in uno, falsus in omnibus. This is a Latin phrase, false in one thing, false in everything. This is a theory of interpreting the credibility of the witnesses. And so the idea is if somebody is willing to lie about something, they would be willing to lie about anything. So you can't take anything that they say as truthful. They're simply unreliable if they're willing to lie about even one thing. Now, not everybody buys this principle. It's not like a hard and fast rule everybody has to follow, but it's fairly commonsensical. Fairly commonsensical that if somebody would be willing to lie about one thing, they might be willing to lie about other things as well, potentially everything. So, how it applies to this case? Well, for example, if Proctor's willing to lie in sworn affidavits about the time that they took it into custody, what else might he be willing to lie about in his reports and in his affidavits? If Bukhenik is willing to lie about what we see on the Sallyport video, what it shows, what else might he be willing to lie about in the course of the investigation? Those are the questions that are going to be asked. And the jury's responsibility is to evaluate the credibility of these witnesses. And so if we can show they're being untruthful about some of these details, then how do we trust anything they have to say? They could be lying about everything. The rural juror, can AJ just ask the question, have you ever seen what color a Lexus taillight lights up when there's no red lens? Or is it speculation? It wouldn't be speculation to ask him if he knows. Or what did he do to verify what a Lexus taillight would look like if it were illuminated in this condition? Other than looking at the videos of Karen's taillight, what did he do to corroborate that those videos showed a busted taillight? Because then we can just go around and look at the Sallyport video that shows her driver's side right taillight. It appears to have some white light right there on the side. Kind of looks a lot like when we saw the Ring video leaving 1 Meadows Ave. And there's a little flash, and then she pulls out through the driveway, and there's like that one little section on the side that looks kind of white. Sure looks an awful lot like that to me, only this is supposed to be the busted side. And you're saying this is showing a busted taillight, but the driver's side looks the same in the Sallyport. And you're saying it was undamaged. He could ask the question. It just, I think whether you set that up depends on whether you're prepared to substantiate what it should look like. And, we don't know what the defense's approach, if any, on this particular issue is going to be. Josh H. Yuri Bukhenik said he wanted to observe the vehicle, yet when he got to the vehicle, they never approached the vehicle to observe it. He said Proctor did. That was his testimony. And in the first trial, he said he actually told Proctor to go up and examine it, but nobody documented it. Big notable omission there. Okay, we looked at it. We saw it. We saw it was damaged. Then why didn't you take a freaking picture right there? Take a few pictures of it there in that snow, in those drifts. Sitting apparently undisturbed for, hour or two, maybe. Nothing but their footprints going up and approaching that right rear taillight. Why wouldn't you get within, 4 or 5 feet, take a photo? That car in the nearly pristine snow with a busted taillight. Why wouldn't you do that? That would be great evidence. Nope, they never did. They expect us to take their word for it. That's why. Chrissy S. Original plan was for her to plea, and it shows. Yeah, it does. It does. Once it came down to they needed to actually make a case by, I don't know what, February 11th, 10th? They had to start finding more taillight. Oh shit, they got too much taillight still missing. They busted off that entire taillight before the lab came out on what, February the 3rd? Pretty sure it was February the 3rd when they took that photo of the taillight in the Sallyport, the one that has the bumper sprinkles visible on the top of the bumper. We haven't heard about the bumper sprinkles yet, but we'll get there. Too much taillight missing. They haven't accounted for all of the taillight. Now, to me, this was really stupid because the way you account for the taillight is that the plow took it away. As long as you find some taillight, isn't that enough? They decided they had to be able to reconstruct nearly the entire taillight from what they found, I guess, in order to support the case that it was Karen's taillight, the pieces from her taillight. Otherwise, maybe it could just be any taillight. So then they had to start discovering massive pieces of taillight out there on the front lawn 2 weeks after the snow has started to melt. It's been raining out there. And nobody in the Albert family, nobody in all these drive-bys that they said they told their officers to do every single day, drive by the scene and see if you see any taillight. And yet nobody except Proctor and Bukhenik and Berkowitz find any of that taillight. Yeah, I agree. Once she didn't plea, they scrambled. Kathy Mick, Andrea, I'm interested in knowing what you are writing down during testimony, and thank you for explaining this case to us. You are the big leagues. Well, thank you for that. It's very complimentary I'll show you the kinds of things I write down. I don't know if you can see this. What I do is just sort of shorthand the notes and what's happening. I'll star little things that catch my attention over in the margin. For example, like over here where I'm taking down little bits of his testimony and I star here, volunteers the TV remote example caught my attention. You volunteered that if a person who is dead is lying on a TV remote, it will show up in the lividity so clearly that you can see the numbers. Why would he volunteer this? When John was found lying on a phone and we've heard nothing about, oh, there's a pattern of lividity on his back that shows where the phone was? We've never heard that before. Don't recall that being documented. Why would he volunteer that? So that's the kind of thing I do. I just shorthand the testimony. If there's something significant, I try to get it in quotes so I can quote it back. But by and large, I'm just trying to get the gist of what they're saying, and that's in part. It's for a lot of reasons. I remember things by writing them down. It's just part of how how my memory works. The process of writing it helps cement it. I'm one of those people that's terrible with names, for example, but if I meet somebody and can write it down, it might help. So part of it's a memory aid for me to help cement it. Part of it is obviously to be able to go back later and remind myself. But also it's so that I have a general outline of what was said in relation to what else was said, so that if I want to go back and check on the live stream, the video stream, it can help me identify where I should be looking. If I can't find the exact thing I'm looking for, but I remember it was right after they were talking about the Dighton seizure at 4:12 and that Proctor swore under oath that it had been seized at 5:30. I'm going to be able to go in and find that part in the testimony and then identify what I'm looking for. So that's generally what I'm doing with the notes. I'm also keeping track of the exhibit numbers as they come in. May or may not end up being significant, but it's just a thing I do. I got my little note here, the one First Amendment, when he talks about Michael Proctor has a First Amendment right to say things. Oof. Just start that with an oof. Not good. Not a good explanation. So that's a little preview of my notes, guys. Sandy B, he also said he heard, could I have hit him? Did I hit him? Not I hit him. Yeah, the initial was could I have hit him? Did I hit him? And he didn't bring up the I hit him until later on when he was doing later interviews where it was no longer a question. Apparently not that significant to him, not at all the way it was to Jen McCabe. So significant that she could never forget it, except for the multiple times she told her story where she did. Skippy 1, Cora says, woof, woof, woof. Translation, I bit him, I bit him, I bit him. No, guys, it's obviously a car accident. I mean, how would you look at that and not instantly think, oh, we need to investigate a collision with a taillight? Obviously. My experience as a trooper investigating collisions, I must have seen that hundreds of times. Yeah, nobody is buying that at all. In Wings, Northwest Wings. Question to Yuri Bukhenik. If you did something shady and there was no proof of it, would you admit to it on the stand? This redirect is annoying. It kind of is. Yeah, it kind of is. If you ignored all of this stuff that contradicts your theory, would you tell us that that's what you're doing? I mean, I didn't find it to be a particularly effective redirect, in part because it didn't address the main part of the damage that the defense did. So much of this damage was self-inflicted anyway, just by his demeanor and his attitude. The combative, not remembering anything whatsoever, constantly needing to be refreshed with the defense. And the contrast with, oh, but when the Commonwealth is asking you questions, you remember every single person who wrote a report in this case, even though It was over 80 of them, at least. Report number 83, and you were previously so overwhelmed by how many reports there have been. Couldn't possibly be expected to remember them all, but you remember every single person who wrote one. I think a lot of that damage was self-inflicted. So I didn't find it to be a particularly effective redirect, but you know, what do you guys think? Was there anything in there, you know, really helped? He got in the timeline of the I hit him, you know. He was basically just responding to the sort of Boden aspect of the cross, where the defense is pointing out, here's what you had, here's what you didn't have in the course of conducting your investigation. And so Brennan's trying to use that redirect opportunity to point out, here's the strong stuff that we did have. And yet, ironically, what is that? It's not the facts, science, and data, is it? It's I hit him. It's just giving away the game all over again. That's what Hank Brennan's case really is. It's the same as Lowley's case. It's I hit him. And you should believe that, not what any of the other evidence and facts and circumstances tend to show. John's phone is walking away at the wrong time. It doesn't matter. I hit him. That's what their case is. So that's what the redirect focused on. And if you don't find that to be a persuasive case, then I don't think you're going to find the redirect to be very persuasive. Britt Cormier, why does the judge allow additional testimony during redirect? Why does she now make them present all evidence during direct? This is the wacky stuff that makes me think this is a clown show. So they brought in the additional taillight on redirect because it had been brought out on cross. The defense had elicited it on cross to question him about the time frame, kind of the timing of this evidence being discovered, the issues with the chain of custody and the documentation, and just the questionableness that, you know, 2 weeks after it stopped snowing, Proctor is suddenly finding, you know, this massive piece of taillight out there on the lawn. Lacks credibility. So it was the defense that brought it out on cross. That's why he went ahead and just dealt with it on redirect, in part because if you're otherwise going to get these pieces into evidence, I mean, I don't know if you want them or not. I assume you do, but maybe you don't. Your only other way to get them in is probably with Proctor, the guy who collected them. Does it matter that they're in evidence? I don't know. I don't know if he's going to call any of the people from the lab. I don't know if we're going to get this whole tail light reconstruction like we got last time. Surely they're going to at least call the folks who found the touch DNA, you know, the trace DNA of John's on the taillight, the DNA analyst. Didn't Hank mention that in his opening? If he does, that's at least something he needs to bring in, but maybe we're not going to bring in the whole taillight reconstruction, so we don't need all the taillight pieces. I don't know. But generally speaking, it's because the defense gets to bring in a lot of stuff that Bukhenik himself didn't have his hands on, but because he was the supervisor of Proctor, Proctor conducted the investigation. His job is to oversee Proctor's handling of the investigation. So what he learns during the course of that investigation is relevant to the Boden defense. So because of that, defense gets to open a lot of doors on cross-examination that the prosecution wouldn't necessarily be able to go into on direct. They can't go into what other officers did outside of his presence, booked into evidence, et cetera, et cetera. It's the defense who was able to get that door open based on this is how you conducted your investigation and became aware of. So that's why, from an order standpoint, it might look a little bit confusing, but it did make sense to me, you know, and just in terms of sort of the progress of how that worked. I don't know if I explained it very well, though. But it's because they wouldn't be able to bring out, what another officer wrote in his report, what another officer got for their information. It would be hearsay. It would be inadmissible if they tried to do it on direct. But the defense then can open that door by bringing it up, not for the truth of the matter asserted, not as hearsay, but simply to show this is how your investigation proceeded after you learned certain things. These are questions you failed to ask, et cetera, et cetera. So hopefully that makes a little bit of sense. Amelia Walsh, can we send them back to preschool and teach them how to use scissors? The smug head on him. He's very stabby looking with the scissors. I don't know, just a thing I notice. The handling of the scissors doesn't bother me nearly as much as every single person putting their gloved hands all over those scissors after they're handling everything else. Scissors are not being sanitized. Yeah, this is cross-contamination happening right in front of your eyes, but all under the guise of being good, responsible evidence handling. But he did make me a little nervous with the scissors today. It does. It looks like he's about to cut his own hand off or cut the glove or something. Yikes. Mike, nothing Andrea loves more than the evidence display theatrics. It's just so ridiculous. It's so absurd. It's like watching a comedy, an old Shakespearean comedy or something like that. Like, they do think we're stupid, guys. So I'm very glad that, this is kind of caught on and people are noticing now. Oh yeah, he's like handling everything on the table before he handles the evidence, but we're supposed to believe that the gloves make all the difference. It's good to pay attention to that kind of thing. Summer is 19. Are jurors' notes private, secure? Judge can read? They're not supposed to. Definitely not supposed to, but yeah, they're secure, but who's in charge of the security? The judge. The judge and the judge's appointed courtroom security folks, who are usually bailiffs. The court's bailiffs are the ones who collect the notebooks, store them in some secret, inaccessible place, return them to the jurors the next day. And of course, never, ever, ever take a peek at what's in those notes. So yes, if you accept court security as doing what they're supposed to do, then nobody looks at the notes. But we only have court security's word for that they wouldn't be doing that. Dan Greenwood, can we have him doing a Mary Poppins, where his arm goes deeper and deeper into the bag, pulling out lamps, SUVs, Chloe. Pulls Chloe right out of the bag. That would be entertaining. That would be entertaining, wouldn't it? Yeah. Yeah. I mean, would it be any more absurd than what we're already seeing? I'm sorry, but the debris, the collected debris, what on earth was that doing in that one evidence bag? I don't understand that at all. If I remember correctly from the first trial, that's supposed to be what they collected from John's shirt, right? I don't remember if they vacuumed it or exactly how they got it, scraped it. I don't even remember now. Just found it on and picked it off. I don't remember. But it was related to John's shirt. It wasn't related to any other taillight pieces. Why is it in this particular bag? Very confused by that. M4A now. Can AJ point out the sloppy evidence handling that Bukhenik and others are still doing right in front of the jury to show their continued unseriousness? Perhaps he could have. He didn't. I don't know of any reason why not. What's happening in the courtroom in front of the jury is potentially evidence for them to consider. So, Trooper Bukhenik, I see you've taken care to put your gloves on before handling the evidence, and that's so that you can ensure that you don't cross-contaminate it, that you don't inadvertently introduce other material that might tend to affect the integrity of that item, and that's so that it will still be viable for later testing or follow-up should such be necessary. Yet I noticed that you handled that microphone with your glove before you put your hand in that bag and grabbed the glass. You didn't notice doing that? Did you notice picking up those scissors with your right hand and using it to cut open the bag? You have no idea where those scissors have been, do you? You have no idea how many people have handled the scissors. You don't know if the scissors have been sanitized. I don't see why you couldn't. They didn't. Maybe the jury will notice for themselves. I don't know. Natalie VB Light Breeze. Andrea, is it me or seeing Higgins around car at Sallyport is cause for questions? Thank you, Andrea. It was earlier. Was that him that we saw, or was it I think they were trying to say that was Berkowitz on the January the 30th video that we saw. I think they were trying to say it was Berkowitz. We see Higgins in or near the Sallyport going in that side door, but that's before her car is there. That's the night or very early morning of the 29th. So I don't know if we've seen Higgins around her car, at least not yet, but we couldn't identify who that bald man down there by the taillight was. Couldn't say if that was Proctor, if that was Berkowitz. Is it possible it was Higgins? I don't know. Rob Inson, I don't understand Brennan's redirect. It's basically a direct. How was that allowed? Again, just because the defense was able to open the door to a lot of aspects of the investigation that the prosecution wouldn't have been able to go through themselves because it would be hearsay if they offered it, but the defense went ahead and opened up the door with the non-hearsay purpose. So then they get to respond to that. Now that the door has been opened, you took this into evidence. This is the information that you had. So he gets to bring it into evidence now. I really didn't see any issue with that from a procedural standpoint. I understand it does look a little bit different, but I think that's just because of the nature of the Boden defense. Josh H., what surveillance video did Yuri Bukhenik review showing lawn at 12:32, showing how much snow was there? If there is video reviewed, where is it? He did make that comment during his testimony that based on video that he reviewed, it was just a light coating, if any, on the ground at 12:30. We know from the last trial, they have the video from the library, the public library, because they captured Karen's car going towards 34 Fairview at this time. And, the grass is still clear at this point. I think there's a small amount on the sidewalk, perhaps, like very, very little snow accumulation at this point. So we know that from the last trial. But yes, you're right. There's nothing that the jury could look at in this trial to be like, oh, that's what he was talking about. That's the video that he reviewed. If that caught their attention, they might be wondering, what video is that? Because we haven't seen it, but he seems to be expecting us to take his word for it, just like he seems to be expecting us to take his word for a lot of other stuff. Seems like it wouldn't be hard to document. If you saw a video, why aren't we seeing it? If you saw the condition of her taillight in the driveway, why didn't you document it so we can see it? They seem like perfectly legitimate questions for a jury to be asking. Ben, in Cross, can AJ go through each piece of plastic evidence again and ask, is there blood on this piece? Observable blood. I mean, maybe he could. Do you see any blood? Of course he wouldn't at one point. At some point, Bev would cut that off. You've made your point. Just ask him, is there blood, visible blood on any piece of taillight? I would expect he might sidestep that. You wouldn't know, but you wouldn't necessarily expect it to be visible. Sometimes there's blood there, even if you can't see it. Or there's DNA there, even if you can't see it. But yeah, this was theoretically possible. He could have. No blood on any of this, huh? Ian Thomas, Yuri fabricating context. Well, It's the totality of the investigation, right? But only the totality of the investigation that he wants you to see, not the stuff about the forward edge and Lucky Loughran, not the stuff about the weird timing of the taillight being discovered, not the stuff with Brian Higgins calling him out, having the motive, etc. Not that stuff. That's not the totality of the investigation. It's his interpretation of the context that we're to pay attention to. Summertime. Is judge allowed to limit defense time with witness? To some extent, yes. She can't arbitrarily cut him off, say, you know, Mr. Jackson, you get 20 minutes and that's all you get. She's not allowed to do that. She's not allowed to say, you know, you're done at the end of today. If he still has areas he needs to get into, he gets to get into them, or she's depriving him she's depriving Karen of her right to defend against the charges. What she can do is, if she thinks he's being repetitive, we're just going back and covering the same thing, she can exercise some control over that. But as long as he's got new information to bring up, no, she doesn't get to arbitrarily say, okay, you're done now. So she's asking him, she's being careful, I think, to ask him, are you done? Perhaps the message is being sent that I want you to be done, but she really can't cut him off. She doesn't have the authority to be able to do that. Amara Deschain, alcohol releases inhibitions. Yes, indeed it does. If you were not otherwise inclined to try to get Karen's attention, try to have it out with her boyfriend, alcohol might make it more likely that you do those things if they were on your mind, if that was what you wanted deep down inside in your soul, but you had restrained yourself up to this point. Yeah, alcohol might let it out. That is how alcohol works, isn't it? Summertime. As of now, do you think jurors see reasonable doubt? Like I've said, I always hesitate to speculate about what's in a jury's mind. I really do. They have so often a way of looking at the case that is not at all what the lawyers expect it to be. And their motivations color what they see and how they see it and how they interpret it. If they're walking in there, even if they know nothing about the case, if they're walking in there with the general sense of, I want to trust law enforcement because I want to have faith in the people that we empower to keep us safe and to give us justice and find wrongdoers and so forth, then you're going to tend to interpret evidence in a way that reinforces that worldview, that supports it. And so you just don't know. You don't know how they're seeing things. Me personally, is there reasonable doubt? Absolutely. I think there's very little here that the defense has not really been able to blow a hole in as far as the Commonwealth's presentation of their evidence in their case. We've seen the inconsistencies with I hit him. We've got different stories. 3 different stories of when and how that happened and who else was there and so on and so forth. Now the last one hasn't fully fallen apart yet because they haven't called Good or Seraph, officers Good or Seraph. Remember, Katie McLaughlin said this was right in front of Seraph, and Seraph said, go get Goody. So that hasn't really fallen apart yet because those officers haven't been called. They testified in the first trial, never heard I hit him. So it didn't happen. That might have to wait for the defense case, but it's available. We know they can do that based on the prior testimony. The search and the timing of it is really the only other thing that is a little bit hard, to deal with. But at this point, is there so much skepticism about these officers and the chain of custody of the evidence that they might call that into question anyway? I don't know. They might question 1 taillight piece, 6 taillight pieces. Don't know because they didn't get booked into evidence the same time anyway. Nothing apparently gets booked into evidence until it shows up at the lab. If I understood Mr. Jackson correctly from last Friday. So are we to take it on faith that these pieces were all kept separate and distinct and, organized by the date on which they were found and who found them? Or did they just all go into a big pile wherever it was that they were being kept in the Norfolk County District Attorney's office? And when it came time to put them in bags, we just picked some out and put it in bags? Can't really foreclose that from the evidence that we have, but is the jury inclined to believe that at this point? That's the question. Are they inclined to at least entertain that? Because that's what reasonable doubt would be. Possibility that this was just literally random plastic that somebody, I don't know, maybe Brian Albert would just sprinkle out there on the street in that little 1 foot area, knowing that the search was coming. Perhaps got alerted to that. So you just put any plastic out there, give them something for them to find. This crime scene is unsecured all day, so you have access to it. And then just whatever they found doesn't end up being Karen's taillight, but it doesn't matter. They found something, and the rest is just there for Proctor to take care of. Make sure that things end up in bags, because none of it's booked into evidence anyway. So it's not secure, and there's no guarantee that it wasn't tampered with like that. So I think that is really the $1 million question. I don't have an answer. I don't know how the jurors are seeing it, and I am always very, very hesitant to guess because you just don't know. Sentient dreamer, Yuri and his apparating memory in and out of his mind. Yeah, his memory apparates just like those people in the video. Do you think the jury has caught, this is kind of weird that we stipulated to it being authentic, but we can see that it doesn't actually depict what happened in real time, because I promise you, people did not apparate in and out of the Sallyport in real time. Of course it doesn't fairly and accurately reflect what was happening. There are anomalies that are not what actually happened. Is the jury, do you think they're wondering about that? I don't know. I never know what they're thinking, but I just wonder about things like this catching their attention. It seems like a common sense one. You're telling me this is a fair and accurate video of what's going on, but that guy just miraculously appeared out of nowhere. Doesn't make a lot of sense. Factual lie, evidence in plexiglass, wrong shoe in the wrong bag, ripped jeans when they are not in evidence pick. Can this be an appeal issue? Probably not. Issues with authentication of evidence are pretty rare because the bar is so low. And so if it's in the wrong bag, as long as somebody is testifying, this is what it's supposed to be, even if it's mislabeled, that's enough to clear the authentication bar. And that's really the legal issue that's presented by should this be in evidence or not. Otherwise, it just goes to the weight. The jury can consider, should I discount this evidence because it doesn't have a proper chain of custody, because it wasn't clear that they had the right shoe, the right bag, because it's not clear that these jeans, were ripped at the time. It goes to the weight. So I don't think this is likely to be an appeal issue. Ben Togel, if I was a juror, I would be fast asleep. That redirect was really boring. It was very boring. I was starting to lose it a little bit myself. Eyelids get a little heavy. Emily, Bev rushing AJ at the end of Recross was appalling. I didn't necessarily see it this way. I mean, I understand she's asking, are you almost done? But it's because are we going to finish today and be done? Or is it because you're going to have more? If you're going to have more, we just bring Bukhenik back tomorrow. I really think that's what she was getting at. That's the impression that I got. So I didn't see this as extremely egregious. I mean, not by Judge Bev standards, not to me, but I appreciate, people may have different opinions about that. Buffy, YouTube, Karen Reed murder trial conspiracy police canine expert weighs in. This is a former police officer and current canine trainer, demos dog bites and his certainty O'Keefe injuries are dog bites with good proof. Is this Garrett Wing? I know I don't remember the name of his video, but Garrett Wing, who is going to be a defense witness, he's on the defense witness list. Brennan tried very hard to keep him out, but couldn't, was unsuccessful. He's got the arm. He's got the like silicone arm that he uses for his demonstration. If this is the same video, yeah, this is the guy. This is the defense expert. He literally like talked about this case. I think that might be how they found him. I don't know. But he was on Melanie Little's channel as well. Makes what I thought was a pretty compelling presentation. Yeah, these are dog bites. Cia LaFleur, love the bun, hun. Free this week. Sorry, still have Yuri Higgins residue from last week. But really, the bun suits you, Karen acquitted. Well, thank you so much. It's yeah, my little loop pony there. Thank you. Nice to hear. Everyone likes to hear nice things, right? From time to time. Fingers crossed that Karen will be acquitted. We shall see. We shall see. Emotional Lemonade. Sergio from Truth Revealed had a Higgins tire iron theory last year. Highly recommend. I hadn't heard of this one. Don't know anything about a tire iron theory. We did get that preview from the defense opening that the injury to the back of John's head came from a raised item. It wasn't like him impacting a flat surface. There was a raised item. So does that suggest potentially some kind of weapon? It could. I don't know. This is new from last year. None of this was explored in the previous trials. So I am very interested to see how this plays out. Tire iron theory might line up with what we saw him doing out there in the parking lot. So interesting idea. Might have to check that out. Lissy Quinn. So witnesses said John O'Keefe may have fallen on left buttock. So what explains the torn right pocket? Wasn't ripped in bar video, dog pulling or drag? Great question. Great question. Did they just try to imply at the end, perhaps, that it was cut for cuttings? There were cuts. Kind of heard Bukhenik say something about that in I think it was on Redirect. Condition of the pants. There were some cuts for cuttings. Is he trying to imply? Because it doesn't look like any cloth has been removed from that area. Doesn't look like it was cut to take a cutting. But not sure if that's what he was getting at or trying to imply, or just me reading into it, because we do. This is not explained so far. Why is that pocket in the condition that it's in? We haven't gotten an explanation for that. So if I'm the jury, I might be wondering, yeah, if he only fell on his left buttock during this car accident, then how did his right pocket get ripped? It's a great observation. Rudy Dub, Andrea, have you seen the latest microdots video? Well worth a look. Love your commentary, by the way. As a lawyer, you're the lawyer I have to listen to. Well, thank you so much. Somebody a long time ago, I think during Depp v. Heard, gave me what I thought was the greatest compliment. It was a lawyer. He called my channel the Law Tube for Lawyers. So thank you for that. I do appreciate that comment. I don't think I've seen the latest one. I've seen several of Microdot's videos. The one that he did showing what the perspective on the front of the lawn would have been at night with the headlights, and just how lit up and visible that entire area would have been to somebody like Matt McCabe backing out of the driveway and turning to leave in that direction. That was a recent video that Microdots did. Found that very compelling. So the latest one that he's done, I haven't seen. I've just, guys, time is a little limited right now. I don't have anywhere near as much time to look at and kind of think about everything that I would like to. But there is a massive amount of good content out there analyzing this case, looking at the evidence. Microdots has done some fantastic work in the past, so I'll probably have to run and check that out too in my abundant free time. Mel Will with a $1.99 super chat. Thank you so much for that. Appreciate your support. The rural juror wasn't sure the best way to get something to you. I sent you a DM on Instagram of a video of pulling out of 34 Fairview with snow and what you can see of the lawn. I think this might be the Microdots video I was just talking about. My IG starts with M and ends with 7. Sorry, I didn't send more today. That's okay. I appreciate that. Guys, yeah, I don't have my DMs on Twitter open just because Twitter, X is a cesspool. And so I don't invite people to reach out to me there. But Instagram, you can send me a message request. People sometimes do if you have something that you want to share. I do try to keep up on that. Again, time is a little bit limited, so I don't always see everything. But if this is the Microdots video, then I did see that. So thank you for passing that along. Always happy to entertain things like that. Just Me Joe, could the poor lighting on the sneaker showing black, not white, be used as example of the colors of the taillight being poor evidence? Sure. It's not forensic. And it's low light photography. It's cameras that are not necessarily made to be sensitive to those particular conditions. So yeah, I mean, that works for me. If the camera, the photograph can show the sole to be black when it in fact is white, it really speaks to the power of photography and the potential that it has to misrepresent, give a wrong impression about what the true circumstances are. People think photographs are just as good as reality, and this is a great example of no, they're not. No, they're not. They can actually be quite distorted and quite misleading. And so if all you're relying on is low quality video of a taillight, might not be showing you what you might think. It's a good idea. I like this idea. Josh H. Higgins changed his hoodie at CPD. I'm not sure yet, guys. I'm not sure. The front looks very similar to me. The back, not real sure. Not real sure. The shape looks similar, but the amount of detail, very different. So I don't know about that, guys. John Beattybot. Any prob HB not disclosing his 2 FBI liars on direct? Any problem with HB not disclosing his 2 FBI liars on direct? Who are the FBI liars? Who are the FBI liars? I'm not sure I know of FBI liars. I don't know about this. The general rule, he can't knowingly elicit false testimony. That's NAPOE. He can't deliberately present fake evidence. So if he knows something's false, he has a duty to correct it. I'm not sure about FBI liars. Sorry, John. I can't answer this one better. Michigan Farm Boy. Higgins' alibi would be more believable if he was supposed to be taking care of Chloe. Maybe. I don't know. We didn't see Chloe in any of the videos, so what's he doing there at the police department? Got a lot of activity with those cars to explain. Doesn't make a lot of sense. Jennifer King with a super chat. Thanks so much for that, Jennifer. Appreciate your support. Amelia Walsh, go back to the comparison video from last trial for the hoodie. It's clearer. So we did see one compilation of that. It looks like there might be another one. Let me pull this up. See if we have more images. Looks like we do. Just getting everything pulled up here so we can see it all. So somebody else now has gone and found multiple different images. Let's see what we've got here. So the first one here, this looks like at the waterfall. And, it's got that kind of face looking thing on the front. Looks like there's some kind of writing on the arm as well. Does that look like there's writing on the arm? It looks like he's got his arm kind of up like this. I don't know. It is very difficult to see in these videos. So that's there from the waterfall. Now in the hallway, guys, it's very similar. It's a very similar looking face. I can make this a little bit bigger. And it looks pretty similar to what we just saw there at the waterfall. It looks like a very similar face, guys. So not sure about that. Now here's an image of the back of the hoodie at the waterfall. I can zoom in on that. Looks like writing at the top, this kind of shield looking thing. A little bit of writing at the bottom. Hard to tell exactly what it is, but at least we do have that general shape. And then when we see it over there at the Canton PD, it looks like the same general shape to me, guys. I mean, I see people can have differences of opinion, but to me, this looks pretty similar. This right here, writing shield type of shape, writing underneath, that looks real similar to what we're seeing over here in the hallway. So it, to me, looks like maybe just differences in the level of detail that's captured on the different cameras. What do y'all think? I think it's the same hoodie, guys. I think it's the same hoodie. Can't say 100%, but it looks like that to me. Lake Dude, sweatshirt same, waterfall is reflecting, can make out Harley shield with the 3-point crest on top, 2 words above separated, and the writing below. Yeah, that's my read on it too. It just looks like a different quality of video, different image quality at the waterfall versus down there at the hallway, but the general shape is the same. Birdie Bensky, Harley Davidson's logo on BH's jacket in both videos. That does seem to be what it looks like to me. Similar shape. Marianne with a super chat. Thanks so much for that. Lake Dude, waterfall camera, a good example relative to the Koberger case and argument the car in footage isn't white. What color is Higgins' sweatshirt? Yeah, lots of issues with that surveillance video that law enforcement is relying on in the Koberger case, both to claim that they are looking at the same car in all of these different pieces of footage that they've picked up. They claim that they were able to trace the car, but the quality of the images in some of them is quite poor, and it doesn't always look the same. There's an issue with the shape of the vehicle having a shark fin on the back versus not having a shark fin on the back. Some of them it looks clear, some of them it doesn't. Also an issue with the shape of the window, like the rear passenger window. Some of them it like kind of comes up in a V. Some of them it looks more flat. Very hard to make definitive conclusions from low quality, especially nighttime video. Nighttime video, just by definition, tends to be low quality. What color is the sweatshirt? Can't really tell on the waterfall, can you? Mel Will, the defense should know who BH was talking to on the cell call from CPD. Don't they have his call records? If not, how did they know about all the butt dials? They should have his call records. Yeah, the FBI got the call records. FBI got the call records from later that morning to catch those butt dials between Brian Albert and Brian Higgins. So did the FBI only get Brian Albert's phone records? I suppose that's possible, but it does seem unlikely, doesn't it? If they had Brian Higgins' phone records, then they should know what number was being called if a call was being made. It's a very good point. Don't know how that got overlooked at the last trial, if that's the case, but those things happen. A lot of details and a lot of that information. You're not always going to catch every little bit of it. Ian Kelly, guess common sense doesn't apply for grass stains when being drugged. YB must think the jurors don't have brains. Yeah, I don't know why, if you're like dragging a guy by, say, one arm, if you're dragging him by his left arm or by his right arm, wouldn't that tend to only drag his left buttock? Or, vice versa. If you're dragging him by his left arm, wouldn't that only drag on his right buttock? Nothing about dragging says you have to be dragging him by both arms squarely on his back. I think Yuri might have damaged the jury's willingness to credit his common sense. If they don't see it the same way, then not sure we can trust your analysis and your conclusions. Z, journalist Turtle Boy charged with intimidating Yuri Bukhenik, but Proctor has First Amendment. Right? You caught that? Turtle Boy on X said, Nicholas Gianturco, corrupt FBI who accepted bribe from Bulger. Interesting. So that's why Bukhenik had that big chuckle when Hank Brennan actually accidentally gave the wrong name. This was the name that he mispronounced. He was referring to Nicholas Guarino, but he said this name instead. I was wondering, why is that so funny to Trooper Bukhenik? If it's just a malapropism, forgot it, wrong, read it incorrectly, why would that be so amusing? Well, if he knows what it's referring to, perhaps that would be entertaining. If he knows that, hey, now we both get that we're both reading Turtle Boy's Twitter, maybe that would explain why that was so entertaining. Accepted a bribe from Bulger. Interesting. Steve F. won a whole lot of glove. Ah, yeah. He's going to send you back to school. Robin Hall, Bumper Sprinkles is my drag name. That's a good one. That would be a good drag name, wouldn't it? A lot of bling. Bumper Sprinkles would surely be wearing. Z, before a hearing, Turtle Boy and Esquire's jury books on window seal, no email. I don't always understand the emojis, guys. Not sure what this is getting at. The jury's notes, perhaps. We, take it on faith. If the court officers are not reading it, nobody else has access to it. Thank you for your super chat. M4A now, truth revealed. Higgins video is must see seriously. I don't know if this is a new Higgins video, if we're just talking about Higgins being in the parking lot, the stuff that we just saw today, this new evidence that they didn't disclose previously, and they should have. Once Higgins testified about his alibi and the time frame and so forth and what he was doing, this is impeachment evidence. Impeachment evidence is covered by Brady Giglio. Obligation to turn it over. They did not. They didn't do it in the last trial. Of course, no harm, no foul, according to Judge Cannoni, because the remedy is a new trial, and here you are getting one. So now we get to look at it. And if we don't call Brian Higgins and impeach him with that video in this trial, then it's not really a full remedy, is it? Because he should have been able to be cross-examined about that the first time around. Sherry D, goods report AM of Berm shows no sneaker. Picture later replaced with CERT PM picture with sneaker. Does this prove planted evidence? So there was that photograph from the first trial. I don't think it's been admitted here in this one yet, but they cleared off the section of the curb so that they, I don't know, could photograph it. They sort of scraped it clear. And the explanation was to just sort of show that it was there and where it was and what it looked like and stuff. I don't know if this is direct contradiction, because I don't know if the area of the berm that they cleared in the good photo that we saw in the first trial is the same area where the sneaker was later found. It looks pretty small. It looks like it's maybe, maybe that big of a distance. So I don't know. I'm not sure that it definitively establishes one way or another. I'm not sure that it raises a stronger inference than just the fact that the shoe should have been visible by the curb anyway. There's hardly any snow there. There's nowhere near enough to hide it. The plow, by the testimony, hasn't covered this part of the street yet. It hasn't been by over here. This snow is relatively disturbed all the way up to the time that CERT is searching out there, according to them. So the shoe should have been visible, whether you can see it in a photograph or not. Trish C, Garrett Wing training my sister's dog right now. Your sister's dog, I expect, is going to be very well trained. People who can train police canines, from my perspective, very, very high on the skill level when it comes to training dogs. Now, not always my preferred methods. Sometimes, didn't we hear, was it in this case during the last trial? I don't remember or not, if it was or not, where we heard about some of this training. There's like German training techniques, aren't necessarily the kinds of techniques that I would be inclined to use with dogs. I tend to use positive reinforcement, very much not a positive reinforcement type of technique. Interested to hear about Garrett Wing's training techniques. But by and large, canines do tend to have highly specialized skills. So, Michigan Farm Boy, Higgins and Chloe was more of an ATF joke, but I wouldn't put much past these folks. I might be slow today. I might not be picking up on this joke. ATF and the dog, I don't know. Sorry guys, might be slow. It is Monday. I did get that extra sleep, but I can be a little oblivious to some references and stuff like that. John O'Neill, nobody using Blue Hill weather station data nearby. The weather guy did use the Blue Hill weather station, but I think he pointed out that's the one that has the actual physical observers there. It's like I forget how far away it was. It was relatively close, but it was the old observatory that was, first established in the 1800s or something like that. It's manned. Some of their processes aren't automated. So I think we did hear about that. But he used multiple sources. He didn't rely on any one of those exclusively. CG, what are your thoughts on the 36 steps evidence from O'Keefe phone? They have to explain the timeline. How does that fit? 12:32 seems to me to be a problem if Karen's car and Karen's phone is back at One Meadows Ave at 12:36. It's only 4 minutes later. Heard testimony at the first trial, and lots of people have gone in, checked it on Google Maps, Google Earth, and stuff like that. Google Maps, seen people go and do the test drive and stuff. I don't think you're making that drive in 4 minutes. So if his phone is taking steps after she left, that's a problem. That's a problem for their theory. I think they're trying to translate it into, well, it wasn't really steps, it was just movement. So the phone flew through the air. Are they going to try to say this was the point of impact? No, because I think they put the point of impact before that, didn't they? 12:31 something. It doesn't fit their timeline. It's a piece of evidence that is very discordant with the rest of the theory of how all of this happened. So the Commonwealth has the duty to explain it. They have the burden of proof. They have the obligation to tell me, how does this fit in with your version of events? Still waiting for those facts, science, and data in general. So am I surprised they haven't explained this to me yet? No, no. I think there's a reason why we're not hearing about any of this stuff until close to the last minute in the Commonwealth's case. Because despite the opening, the case isn't really about the facts and science and data. The case is about I hit him, I hit him, I hit him. And hoping that that will be persuasive enough that we will overlook problems with the facts and science and data that don't align with their theory of how this vehicular accident supposedly took place. Pretty coincidental distance and stuff, isn't it? We had steps before that though, right? Steps about 12:21. Yeah. To me, the steps are a problem. I'm not buying that it's just the phone moving. I'm not buying that. I mean, if it's based on an accelerometer and a gyroscope and stuff like that, how many times have they relied on this information to establish people did in fact take steps? You know, to me, that's kind of the issue. You rely on it when it's helpful to you in your case, and I'm quite certain that they have. But now when it contradicts your theory, well, it could just be any movement. It could literally be driving on a hilly road. Doesn't add up. Doesn't add up. So that's my thoughts on it. I think it's a problem for the Commonwealth, and they're going to need to figure out how do you reconcile that with your theory. Well, I said at the beginning of day 14, we might get a full day of Trooper Bukhenik. I honestly didn't really expect that we would, and yet here we are. That is, in fact, what we got. Not sure that Brennan was expecting that either. So I don't know what we got lined up next once we come back tomorrow. Whatever clever, having defense call the Commonwealth's witnesses means Brennan can lead them on cross, right? Your opinion, is this a strategy and is it worth the scrutiny? If you're a reasonably decent lawyer, I don't think it's going to give you a huge advantage to be able to cross a friendly witness. You should be able to get what you need on direct. Higgins should already know what his version is, and so for you to put it in his mouth, I don't think this in and of itself is going to be enough to be the strategy, just because there's so many other trade-offs. The fact that it looks bad that you're not calling him, you're the one with the burden of proof. He's supposedly an eyewitness, but we're going to leave it for the defense to come in and explain all this stuff. That should have been known. It should have been known he's there at the Canton Police Department. I don't care if they know that there's video or not. They know that he went there, and they know what time he went there. So how's this not raise any suspicions, particularly then when you hear him testify and it doesn't add up with when he was there and what he was doing? So you not explaining that, I think, looks bad. That's a big trade-off to just get an advantage of, well, I can lead him. If they've got a theory that they want to put in his mouth, a way that they've reconciled it, maybe. I mean, I guess we're just going to have to see how this cross goes. But boy, is it a gamble, because you're counting on the defense not getting elicited in their direct, right? You have a theory. Let's say you have a theory about what he was doing with the car. You want to put it into his mouth. If the defense asks him on direct, so what were you doing with all these other cars? Let's watch this video and let's step by step you explain to me what you're doing at each point in time. You've lost the opportunity. He's going to have to ad-lib it on direct. And you've lost your opportunity to put those words in his mouth. Yeah, okay, you get to word your questions in a certain way, but You're stuck with whatever got elicited on direct. So I don't know, guys. I don't know that I can see this in and of itself being a reason not to call a witness. There's just too many other things at play with that decision, too many risks, too many bad inferences. Might be part of the strategy. If so, I would have to say, my opinion, that's probably a bad strategy. Z, can Garrett Wing bring his Kenny Corso for testimony? I don't know if he can or not. His dog, a demonstrative using the dog. That would be fun, wouldn't it? I think that would be a lot of fun. Have the dog bring his latex arm while we're at it. Bring that arm model, have the dog latch onto the arm, doing a hold takedown type of technique the dog is trained to do. See what that looks like when you're done. A little live demonstrative for the jury. God, I would love that. I don't know if Judge Bev would allow it, but I don't see any reason why it wouldn't be permissible. Why would it not be permissible? If it helps explain his testimony, if he's going to testify, yeah, I've seen these types of injuries a lot, and here's how the dog creates them. Allow me to demonstrate so you can understand it more clearly. I would love that. That would be cool. But I doubt we're going to get that, but that would be pretty awesome if we did. Yeah. Huge ass dog. Those are very big dogs. The Cane Corsos. Very big, very strong, very powerful dog. Maybe Hank would argue that's misleading because it's not a Malinois. Malinois mix could mislead the jury if it's not the equivalent dog, perhaps. I don't know. Isn't he trying to tell us it's not Chloe? So maybe it was a random Cane Corso that just happened to be out in the neighborhood that night, got a hold of his arm. It's a weird thing about Hank's position anyway, right? It's not a dog, but if it is a dog, it's definitely not Chloe. Like, commit to a position, commit to a story. I think the canine forensic odontology did get excluded anyway, so she might have done him a little favor, actually, not letting Hank get into that, because boy, is that ridiculous. Michigan farm boy, ATF have a reputation for ending all the dogs they encounter. Okay, I get it now. Sorry, I am very slow on the uptick with that one. Yeah, ATF serving their warrant, dog at the house. What happens to the dog? Okay, I get it, guys. I get it now. I'm sorry it took me so long to get that one close enough under my nose that I get it. I get it now. Yeah. Higgins, the ATF agent, needed to attend to Chloe before the encounter could be ended. Thank you. Appreciate you spelling that out for me. Heather S. Commonwealth could claim John O'Keefe got up and staggered around before final fall, blood on clothes, steps. Important defendant ME says he couldn't move after head injury in AJ opening. Yes, they have to neutralize that. If I recall, that was also suggested in the first trial. Lally, they didn't present proof of it, but I think Lally had asked questions. Well, could he have moved? Could he have moved? Could he have taken a few steps? You had no evidence that he didn't take a few steps afterwards, something like that. So yes, if the defense is going to try to take that off the table based on the medical evidence, it was certainly good for them to highlight that in opening. They'll need to follow up on it. Certainly wonder if the Commonwealth's neurosurgeon is gonna substantiate that. What's he gonna say about the effect of an injury like this? He would know, wouldn't he? Is he gonna agree with that? I'll be curious to find that out as well. Maybe he'll say, sure, he could have gotten up and taken some steps and checked his text messages and locked his phone, laid back down and died in the snow. Maybe that's what the expert will say. Who knows? Should be getting to him soon. Got to be getting pretty close to that. Here's the question I have. Who drives a Ford Edge? I'm being very honest with you guys. I had never heard of a Ford Edge before this case. I didn't even know a Ford Edge existed as a vehicle. I didn't know. I never heard of it. Don't know anybody that drives it. And yet we have a family that drives lots of them. I get that. I mean, sometimes you find a right car. Everybody likes that car. In my family, I don't know if I should admit this out loud, but I will. It's the Honda Element. Oh, they love the Honda Elements. And I got to tell you, I got to say, it is a very cool car. Don't make it anymore. So that's like the old ones are now, kind of in demand. If you're really into the Honda Element, hard to find one. The issue with the Honda Element, my mom had one, my uncle had one. The reason why my mom got rid of hers is because it seems to be like the structure of the car. So you have the windshield is like a little bit more upright because it's a boxy, like Lego looking car. A little funny looking. I get it. But it really was a good car for a lot of ways. The windshield, it's almost like it's a little more vertical than it is on most cars where it's like this. And so it was constantly getting broken by rocks, like rocks on the highway. Rock gets thrown up. I think on a more, tilted window, it'll just bounce off. It won't do anything. But because this window was more upright, it would smash it. So she had to replace the windshield a whole bunch of times. Finally got sick of that. Got rid of the Element. Yeah, it can be like that. It can be like that. I am not necessarily a car enthusiast. I mean, I feel like I know something about cars. Like, I kind of knew like the muscle car shape, the old classic muscle car from like the old Plymouth and the old Mustang and stuff like that. That kind of looked like maybe that video was. But I'm definitely not an enthusiast about a Ford Edge. Like, what is there about a Ford Edge that anybody would know anything about it? I don't know. You guys can tell me. I'm definitely not one that keeps up on like what's Ford putting out this year. I just know what I like. I do like a nice classic muscle car, but for me, it's all about the Jaguar XKE. If I could pick any car to have in my driveway, wave my magic wand and it's there. It's like that 1970s era Jaguar XKE, like the one in Harold and Maude that he turns into a hearse. God, I love that car. It's a beautiful car. Nice, long, straight 12-cylinder engine. Beautiful, beautiful car. That's what I know about cars, pretty much. I know what I like. I don't know. Is that wrong? Well, guys, I think that's our wrap on day 14. Finally done with Trooper Bukhenik. That was a real marathon. I don't think he was expecting that. I'm not sure Brennan was expecting that. But the defense had that planned. If we're not going to get Proctor, then by golly, we are going to subject Sergeant Bukhenik to the accountability for the investigation that we would have otherwise put on Proctor. So it's a great backup plan. It's a great backup plan. And I think it might have caught him off guard. He was much better behaved today with his attitude, wasn't he? After getting worn down on Friday, seemed a little tired by the end of the day. A little tired, got a little bit more agreeable. Wasn't so willing to fight any and every question, semantics, authenticity, etc. And so then he came back today, seemed to have a little different attitude. Might have figured out, hey, that wasn't working so well. That's right. William Falo Art, Phillies versus Cardinals tonight. Got some good Phillies baseball to check out still. This is why I don't catch every Microdots video, for example. All this free time, got stuff to catch up on. It is a boxing night for me too, if I make it over to the gym. So lots of things going on. Just how things go. Oh, hey, somebody else loved an Element. It was like wearing an extra large sweatshirt. Broken windshield, boxy design was not aerodynamic, so gas mileage wasn't as good as Honda usually is. Yeah. All-wheel drive vehicle doesn't help either. It doesn't help with the gas mileage. But I really liked the Element. It was very, very convenient, very good in lots of ways. So glad to know I'm not the only one. I don't necessarily have to hang my head in shame. We did. We loved the element. Multiple people in the family had to pick that car up. Ford Edge is a cop car. See, I don't know. I don't know. What is about it? What is it about it that makes it a cop car? What do they like about it? I have no idea. I know like nothing about a Ford Edge. Maybe we'll find out. Well, guys, we're going to call it a wrap. Only 9 hours today. Not too bad. I got that extra hour of sleep this morning. So that saved us a little bit of time, but we are back on the early schedule tomorrow. So yeah, early bedtime for me tonight, early rise. Gotta get my sleep. Might not be so fresh tomorrow. We'll see. Kind of getting into the schedule of things. So we got to be getting close to the end of the Commonwealth's case, don't we? Surely we're going to start getting some of this technical evidence at some point. Surely we're going to hear from the medical examiner, from the neurosurgeon. Surely we're going to hear from the accident reconstructionist. Are we getting close to that? Don't know how much left they have to go through. Only way to know, I guess, is show up tomorrow and find out. So, guys, thanks so much for joining us again today. It's a big crowd, having lots of fun. All those glove songs. I'm gonna have to like go back and read through the chat again, see how many of those you came up with. The part-time Glover, that was a good one too. You guys crack me up. Fun time here in this chat. Always enjoy it. Appreciate all of you contributing. Appreciate all of your questions, your attention to details, your good theories about what the evidence could mean that we're watching. These are all things the jury might be thinking. We don't know. They're just taking this evidence in and trying to interpret it. Thanks as always, of course, to the mods. Could not do this without you. Keep things flowing smoothly, in order, sharing the links and everything as folks need them. So really appreciate them and everything that they do here. Guys, pretty soon, the Commonwealth surely is going to prove John O'Keefe was hit by a car. Surely we're going to get to that fundamental fact that's necessary for them to prove that Karen Read is guilty of anything at all. Weird that it's taken so long. One might think if one hadn't watched trial 1, where it took approximately 24 days to get to that evidence the first time. Boy, if we get to it on day 15, it's almost like a race in trial number 2. Almost like they got there at warp speed. No, we're getting towards the end of things, so it's got to be coming soon. So maybe tomorrow is the day. We'll just have to see. Guys, look forward to seeing you all tomorrow. Seeing your jokes, your good humor, your fun in the chat, your questions, all of it. Having a great time. Really appreciate all of you joining us. So bright and early tomorrow, 5:45 Pacific, 8:45 Eastern. Do the math in my head. 8:45 Eastern. We'll be back, ready to see what the day brings. Thanks again, everybody. We will see you then.